Good afternoon, everyone. Good afternoon, everyone. Welcome to House Economic Matters. Today is March 4th. We have 11 bills and 100 witnesses. There is a timer for everyone but the bill sponsor. And if your point has been made by a previous panel or speaker, a simple me too is suffice. Just keep this in mind. All of the members do have access to the submitted written testimony. Additionally, I just want to make note, obviously there will be, topics that will elicit emotions one way or the other. It's non-judgmental either way. It's just we need everybody to make sure that there's no outbursts from any individuals in the audience. And you can take this as your warning, and then if that continues, we will have you removed. Okay, first up, Delegate Bhandari, House Bill 1363. Delegate, if you have a panel, you can bring them up. Good.
Good afternoon, committee, Mr. Chair, members of the Economic Matters. Last year, Maryland took a significant step towards inclusivity by passing a legislation that required movie theaters to provide accessible captioning option for their patrons. And this bill is very simple. This bill does some changes in governing movie captioning to include motion picture houses with at least 4 screens. And Mid-Atlantic NATO, Doug Murdoch, Executive Director, met with me, and we made the compromise, and there is no any opposition to this bill. And here is Jacob Leffler.
Hi, and thank you, Chair Wilson.
Hold on 1 second, ma'am. Hold on 1 second. I'm going to have, can you bring a microphone closer to?
Sorry.
Yeah. Apologies.
Move it over this way. Okay.
I'm really sorry. We just got to make sure for the record we have
Of course, no worries.
Okay.
It's on, though.
It is on.
We're on? Oh, goodness. That's even better.
Oh, there you go.
We are all set. Certainly. Thank you, Chair Wilson, Vice Chair Crosby, and committee for the opportunity to explain why this bill is critically important for passage in the House. First, I want to thank you for your support last year in passing this bill, providing movie accessibility statewide. I'm happy to see you here again. We'd like to make sure that more movie theaters are more accessible across the state of Maryland. Currently, the law mandates that movie theaters or movie houses with 8 or more screens provide open caption movies twice a week for the first 3 weeks of a film's release. However, this applies to only 39 theaters statewide, leaving 15 theaters exempt from providing open caption movies. Our goal is to ensure that all movie houses are accessible so people don't have to drive up to an hour or 50 miles just to see a movie with open captions. Under the current law, the following counties have only theaters with 7 or fewer screens, and in most cases are not required to provide open caption movies in these counties: Allegheny, Baltimore City, Calvert, Dorchester, Kent, Talbot, and Worcester counties. This bill, which reduces the threshold to theaters with 4 or more screens, will help resolve this issue by ensuring that movie theaters statewide, particularly in Eastern Shore, Southern Maryland, and Western Maryland, are able to provide more open caption movies. For example, right now, only 1 movie theater is currently required to show open captions in the Eastern Shore area. With this bill, there will be up to 5 additional theaters, which is a 500% increase of accessibility for the Eastern Shore alone. I'm hopeful that Maryland will lead the nation in ensuring equal access to movies for everyone. Passing this bill would make our state a shining example of inclusivity and accessibility. Thank you again for your support over the years. Let's continue to work together to make Maryland a more welcoming and accessible state for all residents. Thank you. Sorry, just getting the interpreters prepped. Thank you, Chair Wilson, Vice Chair Crosby, and committee for letting me testify today. My name is Meredith DeSoma, and I proudly serve as president of the Parent, Teacher, and Community Association at the Maryland School for the Deaf, or MSD, at the Columbia campus. When the Parent, Teacher, and Community Association learned that the bill had been passed last year and signed by the governor, our first thought was how much enjoyment the students would experience, being able to watch movies like everyone else. Unfortunately, that joy does not extend to all students. I am here to express how important the alteration to HB 1363 is for our community and our students. Making sure that the signing interpreter is on camera again, thank you. A Maryland School for the Deaf serves students from various counties across Maryland. Consequently, the students at the Columbia campus come from areas such as Harford County, Cecil County, Kent County, Queen Anne County, St. Mary's County, and Baltimore City. Unfortunately, these counties don't have movie theaters with more than 8 screens. This limitation restricts the students' access to theaters that often open captioning, making it difficult for them to enjoy the films. On several occasions, the families of those students had to drive for about an hour just to find a movie theater that provides open captioning. This situation puts them at a disadvantage compared to other students who do have access to theaters that offer the service, and it also hinders their ability to spend quality family time together. The PTCA, Parent Teacher Community Association, strongly, and I firmly believe that this bill will benefit not only our students, but also our staff, our families, and the wider community outside of the Maryland School for the Deaf. Open captioning is crucial for supporting children and adults in their language development and literacy skills. It also provides assistance to senior citizens, veterans, deaf and hard of hearing people, as well as deaf-blind people, and individuals with auditory processing disorders, and those with other medical conditions. We strongly urge you to support HB 1363. Thank you so much for your time and your attention.
Next.
Good afternoon, Chair and distinguished members of the committee. My name is Ursula DeBerry, and I am honored to be here to provide testimony in support of the bill before you. As a representative of an office that supports deaf and hard of hearing community, I believe this bill is a significant step in ensuring equitable access to all media for all Maryland residents, especially those in the deaf community and hard of hearing communities. The proposed changes are an important adjustment that will expand access. By reducing the number of screens needed to trigger the mandatory movie captioning, smaller theaters can meet the threshold, making more theaters accessible. It will also create a more manageable requirement for larger theaters. I want to conclude to say that I urge the committee to support the bill for the benefit of all Marylanders, ensuring that movie theaters are accessible to the deaf and hard-of-hearing communities. The ability to enjoy films and other media is an experience that should be a basic right for all. This bill ensures that everyone can enjoy these experiences equally. And I want to share a little something personal, if I may. I have a family member in the Eastern Shore, and I know that they, my family, I'm the only deaf person in my family, and they all know sign language, but we can't sign, I mean, they can't sign or interpret for me in the dark in a movie theater, and I certainly can't lip read in a movie theater in the dark. There are many deaf people in that area who go to that area to retire, people with hearing losses that also could benefit from this service, of having theater houses that require captioning. So again, thank you for your time.
Thank you. Seeing no questions, that concludes this panel. We do have one virtual, but I don't believe he's in the waiting room, correct? Okay, that virtual witness was Robert Perkey. Jacob, as always, I think this is like year 9 you've been up here. So it's good to see you, and I appreciate you appreciate you continually trying to advocate. And it's good to see you. Okay, that concludes this bill hearing. Next, we will go to House Bill 1345, Delegate Jacobs. Is Delegate Jacobs here? All right, we can come back to Delegate Jacobs. Next, we'll go to one of our own, House Bill 1365, Delegate Harrison.
Thank you, Mr. Chair. I have a couple of panelists. One is an expert witness that is online, and I think my panelists might be in the hallway. But I will go ahead on and get started because I don't want to belabor.
Yep, real quick. Kaylee's coming in right now. Real quick, do we want to, do you guys need to move your equipment back? Do you need a minute to do that? It can stay, to be clear. Okay, all right, go ahead and start, Delegate. Sorry to interrupt.
Thank you. I am Delegate Andrea Harrison. Good afternoon to the chair and to my colleagues and audience members. As I mentioned, I do have a panel here and one panelist who is online, and I'm calling him my expert witness. So I'm here to present HB 1365, Online Data Privacy, Limits on Data Collection. This bill is aimed at limiting the collection of personal data to what is adequate, relevant, and reasonably necessary for the purposes for which the data is processed, as disclosed by consumers by persons or entities that handle consumer or personal data. House Bill 1365, which seeks to bring the data minimization standard in the comprehensive bill passed last session in line with the data minimization framework found in the European General Data Protection Regulation, as well as 18 other states, including California, Oregon, Rhode Island, New Jersey, and Delaware that have also passed comprehensive privacy frameworks which now cover over 100 million consumers in the United States. Certainly, this provision in Maryland has garnered the attention as a national leader when it first passed and has been lauded as premier. However, as businesses have looked at how to implement this, my understanding is that this novel approach to creating significant confusion, and there's concern about how the consumer online and app experience for Marylanders could likely be increasingly negative and could even lead to consumer consent fatigue. Current language in the law, which goes into effect October of this year, requires that businesses collect and process only data that is reasonably necessary to provide the specific product or service requested by the consumer. While on paper, this makes sense and is certainly the goal, it is certainly our goal to protect our residents' personal data. In practice, what I'm hearing is that this language may well require that businesses create new pop-up, click-through boxes on their websites and apps just for Maryland residents to satisfy the requested by the consumer standard. Due to the way the law is structured, these click-through boxes cannot be framed as requests for consent because that is not permitted in this context, but other compliance mechanisms to document that the consumer wants or has requested or is okay with these types of updates or new product requests. Further, adding these additional consent boxes could lead to residents to simply click through, and they may not actually read what they are consenting to because there may be so many consent boxes that will be required under this regulation. I would bet that many of us find them annoying as is when we want to get to the page or app we're trying to use. As a result, we may not actually be providing more privacy, but rather simply providing more consent. And because we, the consumers, are frustrated, we're not looking at what we're consenting to because the letter of the law has been met and not necessarily the spirit of the law. This underscores the discussion last session where a number of comments were made to the effect that privacy policies are effectively useless because businesses can put whatever they want in them, and then so long as they are doing those activities, they are safe from enforcement and can proceed with invasive methods of data collection. This does not necessarily protect consumer privacy. The requested by standard also turns off routine and non-harmful data flows, which prevents businesses from making systematic and routine updates to their products and services for Marylanders. It would not allow businesses to suggest product recommendations for new products and services that the consumer did not specifically request, but that the business believes the consumer would or would like to consider. And again, we do not know exactly how this will look because no other state in the country has moved in this direction. Instead, since Maryland has taken this path, potentially at the expense of the consumer experience, our neighbors in Virginia and Washington, D.C. may have access to better or newer products and services than our residents. Maryland's privacy law already has provisions that says if you do anything different than what is adequate, relevant, and reasonably necessary, but simply putting an activity in your privacy policy that is designed to be vaguely worded and misleading is in fact a violation of the language that HB 1365 proposes. I also want to state that the more we go away from using clear statements and privacy policies as our basic enforcement standard, and the more we move to subjective judgments about what has been requested by the consumer for a specific product or service, the less clear it will be for those enforcers to determine who is violating the law and who is working to comply with it in good faith. At the end of the day, Maryland is not and should not be bound by what other states have done or the prevailing views on a particular public policy issue. HB 1365 would simply advance Maryland's standard to a standard that is more in line with the rest of the world and the rest of the country. In my view, it is important that our residents and constituents do not fall victim to consent fatigue, have the same privacy protections as other states, and the same access to goods and services. Thank you, and I respectfully request a favorable report on HB 1365.
Good afternoon, Mr. Vice Chair and honorable members of the House Economic Matters Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance in strong support of this bill. So more than 100 million Americans are already under the framework that's proposed in this legislation, which strikes a reasonable balance between consumer protection and the operational needs of businesses. This legislation will bring Maryland into alignment with the U.S. standard, ensuring that data collection practices are both relevant to the consumer experience and reasonably necessary for a legitimate business purpose. Currently, the data minimization language in the law goes too far by imposing overly stringent restrictions on businesses that will in turn, as a sponsor referenced, frustrate consumers. It essentially limits the collection of all personal data to a specific product that is requested by the consumer, which in effect acts like an opt-in. This bill clarifies that businesses can collect non-sensitive data on an opt-out basis that is adequate, relevant, and reasonably necessary for the purposes already being disclosed to the consumer. The bill is important to retailers for several reasons. Retailers use consumer data to personalize the shopping experience for our consumers, alert customers of new products, and serve them with coupons or even sale notices. And secondly, retailers try to grow our customer base with prospective customers by alerting them of the same information, since customers typically do not request this information or they don't even know what to request. So the goal of the legislation is to protect consumers from harm, but is also crucial to ensure that businesses can create the best consumer experiences possible that most consumers actually prefer. With the proposed changes, we are focusing on the right balance, protecting consumer privacy while enabling companies to innovate and meet consumer needs. We urge a favorable report. Thank you.
Thank you, Mr. Vice Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce in support of the bill. We thank the sponsor for bringing it forward. Most of my talking points have been covered, so I would just quickly echo the fact that this aligns us with other states like Virginia and Delaware. It clarifies the threshold with which businesses will need to comply. And when we're talking about the penalties in this statute that include both criminal and high civil penalties, we think it's beneficial for compliance purposes to streamline that across different states. Thank you, Mr. Chair.
Typically, we would just let the panel go, and then we would go to virtual, but is it Paul Martino? Is that your expert? Okay, we'll let him testify, and then we can go to questions, because I saw him in here.
Can you hear me?
I can, sir. I just need you to turn on your camera.
Yeah, I'm trying. Let's see.
There you go. You're good.
Oh, you can see me now? Great. Thank you. Apologies. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. I'm Paul Martino, a partner at Hunt & Andrews Kurth, and I'm appearing on behalf of the Maryland Retailers Alliance. I want to just start by aligning myself with the testimony offered by Kelly Locklear, MRA's president, about the importance of HB 1365 in correcting the data minimization language of the existing Maryland privacy law. As codified now, the limitations on data collection will restrict data in ways that frustrate, not serve, Maryland shoppers. As Kelly noted, the current statutory language restricts all collection of non-sensitive customer data to what is necessary to, quote, provide or maintain a specific product or service requested by the consumer to whom the data pertains. This novel approach that's not used in other states to collection would restrict the collection and therefore the use of data to inform consumers about other related or relevant products unless they request them, something most shoppers don't do because they're not aware of other relevant products unless the retailer informs them. For example, you're all familiar with online shopping sites that display similar or related products or accessories when you searched on one and see another. Consumers appreciate seeing this as they might find a better product they didn't know about. Customers satisfied, the business provides a service they appreciate, and it's a win-win for the consumer and business. But if the Maryland law takes effect as enacted, it's unclear whether a retailer could use the data collected about the product specifically searched to provide this related information, because one could argue it is not necessary to provide the specific product requested by the consumer. HB 1365 corrects this limitation in the current Maryland privacy law that would frustrate the customer experience and limit the beneficial related information businesses could share with their customers. Third, and lastly, like other consumer-facing businesses on Main Street, retailers grow by attracting new customers. Retailers open new store locations, have traditionally obtained lists of local households to send mailers announcing the new store openings in the area. The law must preserve the same ability to collect the data in the online environment for the purpose of marketing to prospective customers. The law should not limit collection of data to what is necessary to provide a specific requested product because prospective customers have not requested anything, and the law would prevent the stores from using data to inform consumers of a store opening or a sale. This will only frustrate Marylanders further. In conclusion, HB 1365 takes a surgical approach to correct the current law to enable Maryland retailers to continue to serve Marylanders the the way they expect to be served.
Thank you, sir. Delegate Rose.
Thank you, Mr. Chair, and thank you very much, Delegate, for the bill. I've really, so if we don't change this under this bill as of October 1st, I love the streamlined process of when I look for something, want to order something, want to shop for something. I greatly appreciate getting the suggestions and, you know, as you mentioned, the sales, the coupons. So if we don't pass this bill, we're going to lose a lot of that data that we get sent to our phones, our computers, our emails. Is that correct?
Yes.
Yeah, effectually, it would create a sort of opt-in process. Like, we don't really even know how it would work. Like, we will willy-nilly be sending you targeted advertisements about anything under the sun. It was interesting on the Senate side, Chair Bidle's example was, I don't want to randomly be sent wrestling attire advertisements, right? Like, you want to see things that you've clicked on and that you're interested in.
I appreciate. I don't want wrestling shoes.
Exactly, exactly.
So, okay, thank you. Thank you very much for the bill.
Thank you, Mr. Chairman. So, question for the sponsor, because I know this will be an interesting bill for us to debate if we debate it, since you serve on the subcommittee that would overlook this. I do want to just make sure I'm understanding the opposition. So the Office of Attorney General's approach was that kind of like we're you know, starting too soon. This hasn't even gone into enactment yet, so we don't really know that we would have such a concern. So that's one, and so I guess one question would be, I'm gonna ask another question, but one question would be, how do we know this frustrates consumers, because we haven't enacted yet? Are we enacting it like a certain state where we know this has been a problem or something? So that would be one question. The second question, though, I thought was more enlightening, was the one from EPIC, the Electronic Privacy Information Center. They alluded to the fact that because when we enacted our law, which was after some others had enacted theirs, that the Maryland law is now becoming the standard, and that there are other states that tend to like what we're doing. And they said that Connecticut is looking at it, and maybe Massachusetts, Vermont, Washington, and New Mexico are looking at laws that are more in line with us. So maybe some thoughts on that one. But my third question, though, is
You know I'm not going to remember all these questions.
but Kaylee's writing them down.
I'm trying.
She got me. The third question is, we changed the wording to say adequate and relevant. How is that defined in other places? Because I don't know what that means. Okay, are we good?
Okay, so we're going to tag team your questions, if that's okay. So yes, I did have a conversation with the Attorney General's office, and their concern, obviously, is that because it has not yet been enacted, but what I have found in my discussions from the business communities, that, and they're trying to figure out how to implement this, some of the problems that they saw was just that whole issue about having to include all of these new consent boxes, basically. Do you consent to, you know, allowing us to, I don't know, send you ads for wrestling shoes, or whatever the case may be? So every time you're trying to search, get to what it is that you want, look for what you want, then a number of these consent, I said consent pop-up boxes come through. And so after a while, you just continue to hit consent, because you're tired, you don't feel like you want to get to what you want to get to. And it could be anything in those boxes, and human nature just says, yeah, I'm not going to read all of that. And so, in my opinion, what we're doing is we're opening up our residents to anything, quite honestly, because we don't know what may be in there, because it's just the nature of the human nature. I don't think that there are any other states that are doing this at the moment. they may be looking at it, because this was a huge step. It was a big, a big novel idea, but no one else is doing this. And in my opinion, when you recognize an issue or what could potentially be an issue, you work to resolve that before it becomes an issue. And I don't remember the third question.
Third would be, and I think the third is really the crux of it. Because as what you're saying, we're somehow going to define adequate and relevant so that we don't get all those pop, because I could see that it could become, tiresome, and, I've gone through things where I can't get to the end. But where is that defined in other places, since you're saying other places use it? So how do they define relevant and adequate?
So let me start with, we must disclose to consumers. We have to do that. And with regard to adequate, relevant, and limited to what is necessary. Adequate means it's sufficient to properly fulfill the stated purpose that's in our disclosure. Secondly, relevant has a rational link to that purpose. And then limited to what is necessary is that we do not hold more than what we need for that purpose. And that is a European standard. That is the United States standard that is found in every other state. And so we went beyond this, where we created this request system that doesn't exist anywhere else.
So are we planning to put those standards in this, amend this to do that?
Exactly. That's exactly what we're doing.
So this is going to be a favorable with amendment bill when we see it eventually?
No, it's actually, that's the way the bill is drafted.
I don't see the definitions. Are the definitions someplace else that I'm not knowing where they would go?
I think we'd be.
And maybe that's something we can take offline, because all I just see is these languages in bold, those words in bold with nothing that says relevant is defined as, or the meaning of that, which I'm accustomed to seeing other places.
Yes, and you're right. It is not specifically defined, and we can define it because it's just listed in the bill as that. So we can certainly do that.
Thank you very much.
All right, and that would just be aligned with the what's already known.
Thank you, Mr. Chair. Kaylee, you said my trigger word, which is opt-in, as you know so well. Explain to me how this is an opt-in approach for consumers.
Sure. So the legislation that we passed last year centered around harms in the marketplace. And we define sensitive data so that you actually have to opt in, right? So that is what you all passed last year. With regard to all non-sensitive data, we have to, as consumers, opt out. That was also a part of the bill last year. But then what we're trying to rectify here is that in this data minimization portion, we went even further so that it includes all personal data, and that you can only go ahead and give consumers suggested information at their request, but they may not know what they're interested in. So you go and you buy a pair of mittens. We'd love to push you the matching hat. Like, that's what we're talking about here.
Okay.
Otherwise, you'd have to somehow opt in, but we don't necessarily know that you're interested in that. And then we get in the situation of debating whether or not it's actually requested by the consumer.
Yeah, I get what you're saying there. Respond to this by the Attorney General. I'm just going to give you a quote. The bill would negate the protections that we passed actually last year in the Maryland Online Data Privacy Act. How do you and how do you respond to that?
May I defer to Paul, because Paul works on this nationally.
Yeah.
Paul, can you hear us?
Yes, I can.
Go ahead,
Could you
sir.
repeat the question, please?
Yeah, the question was around the Attorney General's letter, paragraph 3. The quote is, "The bill would negate the protections that we passed last year in the Maryland Online Data Privacy Act." So can you respond to that? How clearly the AG believes that this is actually taking away some of the stuff that we've been trying to do for the last couple of years. Just explain to me your positioning there.
I haven't seen all of the AG's reasoning, so I apologize. I don't have that letter in front of me. I can just give my own opinion here. The act, the legislature spent a long time with this act, looking at how to balance the needs of consumers for consumer protection and the needs of businesses to be able to continue to serve them in the way they should be served. As Kelly just explained, the bill goes to extensive lengths to describe the kinds of data that cannot be collected or where an opt-in is required, and then the kinds of data where it can be used with the consumer's permission, but they can opt out of it. But what this data minimization language did was sort of trump all that. It kind of, sort of overrides everything else in the bill to say, at the forefront, you cannot even collect data unless it's reasonably necessary to provide or maintain a specific product or service requested by the consumer. And so I would say it doesn't negate, this improvement doesn't negate the purposes of the bill. It actually completes it. It actually furthers the purposes of what the legislature decided to do in drafting this and enacting it, because it's going to make it work. Right now, all the rest of the bill doesn't really work with the standards that have been set up. If you have this one provision in here that's not drafted well, that's novel compared to the rest of the country, that's not up to the standard of the rest of the world, and by fixing it appropriately, surgically, as Delegate Harrison has put in this bill, it will actually enable this bill to work better for Marylanders. It will protect their privacy, and it will also permit businesses to continue to serve them in the way they're being served. So without seeing the actual language of what the AG argued, I can't refute any specific points that's being made in that letter, but I would just offer that I have a different opinion that's based on about more than 2 decades of working on data privacy legislation in states, at the federal level, and in Europe.
Well, Paul, I would love to talk to you offline just so I can get more of a grasp around this as well. The last question I have, Kaylee or Grayson or Delegate, out of all the states that have passed data privacy laws, did I hear that you said none of them have this exact language?
Correct.
So we would be the first state to do this, or all of them do have this language?
No other state has the language that was in
That we had
Maryland's law.
in the
Yes.
Privacy Act.
Yes,
That's what you're
yes.
saying.
There are, I
Thank you for that
think, 18
clarification.
other states that have what is in Delegate Harrison's bill.
Got it.
Including Virginia, Delaware, I believe New Jersey's another one.
Yes.
Got it. Makes sense. Thank you.
No, I'm sorry, second bite. One thing, I hate to use the word triggered twice, but one thing that triggered me is it sounds like this will actually make consumers feel a lot more comfortable entering information or clicking on information because you have those protections in place that are spelled out in the bill. So I know for myself, I work as an IT recruiter in my normal life, and you're afraid to click on things, and this would limit your opportunity to keep, nobody goes to the mall anymore. I don't want to hurt any malls, but, we all shop online. And so I feel like I would feel much more protected doing it this way so that I get items sent to me that I specifically want or related to what I want without having to feel like I'm still entering information. Am I correct in that?
You are correct. Yes.
Thank you very much.
All right, we will now go to the virtual witnesses. First, Margaret Durkin. Margaret, yeah, all right, go ahead and start.
Good afternoon, Vice Chair Crosby and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today in favor of House Bill 1365. Last session and in prior years, TechNet worked with the Maryland General Assembly to craft a thoughtful approach to data privacy here in the state. And our advocacy today doesn't intend to focus on the overall privacy framework, but rather a critical change that will provide a more workable opportunity for commerce for both businesses and consumers alike in Maryland. As such, House Bill 1365 addresses and improves upon the current bill by providing for adequate, relevant, and reasonably necessary standards that you've heard about from the other panelists. Some unintended consequences of strictly necessary standard that currently exist in the data privacy statute would be including businesses potentially limiting personalization services and accessibility features. Changes in this bill will only improve upon the framework here in Maryland, and we thank the sponsor for their work on this issue.
Thank you. Megan Stokes. Go ahead, Megan.
The opportunity to speak to Dan Stokes. I serve as the State Policy Director for the Computer and Communications Industry Association, an international not-for-profit tech trade association. HB 1365 would align Maryland's data minimization standards with the emerging consensus. The standard aligns with those in the EU's General Data Protection Regulation and other state laws that currently cover over 610 million consumers across the world. I'm going to hit a little bit on the accessibility issue. The current standards would limit accessibility. Many Maryland consumers rely on tools like voice recognition, text-to-speech, and other accessibility features, or to use online products and services. Such tools often rely on consumer-provided data to work effectively. While such tools are clearly adequate, relevant, and reasonably necessary to provide products and services, the current standard would require that businesses show that such tools are strictly necessary. If businesses are unable to show strict necessity, they may provide fewer accessibility features to ensure compliance. The standard risks hindering many vulnerable populations' ability to use the internet by depriving them of tools that make online products and services more fully accessible. To ensure that Maryland consumers both continue to benefit from the best possible consumer protections and maintain both privacy and accessibility, CCIA recommends passing House Bill 1365. We appreciate the committee's consideration of these comments. Thank you.
Thank you. Seeing no questions, that concludes the favorables. We'll now go to the unfavorables. We have Kara Williams and Matt Schwartz, and then is the Ellen Bach. You can go ahead and start when ready.
Thank you, Mr. Vice Chair and members of the committee. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. Last year, this committee and the Maryland General Assembly rejected the idea that a privacy bill should simply maintain the status quo in terms of how companies collect and use our data. Instead, the legislature decided to go further to protect Marylanders' privacy and to encourage companies to find more innovative, privacy-protective ways of doing business. This bill would reverse that pro-consumer work. The Maryland Online Data Privacy Act requires that companies limit their collection of personal data to what is reasonably necessary to provide the product or service the consumer requested. This aligns companies' data practices with what consumers expect. Despite what you've heard from other panelists this morning, Maryland's current law does not require more consent pop-up boxes. Lobbyists are arguing that Maryland's law would require more pop-ups because this is how businesses are choosing to implement it, so that they can continue collecting as much personal data as they want. The current data minimization rule in the law allows companies to collect all of the data that is necessary to provide consumers with the products and services they request without giving them limitless abilities to collect any personal data that they want. Industry lobbyists will argue that this bill is necessary to make Maryland's law consistent with other states, but consistent regulations shouldn't mean weak regulations. This bill undermines the entire intent of Maryland's privacy law. As you've heard, numerous states are now considering mirroring Maryland's rule, including Connecticut, Vermont, Massachusetts, New Mexico, and Maine. But this bill would gut one of the most important provisions. It would also make Marylanders less safe online. EPIC asked this committee to give an unfavorable report to HB 1365. Thank you for the opportunity to testify, and I'm happy to answer questions.
Chair, Vice Chair and members of the committee, thank you for allowing me to testify today. My name is Matt Schwartz. I'm a policy analyst with Consumer Reports based in Washington, D.C., testifying in opposition to HB 1365. Last year, this committee passed critical consumer privacy legislation with the Maryland Online Data Privacy Act. One of the most central aspects of that bill, now signed into law, is the data minimization provision, which states that data can only be collected by covered businesses when reasonably necessary to provide the service. That's a common sense consumer protection to prevent the rampant overcollection and subsequent misuse of consumer data. For example, your flashlight app does not need to collect your precise geolocation and should not be allowed to pester you to receive it, since there's little to no benefit to you, the consumer, for allowing that access. Maryland's new law ensures that these types of unnecessary collection of data are blocked by default. This bill, supported by the very companies that exploit consumer data for profit, attempts to gut this important provision and replace it with a standard from industry-friendly privacy laws we know do not work. And indeed, even the sponsors of those laws know do not work. For example, for the past few years, industry has championed the so-called Connecticut model, which includes the same weak data minimization provision proposed here. Yet the sponsor of that legislation, Senator James Maroney, is now considering legislation to largely match Maryland's data minimization standard, supported by the state's Attorney General. Other bills, like those in Washington, Massachusetts, Vermont, Illinois, and Maine, seek to do the same. It's clear that more and more legislators are rejecting big tech's lobbying efforts and are striving to create real privacy protections, like those in Maryland's law. This bill would take us in the opposite direction and should be rejected. Thank you for the time and happy to answer any questions.
Thank you. We'll now go to the virtual witness, Ellen Hengsbach, and if you could just hang there after she testifies, we'll go to questions.
Hello, Chair, members of the committee. Thank you for the opportunity to testify today in respectful opposition to HB 1365. My name is Ellen Hengsbach. I'm with PIRG, the Public Interest Research Group. We're a nonprofit that advocates on behalf of consumers. We oppose HB 1365 because it would needlessly weaken the protections Maryland consumers gained through the passage of the Maryland Online Data Privacy Act. When we use our favorite apps, websites, or smart devices, companies on the other side are often gathering far more information about us than what's necessary to deliver the products or services we're expecting to get. And these data collections both do not match up with consumer expectations and are also dangerous for our personal security. The more data that companies collect about you and the more companies they sell it to or share it with, the more likely it is that your information will be exposed in a breach or a hack and end up in the wrong hands. Even basic information like your contact list can be used to create hyper-targeted scams that make you or your loved ones more vulnerable to identity theft or financial fraud. The best thing for consumers is to change how companies can collect and use personal data up front, which is what Maryland's existing privacy law will do. And so ultimately, the Maryland Online Data Privacy Act, as written, will limit the most harmful data collection practices while still allowing businesses to provide the products and services that consumers are looking for. And by passing HB 1365, however, would be a step backwards for consumers. And therefore, PIRG urges you to continue the important work you've already done to protect consumers' data privacy by not weakening Maryland's privacy law. And we respectfully ask for an unfavorable report. Thank you.
Thank you, Mr. Chair, and thank you for being here today. Isn't it true that you can opt out either by contacting the business itself or turning off targeted ads on your browsers?
Correct.
Okay. And then we're talking about businesses, and I know you're with a am I cut off? It's enough out of me. As a nonprofit, but aren't we in a fiscal situation in the state of Maryland where should we keep a law on the books that makes it more difficult for people to spend their hard-earned money and to generate sales tax and add to our economy? And while I understand what you were saying, I still feel personally, and I think a lot of people would, I feel more secure not having to keep clicking on boxes and filling out information so that I can safely get ads from companies that I know, I trust, and I want to be a part of. So that was a lot.
Senator, thank you for your question, or Representative, thank you for your question. Let me know if I missed any of it.
Thank you for the upgrade.
So
that's true.
This bill would not make it more difficult for any Marylander to spend any money on a product that they want. I know that you heard testimony earlier this morning that companies would have to send you all of these pop-up boxes, but that's exactly what Maryland's current law seeks to fix. A real data minimization standard, like the one that has already been passed in the Maryland Online Data Privacy Act, actually reduces consent fatigue, and that's the reason that consumer-facing nonprofits like us have been advocating for a true data minimization standard across the country for decades. The rule that is in this bill and some other laws across the country in fact relies on those consent pop-ups because they're and long privacy policies that no one ever reads and doesn't have the power to change even if they did read them, because companies can just put anything they want in those privacy policies, and you have to click accept in order to buy from their store, use their website, or do any of the things that you went online to do. So that actually makes you less safe than a true data minimization standard.
But isn't that on the individual to make that decision to choose whether they want to do it that way or not do it that way? Aren't we taking away options and choices?
We can't be concerned about both consent fatigue and want to put the onus on the individual. There is no way for those things to align together, and the businesses are the ones that are profiting off of your data. So respectfully, the onus to use your data safely and only collect what they need should be on the companies that are making massive profits off of your data.
But it's not just big companies, and it's always that, profit is evil. Aren't businesses in business to make money?
Yes, but smaller businesses are not making money based on these targeted advertising ecosystems. It's the large ad tech companies and the big tech companies you do think of when you think about the online advertising world that are profiting off of these smaller businesses using their services.
I'll end with this. I know you're ready to yell at me. I would contend that that's not the case, because my shopping habits, I find small boutiques and small retailers and small companies, once I click on something, once I say yes, I like getting a small business, and then you get information from them, and it's the small mom and pops that are down on Main Street, Ellicott City, other places, or even across the country. So that would just be my last comment, and I'll stop.
Thank you, Mr. Vice Chair. Are either of you Maryland-based companies?
No.
Okay. Do you have any clients that are in Maryland?
I mean, CR has members that
Okay.
live in
Do you have any members that are in Maryland?
We have members all over the country.
Do you have any members in Maryland?
Yes.
Okay. Thank you.
So, gentleman to the left, your consumer reports?
Correct.
Okay, so what do you feel about the bills that I'm seeing coming around about cars that drive around tracking their usage for the purpose of collecting a mileage tax? Where do you stand on that one?
Yeah, I mean, there's been a lot of abuses of driver-related data recently.
Would you say that it's an abuse that a legislature may pass a bill to track cars driving around for the purpose of collecting a tax by the mile?
No, sorry, I was talking about car-related abuses of driver data. I don't know about these bills you're referring to.
No, I'm saying that my online data privacy concerns, at least as you describe them, should be consistent if we're talking about cars driving around and having governments track their usage so they can collect a mileage tax. That's my point.
Agreed.
You're going to be around. Are you going to be around for that bill if it comes around?
I hadn't heard about it. Is that up today?
I'll call you.
Okay. Glad to help out.
So just to clarify, the onus is still on the individual. They can opt in to giving the data, correct? I mean, I know there's consent fatigue out there. I get it, but I just want to make sure, like, we're saying, there's no, why should the onus be on the, it's on them either way. It just shifts. Do they want to read the disclosures, or they just want to check 9 million boxes without reading them?
Well, it's about protecting them by default, so you don't have to ask the consumer one way or the other.
Okay, but I'm just saying.
So they don't have to opt in or opt out.
Right, and I'm sure opting out, they would have to find something on some page randomly to click to get out of it, rather than the 9 million pop-up boxes that drive me crazy to opt in. So, okay.
And this bill does have an
we're good,
opt-out.
we're good. Okay, thank you so much. That concludes this bill hearing. Next, we will go to House Bill 1345. Delegate Jacobs, and you can bring up your panel.
because I haven't seen it.
Hey, Delegate Jacobs, 1 second. Ma'am, are you good? Do you need a hand?
No, I'm okay.
Is that all you got?
That's it.
Okay.
Yeah.
All right. Good afternoon, Mr. Vice Chairman and members of Economic Matters, some of my former colleagues. Good to see you all again. I'm here today to present House Bill 1345. It's Consumer Protection
Delegate Jacobs, real quick, can you just move the mic closer to your, the hallway, they all bought Pam Vitals wrestling gear. I can barely hear you.
It's pretty loud out there, I'll say that. Can you hear me now? All right. Let's try again. All right. I'm here today to present House Bill 1345, Consumer Protection Agricultural Equipment Warranties Bill. Several states have passed legislation creating a lemon law for farm equipment. Under these statutes, an owner of a farm equipment has a legal remedy when the farm equipment has a nonconformity which has not been repaired within reasonable number of attempts. Historically, farm equipment for commercial and agricultural use was not covered under federal consumer warranty law. Some of the tractor combines, et cetera, can cost between $300,000 and $500,000. A lot of equipment that's pretty high price has a very complex computer and electrical system, so sometimes things just go wrong. By no, just the way things happen anymore, it seems like. This legislation seems to remedy the problem by having the consumer during the warranty period report the nonconformity, defect, or condition by providing written notice to the manufacturer or dealer by certified return receipt mail. The consumer shall provide an opportunity for the manufacturer, factory, branch, or dealer to correct the nonconformity, defect, or condition. The manufacturer, dealer, et cetera, shall correct the nonconformity, defect, or condition at no charge to the consumer, regardless of whether the repairs are made after the expiration of the warranty period and within 30 days after the manufacturer's or dealer receipt of the consumer's notification of nonconformity, defect, or condition. After a reasonable number of attempts, the manufacturer or dealer is unable to repair or correct any defect or condition that substantially impairs the use of the market value of the agricultural equipment to the consumer, the manufacturer or the dealer shall replace the agricultural equipment with comparable agricultural equipment that is acceptable to the consumer or accept return of the agricultural equipment from the consumer and refund the consumer the full purchase price. And also, Mr. Vice Chairman, I spoke with industry last week about some amendments which I just got. I mean, literally right before I got here. I do have a copy of those amendments, but I talked with John Deere and a couple of the other big companies that made some tweaks that made the legislation, the language of this legislation really blend in more precisely with the actual use of farm equipment where you have harvest seasons and layup times and things of that nature. It also pushed back the start date to January 1st of 26 instead of October 25 to give them time to align with provisions of this legislation. So with that, I'll turn it over to Mike. This young lady, I think, is one of my constituents that has had a bad experience.
Thank you. Thank you, Delegate Jay, and thank you, members of the committee, chair, et cetera. My name is Janelle McHenry. I currently live in Kent County, Maryland with my husband and my son, where we farm beef cattle, grow corn, wheat, soybeans, barley, and do a lot of hay for the beef, in addition to other industries to keep us viable. So imagine investing in a brand new vehicle, something that you've always wanted, you've needed, et cetera. After you've purchased it, you've driven it for a day, next thing you know, have issue after issue. The parts for that take weeks, if not months, to come in. You're unable to take that to work, to school, to the store, et cetera, to get your job done. This is what we've been faced with. My husband and I purchased a Lemon telehandler back in 2021. And since we've purchased this piece of equipment, it would stop randomly in any position. The boom could be lifted all the way up. It could be going down a hill. It could be going up a hill. It could be in the middle of feeding calves, right in the middle of the way. As a family, it's a huge concern. What if somebody was in that bucket? What if that hay bale falls off the boom while it just stops randomly and hurts somebody? A huge safety concern in general when it just stops in general. But in all, it spent the first 2 years, we only were able to use it about 80 days out of that first 2 years. So it's just unrealistic for a young farm to continue to farm and operate when a machine that we need to operate is completely unavailable. We reached out to both the equipment dealer and those who developed that piece of equipment and built it, and there was nothing that they wanted to do or try to do to even help slow that burden down, and we had to rent pieces of equipment for money to still operate. So I'm just here today that we all want consumer protection for your new vehicle. We're asking for consumer protection for agriculture equipment so that those responsible must uphold that responsibility. Thank you, guys.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Lindsay Thompson, here today on behalf of the Maryland grain producers in support of House Bill 1345. You heard Janelle tell the story of the experience that her young farm family has had and the financial burden that that has put on their family. Investing in equipment, agricultural equipment, is extremely expensive, but it's also necessary, right? We can't do our jobs without having the tractor, the combine, the telehandler, the loader. And when those pieces of equipment are bought, especially brand new and under warranty, and you are making payments on that equipment and they don't work right out of the gate, not only is that a financial hardship, but that is also an operational hardship. I always say farming does not wait. If my combine, my brand new combine, breaks down in the middle of harvest and those parts are going to take 3 weeks to get there and I'm gonna have to wait for service, farming doesn't wait. You have to turn around and, as Janelle said, rent additional equipment. This bill is modeled after Virginia that has an agricultural equipment lemon law. We feel that this is bringing Maryland on par as well with the protections that are provided for vehicles. And honestly, I feel like this may even be more important because you can very easily go out and rent a car. Cars are not on the scale of expense that agricultural equipment is, but it's not always readily available to turn around and rent a piece of agricultural equipment. So this would require the manufacturers to remedy that with either accepting the return or replacing the equipment, removing that financial hardship on the farmer and allowing them to purchase additional equipment. Thank you.
Thank you, Mr. Chairman. Two questions, actually. Have you seen the testimony of North American Equipment Dealers Association? They say that your bill should direct the towards the manufacturer rather than the dealer, and they're suggesting an amendment that would place the warranty obligations on the manufacturer rather than the dealer. Are you okay with that? Or you
well, like I said, I have a set of amendments that I just got literally just before this hearing.
Right, so one of your amendments addresses
them last week, and some of these amendments actually deal with that particular issue. So,
okay.
Perhaps when the committee gets a chance to look at the amendments, they would.
Okay, and then the other question, the bill states may award damages up to $10,000. I don't know where that number came from, but would it be more reasonable to allow recovery of attorney fees if it goes to court? Obviously, you want the equipment fixed, but I mean, sometimes attorney's fees can get rather large. I didn't know.
Well, let me just give you a background of this bill. There are actually total 11 states that have some sort of lemon law. That there were 4 that were real specific to this one, but then there's a total of 11. And so this bill, after reading those bills, Virginia kind of aligned the best with what we were trying to do. And when I took the bill to bill drafting, they wanted to add the Maryland lemon law statute that's in place in Maryland in there. So that's how this combination came together. And I got the bill like the day before the deadline to drop it. So, you know, that's why we got the amendments from the manufacturer, from the companies, John Deere, et cetera, that hopefully will remedy some of those questions.
All right. Does your amendment look at that as well, the damage recovery, or?
I don't know that it addresses the $10,000 issue, but I think your question is reasonable to assume some of the lawyer fees certainly can run up pretty quickly.
Yep. Okay. Thank you.
Delegate Jay, how are you doing?
All right now.
Sorry, Janelle and I have both known him since we were like this tall, so excuse her calling him Jay.
I like it. I'd call him Batman if I could. So in the bill, actually, where Delegate Weibel was talking about the $10,000 fine, my only question is, it says something where if you were found to have acted in bad faith, and I'm just curious, I mean, how do you define bad faith in the setting of consumer protection? That's
how would I?
Well, I mean,
define
or maybe
bad
we can just
faith?
go offline with it, but it seems like a nebulous sort of term that I don't know.
I think they touch on what bad faith is. But, you know, I mean, if the dealer doesn't want to remedy the situation, I think, you know, if they come up with every excuse in the world, you've probably had some in the carpet business. You know, some of those pad salesmen come in there selling you padding that you've had a bad experience with, and, you know, in bad faith, you want to get rid of them too, so.
All right. Thanks, sir.
Thank you, Mr. Chair, and thank you for opening the windows. Appreciate it. You might have covered this. I'm sorry, I stepped out to get some ice water. When you mention, you know, renting equipment, so, you know, I know living in Carroll County, where farmers are often, you know, land rich but cash poor, and, you know, from year to year, it's a gamble. What would be a typical cost to rent, say, a combine for a number of days? Does anybody know what that would be?
So actually in 2023, our combine caught on fire, so we had to rent a combine, and we used it on 200 acres, and it was $10,000.
Okay, well, maybe that's where the $10,000 comes from, because that makes sense. Okay, thank you, I appreciate it. Thank you for the bill.
Okay, seeing no further questions for this panel, we have one virtual, Kit McGuire. Go ahead and start when ready, sir.
Thank you, Chair, committee members. Thank you for the opportunity to speak today. Delegate Wibble, thank you specifically for calling out our written testimony. This bill fundamentally misrepresents the role of equipment dealerships and warranty process. Dealers are service providers, not warranty creators, and manufacturers design the equipment, establish warranty terms, and ultimately determine what is covered. This legislation would place the financial burden of repairs squarely on dealerships regardless of warranty status. This creates an untenable situation where dealers would be forced to either, one, absorb costs when manufacturers deny warranty coverage, or two, face potential lawsuits from consumers who experience losses when dealerships can't provide immediate solutions. When a customer purchases equipment with a manufacturer's warranty, they establish a contractual relationship with the manufacturer, not with the dealers. The dealer facilitates this relationship, but does not control the terms. So this is our primary reason why we're in opposition to this. The second reason is concerns around the impracticability of a 30-day repair requirement. I think that the sponsor has mentioned that the manufacturers have probably brought up similar concerns there. There are just things around, harvest season, parts availability, things of that nature that need to be taken into account there. For example, dealers stock inventory based on historical data and likely repairs, not unknown defects. So when unique problems arise, they often depend on manufacturers to ship parts, and you can't increase that speed by legislation. So thank you for the consideration of our concerns. I'm happy to answer any questions, and standing by for any further questions here. Thank you.
Thank you. Delegate Rose.
A question, and if you don't have the answer, if you can get back to me with it. So they keep mentioning dealers, the difference between the dealers and the manufacturers, but do some dealers purchase equipment to have on hand on their own to resell it to the communities, to your knowledge? And if not, how would this bill, and if it doesn't, but if you have resale of equipment, because I know that the life of some of this big equipment is fairly long, correct? So if it's something that is a used item, how would this bill, to your knowledge, be affected?
I don't know how it's going to affect the used market immediately, ma'am. You are correct. I mean, dealers maintain their inventory, depending on what they project is going to be needed for sale to their customers in their communities. And so the inventory that they keep is going to vary from dealership to dealership and location, and vary throughout the year as well. Generally, they do have several pieces of equipment in inventory. And I know that there are certainly many cases, I would say probably most dealerships will go out of their way to rent a piece of equipment or to lend a piece of equipment if there's going to be a substantial amount of downtime due to repairs on something. Does that answer your question? Is there anything else that I can clarify there?
I think mostly. I'll talk with the bill sponsor offline as well, but thank you.
Seeing no further questions, that concludes this bill hearing. Next, we'll go to Delegate Johnson, House Bill 1274.
Good afternoon, Mr. Chair, members of the committee. Delegate Johnson here, asking for a favorable report on HB 1274. This is third-party litigation financing. This bill would require mandatory disclosure of third-party financer agreements in the state court proceedings to reveal potential conflicts of interest. What is third-party litigation financing? Third-party litigation financing is when an outside entity provides financial support for a person, for a law firm or business to cover their legal expenses in exchange for a portion of the settlement or judgment. So in New York, what happened was that the New York Attorney General exposed third-party litigation financiers for abusing 9/11 first responders. So what happened was that those 9/11 first responders were charged an excessive interest rate, sometimes to the tune of 250%. With this, the United States District Court of Maryland already does this. They already asked for disclosures in the federal court. So what we're asking for is the state to do the same. So with that, Mr. Chair and members of the committee, I'm going to turn it over to Thanos.
Mr. Chairman, members of the committee, Robert Enton on behalf of the American Property Casualty Insurers Association. Today I am Dr. Yes, the chairman's not here, not Dr. No. I'm here to support this bill. Our position is for the property casualty insurers is aligned with the insurance industry. It is aligned with the Maryland Chamber of Commerce. It is aligned with the Office of Consumer Protection in the Attorney General's office, supported by consumer groups, and also in line with the Commissioner of Financial Regulation. Very simply, what this bill does, it requires and makes it clear that companies that provide money to third parties, and the way that they get repaid is by taking a portion of a settlement or cash received in a suit brought by a consumer, that is a loan. That's the bottom line. It's a loan. If I provide you funding, regardless of what you're going to do with it, and you have to pay it back, and maybe there's this contingency or that contingency, that is a loan. The position right now of the Attorney General's office or the Commissioner of Financial Regulation is that these are loans, that the people that make them have to be licensed. You're going to hear from the trade association for the companies that do this to say this isn't a loan. This is funding for, it's not for the litigation, it's funding for groceries, this, that, or the other. The bottom line is they're being given money and they have to pay it back out of the recovery. All the bill does is say you have to be licensed and you have to make adequate disclosures to the consumer, and if it's a tort case, to the insurance company that's involved. That's all it does, but it's critical if we're not going to have consumers be abused, and if consumers know exactly what they're getting into, and if your regulators have the ability to look at these companies, to examine them, to make sure they comply with Maryland law, including the caps on interest rates. So for those reasons, we strongly support this legislation and hope you'll give it a favorable report. Thank you.
Mr. Chairman, members of the committee, for the record, Bruce Bariano. I'm here individually, practiced law for 30 years. I think this is a superb piece of legislation, but it needs to go farther, because not only do you have the arrangements and the relationships that are set up in this bill, but you also have lawyers that are taking out loans themselves to finance personal injury litigation. Personal injury litigation, if you do a great deal of it, it's very expensive, particularly because you take it on a contingency and you only get paid if you have a recovery. But I think what needs to be added to this from a consumer protection standpoint is lawyers that take out the loans and they don't tell their clients. So when they do a settlement or they handle a matter, they've got a nut that they've got to pay in addition to the interest of their client. And I personally think it's a violation of the code of ethics of a lawyer not telling their client. And so this bill should apply to attorneys as well that are taking out these loans. And they have to advise and let their client know up front that they have another financial obligation that relates to the case that they're handling on a contingency basis for the client. Thank you very much. Urge a favorable report with that broadening and further protection.
Good afternoon. My name is Nancy Egan. I represent the American Property Casualty Insurance Association, whose members write 71.4% of the property casualty market here in Maryland. And I want to thank Delegate Johnson for introducing this consumer protection legislation. I just wanted to let you know that we did reach out to the Office of Financial Regulation and the AG's Consumer Protection Division, and they have suggested amendments which only strengthen the legislation. They want to make clear that this type of lending to plaintiffs that are involved in a lawsuit should be required to be licensed. And as well, the AG's office wants some additional protections added to the bill, and we are very much in favorable. These small loans are given to consumers that are part of a lawsuit, and then they charge these very high interest rates, and they're unaware that they are required to be subject to Maryland law. If you look at the testimony of the Consumer Protection Division, it says fairly clear, any argument that these loans should be treated differently than other small loans because they are contingent on a successful recovery in litigation is not strong, as the Maryland consumer protection laws explicitly cover loans under $25,000, even if they purport to be contingent and are non-recourse. What is unclear, what third-party litigation financiers typically charge for loans, as it appears to be a guarded secret in the industry. And their division believes disclosure of the interest rates and other costs of lending is important for transparency in House Bill 1274. Let me just give you one example. In the matter of Plaintiff Funding Holding, Inc. doing business as Law Cash, where the Office of Consumer Protection took a consent order, there were 292 transactions involving 240 consumers. And in this case, the Law Cash had to refund over $195,000 and pay a fine of $140,000. I have some additional examples I can provide, but we hope you provide a favorable report. Thank you. Oh, I'm sorry. You got Mark.
Thank you very much, Mr. Chairman, members of the committee. I'm Mark Behrens. I'm also here on behalf of the American Property Casualty Insurers Association. I don't want to belabor the points that have already been made about the importance of having licensing and consumer protections in the bill. I want to focus on one of the provisions in particular that is a very sound provision for consumers, and that is in the class action provision. You all have probably all been part of a class action yourself. Have you ever gotten one of these notices in the mail where you're part of a lawsuit that you never knew about and you're getting 3 cents or something? You get a coupon to go buy the product that your lawyer has already claimed was defective in some way. Well, in the class action context, there's a real risk that you have a funder who colludes essentially with the lawyer to both make a lot of money, and the consumers who are supposed to be front and center in the lawsuit, their interest gets sold down the river. It's probably happened to every one of you. And what the bill says is that the lender owes a fiduciary duty. That is just like when you have a lawyer, or you go to a doctor, or you go to an accountant that does your taxes. A fiduciary duty means that they have a special relationship with you, and they have a legal obligation to put your interest first. And the bill would require that. It says in the black letter of the bill that the funder has a fiduciary duty owed to each member of the class. And also, the litigation funding contract has to be provided to each of the class members. So you'll know when you're in a lawsuit, and you'll know if your lawyer is working with an outside funder. And you'll know after this bill passes that they're putting your interest first. And with that, I'd be happy to answer any questions that the committee may have.
One quick question is, how many states do this currently?
The licensing of these litigation financiers are.
Hold on one second, Nancy. You turned it off when you hit the button.
Oh, I'm sorry.
That's okay.
The licensing of the consumer third-party litigation financiers is currently 16 states, and then add Maryland would be 17.
You all mentioned something about contingency. Okay, so it's contingent on you winning the case, right? So if I take out that loan and you lose the case, what happens? What's my obligation?
Non-recourse, that means that if they don't win their case, then they don't have to pay the loan back.
And what's typically an interest rate on something like this?
We're seeing in states where they're not regulated, sometimes up to 250%.
Okay, thank you very much. Thank you, Mr.
Mr. Chairman, couple questions, since I'm not an attorney, so I wanted to understand some of the context. The examples you're giving me, you gave with the 9/11, and I think it's something I remember when I was on judiciary, happened like with the Freddie Gray case of lead poison, lead paint stuff, and the family sold the funds to something, a lot of other stuff happened. But are these only related to class action suits? So they're not only related to...
No, it could be any plaintiff lawsuit.
Okay.
In fact, if you ask about that In November 2017, the consumer, CFBP, sued a litigation financer Access Funding in federal court in Baltimore. Access, which was featured in the 2015 Washington Post story titled "How Companies Make Millions Off of Lead Poisoned Poor Blacks," was accused of violating the Consumer Financial Protection Act of 2010 for providing these cash advances to plaintiffs owed settlement money from lead paint defendants. The Maryland AG had also sued
You don't have to read it all. I know about it. So, okay. So I just want to get to my questions,
Yeah,
but I just wanted to understand the context of it. So right now, based on, I guess, the answers you had before, these financiers come to folks and say, you know, we're going to help you with this case, whatever. And since they're not necessarily class action, they may want their independent lawyers or whatever, attorneys to do that, okay? And they don't have the money to pay for it. So basically, this is a financer, not necessarily an attorney, because Mr. Bariano said we should add attorneys to that. So is that everyone's agreement that there should be both that we're talking to, should be under this law if we're passed?
The disclosure of any financial agreements between the attorney and the, those would be commercial lenders to the lawsuit, the law firm, and then there's the consumer third-party litigation financing, which is the ones that are regulated by the Office of Financial Regulation.
Okay, so right now, neither one of those would be subject to the, truth and fair lending statute?
Currently, the Office of Financial Reg and the Consumer Protection Division say that these types of loans should be subject to licensing and subject to the Maryland lending laws. However, we're putting it into statute to make it clear and also to add in very specific language into the statute about what needs to be disclosed to these people that are taking out the loans, assuming they're going to win a lawsuit and then not realizing they're having to owe large percentage rates afterwards.
So I understand from the lawyer's standpoint, if you don't, because I guess you can take a case on contingency and not get paid. But financiers don't do things on contingency. So how would what would happen if they aren't able to recover, right? Because that's a whole different, you don't have a mechanism where I go and say, hey, if I get my taxes back, I'll pay you for this mortgage, so I can pay you, my down payment for the mortgage. You don't do that in financing. So how is that handled?
That's exactly what's happening here. So there are two different types of lawsuit loans. One is a loan directly to the consumer. And these are usually smaller amounts, $3,000, $5,000. It's like a payday loan, okay? And the obligation then to the consumer is, it's a non-recourse loan, so it's, I'm going to give you this $5,000. And if you win your lawsuit, then I'm going to get my $5,000 plus whatever the interest rate could be, 30%, 50%, whatever they charge in the contract. So that's one form of this. And if you lose the lawsuit, you don't pay it back. So that's why they say we have to charge higher interest rates, because we may win some of these cases, we may lose one.
Okay.
Okay. And what the bill tries to do is, by putting this under the current licensing, is treat it like other bank loans. So the consumer's protected, so they can still get a loan, but not get gouged.
So it would come under, I think in Maryland, only 36% is the max we can do for some of these loans, or?
It's over 1,000, it's 24%, and then up to 1,000 is 33%.
33%. Okay, thank you.
That was literally my question, was the
Thank you, Vice Chair. So Delegate Aaron's asked how many states this applies to, and I guess if Bob or anybody, do other states treat this the same way as this bill would treat it in Maryland?
I can answer that if you'd like. My understanding is that of the, 16 states, whatever, all but 2 of them follow what's basically in the bill before you today, and that is that treats these as loans and that the company has to be licensed. And frankly, I just don't understand what the problem is. If you're giving somebody money and they have to pay it back in a certain fashion, why isn't that a loan? Why shouldn't it be subject to the license, the lender be subject to licensure, and why shouldn't it have to comply with the interest rates? And that's what other states, when you ask about other states, that's how other states, for the most part, have treated it. And this is an initiative, it's unusual, but you have the insurance industry, you have the Maryland Chamber of Commerce, you have consumer, the Office of the Attorney General, the Consumer Protection Division, all saying that this is something that ought to be done.
I mean, this is only a probing question because I'm looking at both sides and trying to understand the bill, but I'm very familiar with what a non-recourse loan is. Usually in the non-recourse loan, there's collateral or there's some asset where if you don't pay the mortgage, the collateral goes to the other party, and the non-recourse component is they're not going to come after you to make you pay. And so my only question is, does this, would you agree or disagree that this lending product or whatever this looks like is a non-recourse loan?
Well, it's a non-recourse loan to the extent that they're not going to pursue the borrower if there's no recovery in some fashion from the legal proceeding. So to that extent, I guess you could argue it's non-recourse, but it's still a loan, whether it's non-recourse or recourse.
Oh, I mean, what I would say is a non-recourse loan is definitely a loan, but there's collateral.
Yeah, exactly.
Now, so you're saying this is a non-recourse loan.
That's my understanding.
But yet there's no collateral, so there's no collateral. There's no collateral requirements.
Right, there's no collateral. Although I guess in a way, the collateral is the lawsuit.
Right.
And the proceeds of the lawsuit. That is the collateral. There's no mortgage recorded in the courthouse. There's no financing statement recorded at the courthouse. But that money is not going to go, about one dime of that money is going to go to the consumer until the lawyer gets paid and until the financing company gets paid.
So collateral in this setting is not assets, it's over a year's period of time, they're going to win so many cases and they can afford to lose on some, that's their collateral. And that, or at least by definition, it's probably not collateral, but it's the business model that they're bringing forward. So the rates are capped in Maryland. Delegate Queen brought this up. And do we know what the rates are?
And here there's...
Only because I wasn't listening.
For these transactions, right now, if you pass this bill and they're not lenders, there's no cap whatsoever. None.
Let me go back to what we said before, though. Under the Maryland law, it's 24% for loans over $1,000, and for loans from 0 up to $1,000 is 33% interest. That's the current law for these types of loans.
Thank you. I'm just trying to make sure that I have a full understanding of the bill based on some examples that were given. So you talked about like personal injury. I don't remember who talked about personal injury, but so just say it's a personal injury case. The attorney, somebody's working as a maintenance person, and they're moving a refrigerator, and there's an accident or of some sort, and they end up injuring their back, and essentially they're pretty much paralyzed, or for the most part paralyzed. The attorney then goes and gets a loan from someone called a litigation financer, and will give some of those dollars to the individual who now cannot work so that they can survive. No? And then, no. Okay, help me to understand the bill then, because I'm totally misunderstanding
If you have a
that.
law firm or you have a law practice and you're doing a great deal of personal injury cases, there are contingencies. We all know what that is. The injured person does not have to put up any money whatsoever.
Correct.
Not a dime.
Right.
Litigation costs. There are depositions, there are filing fees, there are getting expert witnesses if you go to court. All those expenses can really mount up, particularly if a law firm is doing a lot of that stuff. Well, there's some law firms, and that's why I think they need to be included in here. There are some law firms where they take out the loans themselves because it's a cash flow situation. And my only point was that, say there's a settlement, either by a court ruling or a compromise, I think it's absolutely essential that that lawyer or that law firm let the injured person, the party, know up front that the lawyer has a nut. They've got money that they have to pay because they can't serve two people at one time. And they can't serve themselves with the obligation that they've made to advance the money in any settlement or negotiation. So I think it's a great bill. I just think I think the way I read it, just to be brief, the way I read it is it does not include the scenario where it's the lawyer borrowing the money for financing the cost and the expense of handling these contingency cases.
So what does the bill say? Who in this bill is borrowing the money, and who is the litigation financer? And
Thank you.
Yeah.
So to be clear, this is addressing these small type consumer financers. This is exactly what you're saying, someone that's injured and waiting for the case to settle and says they need expenses for their day-to-day living. So they take out these loans on the basis that they have a very good case, and the lender will lend them the money based on what when they review the case, that the person trying to borrow the money. So they're looking at the cases and saying, well, this looks like a good case. We're going to lend you this money. It's at certain interest rates. And then when it settles, we take our proceeds out of your settlement.
And who is that? I mean, who are they going to? Is this like
They're finance companies.
They're finance companies.
So I get injured, I can go, let my fingers do the walking and go down the yellow pages and
if you looked it up.
find a litigation financer.
Or go online and Google it and find them. Or maybe your lawyer will refer you, say, well, there are companies out there that finance, because you've got this case that will loan you money. And to me, it's, if I'm hurting for money and I got to go spend a couple $1,000s in court costs and fees for depositions, whatever, where am I going to get that money from if I got to feed my family and pay my rent?
So then consumer litigation financing currently exists?
Yes. Oh, yeah. Now, it's questionable whether it's in Maryland or not. We have an email from
just to
one
give
company that says they do business in Maryland. I checked with the Commissioner of Financial Regulation, and he checked the website where they're listed, and they are not listed. But they say they're doing business in Maryland.
And this is seeking to regulate those
Yes.
businesses?
It's making it stronger and making it very specific in the law, because the Office of Financial Reg and the Consumer Protection Division already considers them under regulation and considers them that they are loans. But this is to make clear and to make sure that they are disclosing to consumers what specifically is going to happen at the end of the lawsuit.
So before I go back to Delegate Queen, I guess kind of at the crux of this, and Mr. Bariano, I'll put your situation to the side because you call out attorneys specifically. But really what this is almost like private equity investing in lawsuits and trying to bank off the lawsuit. And I would think that the opponents are going to come up here and say, well, that'll stymie litigation and somebody's ability to get their return. From the table in front of us, from your perspective, I would think that it would cut down or potentially minimize the amount of exposure or lawsuit. But I try to put myself into the individual's position, and what we're asking somebody to do is maybe they've been exposed to lead for 40 years and they have a claim. that somebody could come in and basically buy, their damages that they are entitled to for a lifetime of exposure in that one instance. All the bill does is require the disclosure, correct?
That's it.
I mean, there's a licensing component to it, but it's disclosure so somebody knows.
Yes.
Okay. Delegate Queen.
Thank you, Mr. Chairman. That's kind of one of the clarification. I'm trying to go through the bill to see, are you asking for disclosure and licensing or both? Because I don't see where you're doing both. And
We're asking
so
for both, Delegate Queen.
you're asking for both?
Yes, we want disclosures, and we want to have the statute to say, you can come into Maryland, you can do this, but you got to be licensed. And
Right, you got to be licensed. I see licensing, and within licensing, I think you're assuming they will do the normal disclosures for loans. Okay, well, okay, wait, I won't get back into that, we can read the bill later, but when you say that the 16 states are doing this, are they doing licensing or disclosure? Because I can have disclosure without licensing, correct?
Of the
So I want to
16
know what they are doing.
16 states that require the licensing, and 6 of them require the disclosure.
Okay, 16 require licensing, and of those 16, 6 of them require disclosure. And we want to have both, what the 10 have.
Yes.
Okay, that's what I want to know.
And there's, I think, legislation pending in 12 states right now trying to address this specific issue.
So
Okay.
just to follow up on that, because I'm trying to look at the bill, and this is offline, Delegate Johnson. I don't see any licensing structure set up. So I just need you to follow up with me on what that would look like, because I don't think you need both. But I'm not saying, I don't think you need licensing to do disclosure. I'm not saying you don't need both in that general sense.
We had them.
Delegate Johnson, if you could just follow up with me
I'm
on
sorry.
that language. Okay. Seeing no further questions, that concludes this panel.
Thank you.
I have 2 virtual. First, we will go to Eric DeCampos. Okay. Go ahead, sir, and the other virtual is not here.
Thank you, Mr. Chair. Good afternoon. My name is Eric DeCampos, and I represent the National Insurance Crime Bureau. NICB is a nonprofit organization that works with state and local law enforcement and member insurance companies to detect, prevent, and deter insurance crimes. Now, insurance fraud is not a victimless crime. Fraudsters will exploit every avenue and opportunity to bill consumers and their insurers to line their own pockets, which ultimately increases the cost for everyone. But unfortunately, the courtroom is not immune from this. Fraudsters and their affiliates have engaged in predatory litigation tactics and employed tools to advance their aims. And NICB is concerned that absent additional transparency and accountability, litigation financing can serve as a facilitator of insurance fraud. For example, NICB recently assisted the U.S. Department of Justice's investigation and prosecution in a fraud scheme in New York, in which the fraud scheme included deliberate and unnecessary surgeries performed on victims simply to drive up insurance claims and lawsuits. And these surgeries, as well as other medical procedures, were actually funded by the litigation financing companies involved in this case. The financiers also paid the fraud scheme organizers and other participants referral fees for each patient or victim who signed a funding agreement with those financiers and charged those patients, those victims, absurdly high interest rates, with the majority of the proceeds awarded in the fraudulent lawsuits going back to the financiers themselves. And so House Bill 1274 would provide important consumer protections. These reforms, among others, would help protect consumers and provide regulators with critical information to identify and combat fraudulent activities. Accordingly, NICB...
Thank you, sir. Thank you so much. Okay, seeing no questions, we'll now go to the favorable with amendments. Marta Harding.
Thank you, Mr. Chair, members of the committee. Marta Harding here on behalf of State Farm. In support of the bill, we have requested one amendment. I will just say that it's my understanding on the question of this bill doesn't supplant the existing Maryland laws that require lenders to be licensed and that impose interest rate caps and the like. And in fact, The Commissioner of Financial Regulation has gone after numerous companies, and Ms. Egan cited some of those, for violating those laws. I don't think anything in this bill supplants that. What this bill does is layer on top of that some additional disclosures that we think are very appropriate in this context, and we think the bill is appropriate in that regard. The only amendment that we have asked for consideration of is just imposing an overall cap on the amount of recovery that can come from the award in the amount of 25%, and that is consistent with what has been done in other states, specifically Montana has imposed that kind of a cap. So we would just ask that the committee consider that, just to put an overall parameter out of how much of the award that the company can obtain.
Seeing no further questions.
Thank you.
Next, we will go to the unfavorables. I have two, Eric Schuler and Michael Winkleman. Go ahead and start.
Good afternoon, Mr. Chairman. My name is Eric Schuler, and I'm the president for the Alliance for Responsible Consumer Legal Funding. We're the trade association that represents the companies that offer consumer legal funding. First of all, I want to thank Delegate Johnson for hearing us out on our proposed changes to it. First of all, there's two distinct products that are being regulated by the same piece of legislation. One, which is consumer legal funding, which provides for household needs for the consumer and not used to fund litigation. And then litigation financing, where those funds are used specifically to fund the litigation. The difference between the two is the average funding on the consumer legal funding side is $3,000 to $5,000. The average amount of money on the litigation financing side starts at $3 million. I also want to be clear with some information that was put out from the previous panel regarding regulations across the country. I encourage every single one of you to go to our website, arclegalfunding.org. On the right-hand side, you will see every single statute that has passed across the country. Not a single state has passed statute that classifies this product as a loan. And in fact, several states specifically state that it is not a loan. And in last year in 2024, Washington State redid their lending statutes as to define what is a loan, and consumer legal funding was specifically carved out of that statute. The one other thing too was brought up regarding class actions. Consumers do not get money to fund class actions. That is litigation financing. In my written testimony, we make recommendations to make the bill what we think the bill is better. We are not opposed at all. I want to repeat that. We are not opposed to having the industry regulated. We just want it regulated properly, like we have in about a dozen other states, where we have had no issues, no complaints, and no problems with the industry since we brought in regulation. I'll be happy to answer any of your questions.
Thank you, Mr. Vice Chairman, Mr. Chairman, members of the committee. My name is Mike Winkleman on behalf of the Maryland Association for Justice. We're the trial lawyers. We represent the injured victims in Maryland, and we oppose this legislation. The legislation as drafted is not what was presented before you in the committee today. Here is what the legislation actually says and what it does. If you are injured, either through lead paint, either through being hurt in your building, or through the CVA, through the Child Victims Act, and you need litigation funding to pursue your case, what this legislation says is that you must provide the terms of that funding to the very people that injured you. It doesn't say you have to provide it to the consumer. It says you must provide it to the people that injured you. We, as the trial lawyers, already provide all of the funding information to our clients. With all due respect to Mr. Bariano, if I did what he suggested, I would be disbarred. I would not be practicing and sitting in front of you today. We disclose to all of our clients the terms of the litigation funding. They know exactly how much the litigation funding is. They know exactly what the recovery is, the rates. We are required under the rules of ethics to provide all of that information. So that is patently false to say the attorneys need to be regulated. We already are regulated in this way. What this would do is put consumers at a detriment because it would put a chilling effect on anybody that was going to do funding. If I were going to do the individual funding, which I do, now I have to disclose the terms of that funding to the very people that injured my clients. That's patently unfair. That is not consumer protection, and that is why this is only supported by the group in front of you that you saw, which is the insurance industry, not pro-consumer. Happy to answer any questions you have. Thank you.
Thank you, Mr. Chair. So, Eric, I guess if I can continue my conversation about this and it's not mine, it was their conversation about non-recourse loans. I mean, a non-recourse loan is a product. That is a thing that I'm familiar with. And again, just by way of reminder, if you default on a non-recourse loan, you might lose your asset, but they're not going to go after you personally for the default. How does this, that you're, the product that you're selling, how does it compare and contrast with the non-recourse loan, to the extent you and I might agree on my definition of a non-recourse loan?
No, I appreciate the question. And what you're saying before, non-recourse loans, there's always some sort of collateralized, and most times a property that is in place. Here, there is no collateral here, in that if the consumer loses the case or drops the case, or if there's insufficient funds to meet the obligation in the contract, the Consumer Legal Funding Company has no recourse against the consumer and cannot do anything against them. The courts have ruled on this in New York, in Texas, in Georgia, just to name a few of the states that have said that this product is not a loan. It is not subject to the lending statutes, because there has to be a double contingency here. One, the consumer has to prevail in their case, and second, there has to be enough funds to do it. If that doesn't happen, then the Consumer Legal Funding Company has no recourse. We don't look at credit, we don't look at job history, we don't look at how much money they have in the bank, we don't even go look at use their FICO score. None of that comes into play here. A loan, under the federal CFPB Act and the Dodd-Frank Act, there has to be an ability to repay. In our situation, the consumer doesn't have to have the ability to repay, just that they have to have a valid legal claim, and there's a probability they're going to be successful in their case. That's it.
Right. So are these mainly plaintiffs? I'm only asking because I'm okay. So in a hypothetical scenario, somebody needs to have access to the courts, but you're using the example of like $3 million. So when you say access to the court, the return and or the potential payout is significant, but it's not cheap to go to court. I assume these are your clients that want to have access to the courts for something that's complicated or complex, expensive to prevail in, and that's where your company comes in?
No, and that's, thank you for asking. That's why this bill is very confusing, is because it's calling consumer litigation financing. There is no consumer litigation financing industry. Consumers are not getting money to bring litigation. If they want to bring litigation forward, they go to an attorney. That attorney says, okay, I take your case on a contingency basis, and then that attorney figures out the financing for it. Consumers are not going to an entity and saying, okay, I want to sue XYZ company. I need $300,000 in order to do that. And then this company that says, okay, here it is. That doesn't happen. Consumer legal funding is 100% used to provide household needs. And in fact, if you look at the statutes that we have passed, there is a line in there that's missing from this legislation that says it prohibits the consumer from using the funds to fund the litigation. And there's litigation financing, where that money is specifically used to finance the litigation. And those typically are business-to-business transactions. Company A is suing Company B over a patent infringement. Company B wants to do a cross complaint against them. And their CFO is saying, win, lose, draw, this is going to cost me $3 million. I will go to a litigation financing company, and they will underwrite the claim for me. If I lose the case, I'm not out $3 million. If we win the case, my recovery isn't going to be as big, but they're going to do it. But those are business-to-business transactions. And the problem with this piece of legislation is it's conflating the two issues together. There is no such thing as consumer litigation financing. There's consumer legal funding, and there's commercial litigation financing.
Right, so the follow-up to that then, so you're saying this is business to business, this is a different thing. We're not protecting a consumer in the traditional sense that you're seeing it.
Correct.
Okay. And so many times businesses make a business decision whether to show up at court, and a lot of times that business decision is, it's going to cost me more than what I would be able to collect in a proceeding. Is that?
Correct.
Okay, so in other words, this changes the financial mechanism that would cause somebody not to go to court because they're being given a chance to fund a action, not knowing that they're going to get the outcome.
But again, those are business-to-business transactions, and those are going to be a lot more sophisticated types of transactions than a consumer who needs $3,000 to $5,000 just to make sure they can keep a roof over their head and food on the table.
I've just got one last question. How do you price this to a buyer? I mean, okay, so there's a cost,
right,
and then there's a markup. Okay, I'm just thinking about it as a retailer. How are you selling this? Because, you know, the flip side is going to be a loan has an interest rate, it's an understood repayment period and dollar amount. How are you approaching these businesses with the value proposition?
So typically, these are risk assessed, meaning that the consumer
so you have a
legal
different interest rate depending on whether you think you're going to be successful or not.
Probably the case being successful, how long it looks at. Each company typically has.
I'm sorry. So if it's a long shot, it's going to have a higher rate than a sure
Correct.
thing.
But what we have proposed in our amendments, which is in my written testimony, is that each company will put what I'm classifying as a will not exceed number. So the consumer and their attorney, who has to sign off on every single one of these transactions, by the way, the consumer and their attorney will know day one what is the maximum obligation that consumer will have. So there is no ambiguity whatsoever as to what this costs. You don't have that when you do a credit card or whatever it is. In home mortgages, yes, you have that. But if you look at what you buy your house for what it really costs you 30 years later, I think most people have a heart attack.
And Delegate, if I'm...
Yeah, you're good.
Okay.
Question for Mike, real quick. You said that, and I'm just asking you to clarify here. You said you would have to disclose that to the other side. The way I read the bill is you have to disclose it to the claimant, not the other side. Maybe it's both. I understand it could be discoverable, but where does it say the disclosures to the other side? And it's in the document 18 times, so I apologize if I missed it.
That's all right, Mr. Vice Chair. So I'm looking at page 8 of my printout on the bill, section A1, subtitle 145006, shall be disclosed to each party in the action.
Okay.
So it's not disclosing it to the consumer, it's disclosing it to the persons that injured, the party that injured you. And it's a required disclosure, so not even requested by discovery. It has to be preemptively provided, which is not provided for elsewhere in law.
Okay, Delegate Queen.
Thank you, Mr. Chairman. So, and forgive me because I've got totally confused now because you're talking all this legalese and I'm not a lawyer, so let me make sure.
I'm not a lawyer, but I do play one on TV.
You play one on TV, okay. All right, so you mentioned, so I want, my thought that this bill's intent is disclosure, right? We kind of agree with, at least some of it is disclosure. Some part might be regulation as well. So you talked about two types of loans, and we're focusing on consumers, not necessarily the business-to-business piece. So, so this litigation financing is a consumer type of financing, yes or no?
No. Litigation financing is commercial business-to-business transactions, but the bill does encompass that because it conflates the two issues together.
Okay, so as a consumer, I go to an attorney to get help, and that's going to be called consumer legal financing, or how is that? How are they different? What is the product we're dealing with?
Yeah, so consumer legal funding is used for household needs after you already have a case in the works. When a consumer calls up one of our companies, the first two questions they're asked is, do you already have a pending legal claim, and are you represented by an attorney? If the answer is no, then the call stops. So the consumer already has to have a case already in the system before our companies will talk to them. And then we're clear that the funds we provide them can only be used for household needs, mortgage, rent, car payments, keeping lights on, things like that, and not to fund the litigation.
Okay, so how's the we'll come back to what you give the money for. How does the litigation get funded then, if they already have?
So the attorney, so if I want to sue it, I go to an attorney and I say, Mr. Attorney here, I want to bring this suit. And this attorney says, okay, I'm going to do this on a contingency basis. I'm going to charge you X% plus costs, associated costs to go along with it. The attorney then figures out what that financing is. They may do it internally. They may go to a bank. They may go to a line of credit, whatever it is. They figured out the consumer has nothing to do with the financing of the litigation. It's the attorney that does all that.
So how does that, okay, so there's no disclosure between what you talk to the attorney about, between the two of you?
I disclose all of it to my clients.
To him?
No, I disclose it to my clients, of course. I have to.
So the consumer would get that information?
They already do.
Yes.
And how is that disclosure done? Is it done with an APR? Is it done like a typical loan kind
It's
of
in my
thing?
retainer agreement.
It's in your retainer agreement, so how many hours you spend or something like that?
No, in the retainer agreement, it sets forth that there's going to be a financing, and the terms of the financing, it's all in our attorney retainer agreement.
And the terms of the financing may say some interest rate or limit and payoff, that kind of thing? I mean, does it look like a truth in lending, I guess is what I'm getting to. Does it look like a truth in lending kind of disclosure?
It doesn't, because our retainer agreement would be 100 pages long. But any client that wants to see the documents are certainly entitled to them. And people ask from time to time, and we just show them.
Okay. And so the other part where you're then now helping so assuming that, okay, I have some class action suit, and I might need money now to pay mortgages and that kind of stuff. And you say, I'm going to give you this money, and you don't call it a loan. I'm just going to advance you what I think I'm going to get as a return from this lawsuit. Is that how that's disclosed, or how that's calculated or figured out?
Typically, well, our company will take a look at the case and say, based upon our experience, your case should settle for X. And typically, we don't fund no more than about 10% of what we think the value of the claim is. Not necessarily what the attorney thinks, but what we think. We're going to be a lot more conservative than their attorney is. And then once we determine that, then we call the consumer's attorney and say, okay, Mrs. Jones contacted us, and we're looking at giving Mrs. Jones $2,000. Are you okay with that? If the consumer's attorney says, no, they're not okay with it, it doesn't happen. This is one of the only financial transactions I know out there. Just to get $500, you have to have an attorney say, this is okay for you to do. In most states, you can go out and get a $500,000 mortgage, and you don't need an attorney there at closing.
So I guess regarding this bill, you mentioned page 8 where you had some issues with. Are there other, because I don't see any amendments from you also. I don't know other areas where you have concern. That would be one question. I would like to see that. And I guess the second question is, in the states where they talked about that there's the 16 states or something that has regulations or disclosure, do you not work in those states, or how is it handled in those states?
No, in fact, there's about a dozen states. There's a couple of states in which we do not operate in, Arkansas and West Virginia and Montana. We don't operate there because the rates that have been put in place there are prohibitive for us to work in. The bill that was mentioned in Montana, not a single company operates there. The bill that was passed in Arkansas, not a single company operates there. Bill that was passed in West Virginia, not a single company operates there. So they passed a regulation with the purpose of making sure that this product is not available to the consumer.
Okay. Last question, I'm sorry, just a bit. So there was a amendment that was offered by State Farm that put some kind of cap on it. What's your response to that?
I'm open to the discussion. I just wish we were included right from the get-go, because like I said, I'm not opposed to regulation. I just don't want to be regulated out of business. And because currently we're regulated out of business.
Okay.
And Delegate, it's important to understand.
No, Mike.
Okay.
So, this is going on pretty long here.
Okay.
Delegate Aarons.
Briefly, we keep using the word loan. This is not really a loan. This is an agreement.
Correct. We call it a funding because A loan is a guaranteed some sort of repayment. There's no guarantee in this.
But it meets some of the criteria of a loan. I think that's where the confusion comes. If you win, you have terms.
Correct.
You have period time, you have all that stuff that a loan is, so that's where the confusion comes in.
Correct. But what we're offering in our amendments and everything else is we want to make sure the consumer knows exactly to the penny what the cost is. We don't want anything hidden on this.
I
So
guess
they'll know
that's
that
where
right
I have difficulty, because if
Yeah.
you win, it's a loan.
In that same
We
sense,
had an
but
agreement. But if you
in
lose, it's an agreement.
Right, but 10% of the time on the consumer legal funding side, we get absolutely zero back. 30 to 40% of the time, we're getting less than contracted amount back. So these are very high-risk products.
Sounds like me at poker. Thank you very much.
Thank you, Mr. Vice Chair. So let me ask you to this. Do you both do business here in the state of Maryland?
Yes.
Oh, you do?
Yeah, I live and work and have a practice in Prince George's County.
Okay. And so and I know, Eric, your situation. So the question is that with a loan, so there's 7 types of loans, right? So with your funding that you provide, is there an APR attached? Because I don't think that you ever really answered Delegate Queen's question.
Does my attorney retainer agreement include an APR?
An APR.
It does not.
It does
We are
not.
not ethically required to, that I know of, but we are bound by the rules of ethics, which require that we not violate existing law. So it's implied by contract, yes.
Okay. And Eric, what's your business?
The consumer, I represent the trade association that represents the companies that offer the consumer legal funding product.
So I'm sorry, say that again?
I represent the companies that offer consumer legal funding. Maybe, I'm sorry, maybe I didn't hear your question.
So do you provide, with your funding mechanisms, is there an APR attached to your funding?
In some states, we're required to disclose an APR. In most states in which we have statute, we're not, but the consumer will know exactly to the penny what the cost of the product is. There is no hidden transaction fees. The consumer, in every single statute that we've passed, the consumer knows exactly to the penny what the transaction will cost them before they sign the contract.
Okay. All right, thank you, Mr.
Yep, and I would just say, I know there's been a lot of discussion, but consumer, claimant, I mean, we can interchangeably, I don't want to say that they're necessarily interchangeable, but we can change it to make one, or regulate one in a certain sense. The second is, if it's not a loan, sure feels like a cash advance. So, all right, seeing no further questions, that concludes this bill hearing. Next, we go to House Bill 1294. Chair Wilson.
If they're outside, they were assuming that we would stuck in another committee.
Right here?
Yeah. All right, we'll get started. For the record, C.T. Wilson, I'm sorry. For the record, for the record, Delegate Marlon Ampry here in support of House Bill 1294, Commercial Law, Credit Regulation, Earned Wage Access, and Credit Modernization. Here on behalf of the chairman, happy to do this on behalf of the chairman. And this bill is very similar to the bill that we passed last year and passed over to the Senate, House Bill 246 from last year in 2024. We just added a few more provisions to make sure that we are protecting our consumers here a little better. And we also added some some regulations around some of the tip language that I'll walk through here. Unlike in other states where EWA or Earned Wage Access is regulated as its own financial product, we are agreeing to regulate it under Maryland's lending law, Commercial Law Title 12 with consumer loans and credit provisions. So This bill will add EWA-specific definitions to Title 12, Subtitle 1, requires EWA providers to obtain a consumer loan license, and adds a new Subtitle 15 to include EWA-specific consumer protection requirements. So there's a lot of requirements here. You all are, please read through the bill. You can see some of the requirements that are there. I'm going to highlight some of the major ones that I think are really important that we're going to have here to ensure that that those who are using these services are properly protected. First, providers must develop and implement policies and procedures to respond to questions raised by consumers and address complaints from consumers in an expedient manner. Every time, so there's also a fee-free option, right? So I want to make clear, there's not always a fee associated with these provisions. So sometimes if you are able to, if you know you need $200 on Friday, if you request the money on Monday and you don't get the money till Thursday, you would then most likely not be subject to a fee because you got in front of it further enough. Now, plenty of people will opt if they need the money immediately, and when you need the money immediately, that is when the fee would be put in. But every time they solicit a fee or voluntary payment from consumer, providers must offer that consumer a fee-free option to receive proceeds and must clearly explain how to elect that no-cost option. So you have to put on the website, if you want to avoid costs, this is how you can avoid the cost for these fees. And they must provide consumers their rights under the agreement. Providers must also allow consumers to cancel use of a provider's EWA service at any time without incurring any cancellation fee. Again, no cancellation fee here if you are able to cancel at your will. Now, one of the differences from last year is that we are providing an opportunity for individuals to tip the service that they are using. All right, providers that solicit tips, gratuities, or other donations from consumers must set the default tip to 0 and must clearly disclose all the following to consumers immediately prior to each transaction. And that's that the tips are voluntary. Again, tips are not required, they are voluntary. The tip amount must start at 0. The amount of proceeds a consumer is eligible to receive and the frequency with which a consumer may receive proceeds is not dependent on whether or not the consumer pays a tip or on the size of the tip. They cannot mislead consumers about the tip or how it works. And I just want to point out, there's some language in some of the letters who are in opposition to this bill around the tip being deceptive or it's not something that we should offer, but that's just not true. I want to point to make you understand that the ability to tip is ultimately a First Amendment right. You have the right to tip. It's a form of your First Amendment right of free speech to be able to say that you feel a certain way about the services that are being provided to you. Also, have a collection of fellow elected leaders here who might be familiar with a service called Act Blue. All right, yeah, you've heard of Act Blue, right? Well, at least some of y'all have heard of Act Blue. Some of y'all don't know about it. I don't know if they got an Act Red out there, but the Act Blue. So with Act Blue, when your supporters give you money on Act Blue, there's an option at the bottom. Hey, to keep this service available, would you like to make a tip or would you like to make a donation to our services so we can keep this program and system up and running for individuals? Another example, let's not make this all political. You've heard of GoFundMe, right? When someone gets hurt or injured or some catastrophe happens, someone creates a GoFundMe page, right? You go to GoFundMe, you want to donate $100 to someone who's gone through a horrible circumstance. Well, guess what? Right there on GoFundMe, they ask you, hey, would you like to make a donation to GoFundMe to keep these services available for others who might need a service like this? So same thing applies here. Again, because remember, you don't have to pay a fee if you use these services. You can avoid fees. But you might say, hey, you got that $300 and you were able to make that birthday party happen for your son, and it wouldn't have happened without that service that was provided for you, and you avoided the fee. You want to say thank you to that service provider, you might want to throw in the $3, $4 as to say thank you and keep this service available for the next time you might need it or someone else you might know might need it. So that's I just want to make it clear that the tip component of this bill does not run afoul, it is not discriminatory, it's not going to lead anyone the wrong way. We've put in protections to make sure it's fair, reasonable, and there's other things out there that are using the same type of service. I'm going to walk through a couple more of the provisions that we have around to make sure that their people are protected, and I'll let the panel speak. So there's a prohibition against compensating consumers' employers. Providers are prohibited from sharing a portion of any fees, tips, or other amounts received from a consumer for EWA services with the consumer's employer. There's a prohibition against using credit reports for underwriting. Providers may not use a consumer's credit report or a credit score to determine the consumer's eligibility for EWA. You're also going to see in some of your letters about, hey, Why doesn't the person just use a credit card? Well, the credit card is going to have more fees, higher interest rates, and ultimately harm your ability to go have access to money or access to services in every other realm, in every other market, right? So if here, let's say you don't pay back the money to the individual or the company that you use, they're not going to report you to the credit bureau. You just can't use that service again until you pay them back. If you were to use a credit card and you don't pay it back, guess what? It goes in your credit report. You can't get a cell phone that you might need. You can't get a lot of things you might need. So I think there's an important reason why we need these type of services. Last thing I'll cover is the fee cap. So as far as fees, providers may not charge consumers an expediting fee of more than $5 for any advance of $75 or less, and $7.50 per transaction for any transaction greater than $75. That's the cap on fees. So again, this is a very reasonable bill. Again, reminder, we passed this last year, and again, I'll urge a favorable report on House Bill 1294, House Bill 1294, and I'll leave it to my panel now to add some additional remarks. Thank you. Don't push the button. Now you got to push it though, because it's off. You got to push it back, right?
Hi, everyone. Thank you, Chairman Wilson and members of the Economic Matters Committee. My name is Ashley Urisman, and I'm the Director of State Government Affairs for the American FinTech Council, or AFC. I'm here today in support of House Bill 1294. AFC is the premier trade association representing the largest financial technology or fintech companies, including the biggest providers of earned wage access or EWA services. Our mission is to promote a transparent, inclusive, and consumer-centric financial system, and we support a responsible innovation in financial services and encourage sound public policy. Before guidance from the Office of Financial Regulation pushed many of our responsible EWA providers out of the state in 2023, more than 100,000 Marylanders benefited from access to EWA services. We are grateful to Chair Wilson for sponsoring this bill to establish a revised regulatory framework which empowers responsible EWA providers to return to serving users in Maryland. To ensure that EWA providers safely and effectively serve consumers, we, AFC, have established clear standards on what constitutes responsible EWA and to ensure that users remain protected. Our standards require that a voluntary no-cost option be made available for all users, that strong fee disclosures are represented in a clear and transparent manner. We require that providers cannot underwrite or do credit checks in order to offer the service. And we require that our providers give users the ability to cancel their EWA service at any time, meaning it does not have to be repaid and there will be no recourse other than being barred from the service until it's repaid. We believe that the guardrails set forth in HB 1294 reflect our strict standards. This bill creates an opportunity for Maryland workers and EWA providers to build a stronger economy in the state. Thank you again for considering this issue in a timely manner and seeking a pragmatic solution to regulation, and I'm happy to take any questions you may have.
Good afternoon. Good afternoon, Chair Wilson, members of the committee. For the record, my name is Kyle George. I'm National Political Director for EARN, one of the largest providers of EWA in the country. I'm here at the request of lobbyist Frank Boston, and as a former resident of Maryland, it's my pleasure to be here again in support of HB 1294. In a business context, we readily understand that when a business gets paid can be as important to its success as how much it gets paid. A business with significant accounts receivable may struggle to meet its financial obligations, even though it may be doing fine on paper. But families also worry about cash flow. For decades, policymakers have recognized the plight of families living paycheck to paycheck. And for decades, solutions that address the crisis have been elusive. Earned wage access does not solve the issue of how much workers are paid, but it does address the timing of when workers can access their wages that they have already legally earned. Working-class Marylanders often make difficult decisions when the month is longer than their paycheck. I know from personal experience that families sometimes have to make difficult decisions about which bills we must pay this month, which bills can be late, and if it's more effective, cost-effective to absorb and overdraft a late fee than to pay it out. And often these decisions arise because due dates arrive before pay dates. HB 1294 would enshrine safeguards that protect Maryland consumers from more expensive alternatives, such as credit card fees, overdraft fees, or late fees, by allowing them to access their own wages that are sitting just out of reach and won't arrive on time. Importantly, HB 1294 ensures that EWA is always non-recourse and that free options are always available to Marylanders. Being non-recourse, consumers will always retain the legal right to walk away from EWA providers without fear of collections or negative credit reporting. For too long, policymakers have done little more than paid lip service to this problem. So thank you to the committee for finally addressing this important need.
Good afternoon. Thank you, Delegate Ampry, for the introduction, and dear Chair Wilson, Vice Chair Crosby, and members of the committee. It is great to be with you all again. You may be very familiar with this bill. It's been over a year worth of progress. I think that we are seeing this moving in the right direction. For the record, my name is Claudia Flores, and I'm the Director of Policy at Daily Pay. Daily Pay is the leading provider of employer-integrated earned wage access. Here in the state of Maryland, we have more than 60,000 workers who rely on this service, and we partner with more than 500 employers in the state. I don't want to repeat some of the arguments that you will hear from this panel, but I do want to emphasize that, Daily Pay is in the business of allowing people to access their verified wages. People have work, they've earned their money, this is legally their money. What we are doing is providing the technology that facilitates access to their wages so that when families have to pay an electrical bill, so that when families have a flat tire and they need to make a decision about what bill they're gonna pay, they are able to access the money that they've earned rather than relying on a product that is going to ruin their credit score, that is going to lead them to endless cycle of borrowing and debt, which many Marylanders are already impacted by. So that is the goal of this technology. That is why the bill has very robust consumer protections that would codify into practice what many of responsible providers of earned wage access services are doing. I do want to, we've heard what it is in HB 1294, so I want to be redundant, but you may hear some numbers today. I just want to remind you that numbers can be very impersonal. I'm going to read you very quickly stories from Marylanders who use our product. One of our users, as long as I work, I have never been broke or borrowed money since I have been using Daily Pay. I don't have to tell everyone my life story to pay my bills or food. I love that I have my money available to me. I absolutely love the fact that you keep me up to date on my day-to-day earnings. I urge a favorable report, and thank you for your time and leadership on this issue.
Good afternoon. My name is Mark Salters, and I'm a public policy manager at PayActive, and I want to start by thanking Chair Wilson for his work on this issue the past year and his dedicated leadership on the problem. PayActive is a leading employer-integrated earned wage access service that allows employees to access their own already earned wages prior to payday. Employers choose to offer PayActive services as a benefit to their employees. We integrate directly into the employer's time and attendance system and verify wages from this data. We are proud to be a public benefit corporation and certified B Corp, and currently partner with over 800 Maryland employers and offer our services to 10,000 employees. As we have discussed with this committee before, EWA enables Maryland workers to access their own already earned wages to handle unexpected expenses between paychecks. This empowers workers to make sound financial decisions and avoid high-cost debt products like payday loans, credit card debt, and late fees. We are proud to support HB 1294. This bill would enact some of the strongest consumer protections in the country that we have seen so far, including a mandatory free option, ensuring all transactions are non-recourse, prohibiting the use of credit scores or credit reporting, and implementing a first-in-the-nation fee cap on all transactions. Thank you for your leadership on this issue, and we kindly ask for a favorable report.
Oh, yeah. Oh.
Greg McGreevy.
Oh, yeah. Yeah. Somebody wants to hop up? Yep.
Thank you.
Thank you.
Cheers. Sorry. Good afternoon, Chair Wilson, Vice Chair Crosby, members of the committee.
My name is Greg McGreevy. I'm here today in my capacity as the head of legal for Bridget, which is a financial wellness company that offers direct-to-consumer earned wage access to over 130,000 customers in the state of Maryland at an average of $75 per transaction. Earned wage access is a financial lifeline that many Maryland residents rely on, as well as our customers who self-report 83% that they feel less financially stressed, and 72% reporting that they are able to perform better at work when they utilize our platform. We appreciate the efforts to create a robust framework for earned wage access in Maryland. We believe HB 1294 establishes consumer protections, a licensing requirement for providers, as well as a first-in-nation fee cap for delivery fees that creates a robust regulatory framework for the product in the state. Unlike traditional credit, earned wage access does not charge interest or late fees. It doesn't require credit checks or report to credit bureaus. It's non-recourse, meaning it does not have to be repaid with fear of collections or negative credit reporting. It allows for flexible repayment dates should a customer need more time with no penalty, no questions asked. Bridget offers EWA as a standalone product, but also offers a low flat fee of $1.99 for expedited transfers. We also offer a subscription-based suite of services that includes a robust package of things such as identity theft protection, credit monitoring, 0% APR credit builder loans, as well as budgeting tools that help our customers on their path to financial independence. This subscription is completely optional and can be canceled at any time, and there's no requirement to subscribe to utilize our services. Bridget is requesting a technical amendment to ensure that the per-transaction fee cap applies to the expedited delivery fees and not the optional non-EWA related services that were just described. And we ask for your support on that amendment. Thank you.
We have it. Thank you, Mr. Chairman. Delegate Ambry.
Yes.
You said a whole mouthful.
Yes, ma'am.
Okay, and I, can you, for me?
Yeah.
I mean, all these are smart people on that side of the room. For me, can you break it down just a little bit more in lame term that? Commercial law, comma, credit regulation. Are you trying to regulate credit? Earn some wages, access, credit modification. What is this bill trying to do?
So what thank you, Delegate Turner. So what the bill does is it simply just ensures that there's a model of earned wage access. So I'll give you, it's better to work with an example.
Okay.
So let's say I'm a working single dad. I got a birthday party Saturday for my son. It's gonna cost about $250 for the party.
Okay.
I gotta borrow some money. My car breaks down. I need $200 now to make the week work. So what these models offer is you can go online and you can borrow this $200 just for that week. Okay. And you can pay them back the next week. So the way it works is if I need that money right now, I have to pay a little, like a $3 or $4 fee to borrow that money. And that's how the bill works. We're just regulating the people that lend that money out to people.
Okay.
That whenever what the bill essentially does, it lays out the framework and rules to make sure that these companies are not taking advantage of people when they need that little bit of money to get through, to make ends meet that week or for 2 weeks or et cetera. So that's what the bill does, is it regulates the space to make sure that these earned wage access models are not harming people when they're trying to borrow that little bit of money to make ends meet.
And we don't have that now.
We currently don't have the proper mechanisms to regulate it, correct. So some states have a different separate model. So we're putting in some things within our commercial law code to make sure that it's properly regulated to keep consumers in Maryland safe.
Oh, okay. Thank you. You could have first time around.
We agree. He was kind of long-winded there. Delegate Frazier-Dago.
Thank you, Mr. Chairman. Just a very quick question on the tipping section.
Yes.
If you decide to do tip, are you going to get that, what we passed earlier this year, so that you know exactly where that tip is going, or is that left?
I think that would be a requirement. That was one of the things.
Yeah, the requirement is you have to know, yeah.
There'd be, just like Act Blue, I hopefully would be doing the same thing, would let us know exactly where that tip is going.
Correct.
Just like the bill we passed earlier.
Yes, sir, if it does pass the Senate.
Correct.
Thank you.
Seeing no further questions, I think that's all the table. Nope, that was a favorable amendment. We do have somebody from the AG's office, Wilson Meeks.
All right.
With Tony Salazar and Kathleen Highland for info. So you guys can all three come up.
Chairman, the Consumer Protection Division is opposed.
Yes.
She says she's favorable, so.
Oh, what was your name, ma'am? Apologize. Please go ahead and take a seat. You can go ahead.
Thank you, Mr. Chair, esteemed committee. Brianna January with Chamber of Progress in strong support of HB 1294. Chamber of Progress is a tech industry coalition advocating for the progressive future of tech and inclusive access to that future. For the interest of time, I will just thank you, Mr. Chair, for your leadership on this issue the last few sessions. We do believe that this is the balanced and appropriate approach for Maryland, and we look forward to working with the committee to move this forward for both consumers and providers. Thank you.
And now the person who's opposing the chair of the bill, Mr. Meeks. Go ahead, sir.
Thank you, Chairman. My name is Bill Meeks. I'm an Assistant Attorney General with the Consumer Protection Division of the Maryland Attorney General's Office. Maryland's consumer lending laws apply currently to EWA lenders. These laws cap the interest rates at 33%, which is a very high interest rate intended to allow lenders to make money while protecting consumers from financial abuse. The law also requires that interest rates be disclosed so that consumers can price shop for better deals. The division opposes House Bill 1294 because it seeks to remove these consumer protections. The bill allows EWA lenders to charge fees equaling interest of 240% or more. The negative financial impact on consumers can be significant. Many EWA consumers make $25,000 a year. For a typical consumer making $25,000 a year, the fees allowed under the bill could total 3% or more of the consumer's total gross income. The cost could be higher if lenders adopt practices where consumers could need to take out multiple loans to get a meaningful advance, each one with its own fees and charges. Studies have shown that EWA use increases bank overdraft defaults and also results in debt cycles where one loan is used to pay the previous loan. The bill further allows all lenders to seek tips in connection with a loan. Calling these finance charges tips is inherently deceptive. Tips are gratuities from consumers to employees for services. Here, the money goes straight to the lender for making the loan. It's a finance charge. EWA lenders have proven that they will take advantage of consumers through the tip solicitation process over the years, including by implying the tips help other consumers or are altruistic. Most consumers feel obligated to pay the tip, even if it's supposedly optional. Nor does the division believe there's a good reason for changing the law to benefit these EWA lenders. Higher interest rates are not justified. EWA loans are not risky for the lenders. They're almost always paid back. The division sees no evidence that EWA lenders cannot be profitable under Maryland's current laws. The General Assembly decided 100 years ago to prohibit usurious payday lending. It should not now change Maryland's law to allow it.
You wrapped it up? You finished? I just want to make sure you didn't rush off because of the alarm. Was that everything?
I tried to jam it all into 2 minutes. I'm happy to take questions, and I can provide as much information as I want.
I know I have a few questions, obviously, because it's my bill. One of the things I'm concerned with, and I've discussed this several times in this committee, so I know they're probably tired of hearing this, but we talk about interest rates. You said the interest rate, the cap is 33%.
Correct.
And so what is that on a $1,000 loan?
So that would be a $330 profit for a lender to give out a $1,000 loan.
Okay. And I say that because now, what about your ATM? Like if you go to the casino and you gamble and you want to get your money. Now, granted, they're not going right to my bank account, but they are, taking a credit on my bank account. And it's usually, I don't know, from $5 to $2, $2.50 at the low end for a barber shop in a black community. High end, $7.50 at a casino. How's that okay?
Well, I'm not here to tell you that exploitative ATM fees are okay.
But
what I am going to say is that,
but that's a loan, right?
The lending laws set reasonable interest rates limits.
But that goes
the ATM fee.
No,
they're not loans.
I got you.
Sorry.
So to be clear,
Yeah.
That's not a loan, even though that's not my money. It's not my bank. It's something that's going to basically go tap into my bank account on a Monday when it opens. That's how those ATMs work on a Saturday night in a casino. Sure you're aware. And I was wondering why you took an interest, and not you personally, I understand you have a job to do, but why, because this seems something that was very utilized in Maryland a lot. And I'll get into some of the other things we discussed here about, but I just didn't understand how, number one, we were interested in that. And when I just know from ATMs, and if you ever go to a barber shop, there's always an ATM in there. It's a $2.50 fee every time. And that's a takeout, and that's for $20. And they're all over the state, have been for years. And that's okay. But somebody who's like giving, and honestly, we can argue back and forth on the utility of this, but obviously there's some utility because of the people who are using it. You don't have a rationale as to why it's okay for the ATMs to charge a fee, but not this business to charge a fee?
Well, I personally don't think it's okay for ATMs to charge exploitative fees, but
Well, I
if the
hope
General
that next
Assembly
year-
wants to change those,
Well,
that
the
actually
AG
pass
can
a
also
law
put a bill
to
in.
change the ATM
The AG could also put a bill in, so please take that message back. Secondly, we talked about tips, and I think the Act Blue is very interesting because I would argue that I think there's a constitutional issue there, but I read the report saying that the AG did not think that it was a constitutional right, or it's a form of protected speech to ask for a tip. But the very mechanism that the AG uses to raise money, myself included, ask for a tip. Because I guess what I'm concerned with here is that we found a target and we're shooting at it regardless of how many other targets are in the way. Because that's Act Blue, and they ask for a tip. And that's something that at least the voting body of this group here uses. We all use it to collect for fundraising. That was a little wink and a nod to y'all. But, and I don't know what they use, but I don't, it was Act Red, Act Pink, whatever. But whatever it was but we've never targeted them before. And I feel like we're selecting winners and losers here. And that's my frustration because, especially in lines of the bill that hopefully will pass, which is there will be a tip screen, the default will be 0, and it will have to say where the tip is going. Does that still offend the AG from your perspective? If there's a tip line, but it's defaulted to 0, and it tells you where the tip is going?
It does, and it does for a couple of reasons. There's a significant difference between Act Blue or something else soliciting a donation to continue its activities, stuff that people use, and what is a finance charge in connection with offering somebody a loan, a for-profit business that has already been regulated under Maryland law. And what this House bill will do is change the law to allow all lenders to seek tips in connection with the loan. And this is problematic on a number of different levels. On one level, it's problematic in that it's not actually a tip, it's a finance charge. It is part of the interest rate. If it's disclosed as such, people register it as one thing.
How is it part of the, so go back, how is it part of the interest rate if it's a variable tip or a 0?
Well, if it's a 0, then the interest rate part of the tip would be 0. But the way that interest is defined in Maryland law, it includes all basic revenue that the lender collects in connection with offering an advance of money to a consumer, and that would include tips. And part of what the law would do is, because it doesn't require an APR disclosure or something like that, it makes it very difficult for consumers to understand what the true cost of lending is in different contexts. If you just give a tip that's $2 or $4, and the bill has this difficulty in it overall. It's very difficult for a consumer to understand what the true cost of lending is in an annualized rate, which is the typical way. That's the way that lenders are basically mandated to disclose what their finance charges are to consumers. And if you can't understand that, one, consumers may overpay. I mean, the lenders are asking for this tip process, not because it's consumer beneficial, but because they know that they can make more money by asking for a tip than just by putting a certain APR in there.
Right.
So consumers can't understand, end up overpaying, and also can't do comparative shopping. I mean, the APRs associated with a lot of these EWA products are pretty astronomical, and consumers might be easily able to go and get better products elsewhere.
So it's your understanding that consumers understand APRs, like they would understand a 33% APR on a $250 loan than they would understand a fee for $2.50. It's your understanding, you believe that math, that they, because I'm not great at math, which is why I'm a lawyer, will be able to figure that math out rather than just looking at the flat fee that's right there in front of their face. You believe that they can do the math quicker in their head than looking at that $250 fee that's looking them right in the face.
Well, I think the disclosure via an APR basically takes the math out of the equation. What you do is you see, okay, here's 10%, 15%. People ordinarily understand, hey, if I'm going to take out an auto loan and it's 20%, wow, that's very high. If I'm taking out a mortgage, 10%, whoa, that's very high. If I have a credit card, that's 50%. Oh my gosh, that's astronomical. Here we're talking about APRs of 240% on these EWA loans. If somebody saw that and they compare it to a loan in some other format, they would at least have these two data points that they could compare and choose the best product.
Versus the flat data point of this is how much it's going to cost you over the entire time of the loan, which is $250. That's fine. And also, I read in your letter that we were talking about, you basically said, in your opinion, it would be better or less expensive for the consumers to get the most expensive credit card and finance whatever purchases. So in your opinion, you'd rather our consumers use credit cards of any kind that I believe can report to your credit, can be collected, than to use something that neither reports to your credit nor can be collected. You believe that it's in the best interest of a consumer to go after a credit card merely because they see an APR, again, that 13 or that 22% APR. And you believe that it's in their best interest to do that over a flat fee.
Well, the point there was that the bill as written has really astronomical interest rates in it. And those interest rates are far beyond what Maryland law right now applies. If these lenders, the EWA lenders, complied with Maryland law and provided interest rates at 33%, then there would be really no issue with them. And then consumers could price shop and figure out whether or not the credit card was better or not. The point we were trying to make is that, as written, the APRs, when you calculate them for the fees and charges in this bill, are beyond what even the most expensive credit card would be. So we're not advocating that anyone do that, but technically, if you took out, I mean, a lot of these loans, they only last a couple of days, right?
Right.
And there's no risk to the lenders because they have access to your bank accounts.
And there's no list to the buyer, though, is there?
So I'll get to that in a moment if you'd like. But the point is, if a consumer did the same thing they did with these EWA loans, took out a 10-day loan on a credit card and paid it off right away through their wages, then there'd probably be no interest charge at all. So that was that point. The recourse point, I know that the EWA lenders make a big deal out of that, but the reality is that all of the studies have shown that these products are almost always paid back. And that's because of the way that they're structured. They're structured so that consumers have to give access to the banking information where their wages are deposited to these lenders. The lenders then get first dibs on that money. They take it right out of the account. So they're almost always paid back. So the fact that there's no recourse is almost obviated by that fact.
And I guess it's just, I guess we'll just agree to disagree. And I know that in certain communities, access to credit is extraordinarily difficult. And I know from being a soldier when I was an E1 or E3, I guess, and the $630 I was earning a month, you know, sometimes when you're trying to, I don't know, do something dumb like buy a car stereo, you know, there are certain mistakes we make. And I've learned that using credit cards is the worst way. So I was very taken aback by that. I guess I understand your comparison. But I hope you would agree that in certain communities, especially in the poor communities and people of color, access to credit cards are also not very accessible. You'd agree, right?
That may be so, Chairman.
I mean, this is your subject matter. You're here testifying.
I've not personally looked at the studies and stuff like that, so I'll agree with you.
I mean, my concern is that when you don't have access to traditional lines of credit and you cut all this stuff off because we're arguing what I would argue literally is math. Something because there's an APR that you understand that I specifically don't. I think in another hearing, I totally got it wrong, versus a flat fee that I know everyone can understand. I feel like it's almost like we're I don't know, I'm not really sure where we're at. I feel like we're defending Hitler's mustache here. We're getting caught on a very small detail when it's a much larger issue. But I appreciate the work you've done. I think we do have a few questions. Delegate Ambrey.
Yeah, just back to the credit card example, for someone where what they need the money for, a credit card wouldn't be usable. For instance, rent. Some things that you might need the money for don't take credit cards. You have to use funds. What would be their option for getting money then? Because a payday loan is going to be astronomical on the actual amount of money as far as the interest rates versus having a situation where in this situation you don't even have to pay a fee at all as long as you get in front of when you get it. So what's the option if the credit card is not available?
Sure, and to be clear, we're not advocating people go out and use high interest rate credit cards. So let's start at the beginning here. First, there's no evidence that the division has seen that these companies can't operate profitably under the current Maryland laws, which cap the interest rates at 33%. So that would be the preferable option, is that these companies just simply comply with Maryland law, and then they provide an affordable product to people. But I think I'm sorry, Delegate, I lost the thread there for a moment.
I'm just trying to better understand what options are available if you can't use a credit card for whatever thing you need to pay for.
I'm not sure what other options are available, but there may be other short-term loans that you can get. I mean,
you have to go to a bank for with a good credit score to get. So we can talk offline.
Thank you, Mr. Chair. I went on Act Blue. I don't think I'm going to be donating with any tips on. So your example, and I'm going to be super brief. Obviously, there's a agreement to disagree on the subject from your perspective, but the example you gave is frankly making the case that I think us who support this bill are making, and that is on the $1,000 example, what's 33%? And your answer was $330. The problem with the premise, and correct me if you think I'm wrong, is that the 33% APR is to assume that you're borrowing that money over a period of 12 months, and that is a annualized rate of interest. And so if you took a mortgage for, let's just say $100,000, not $1,000, and you were paying 33%, well, man, that'd be rough business. I mean, and so consumers generally understand APR through the lens of a mortgage. This is a completely different product, wouldn't you agree?
It's not a completely different product. It's actually just a short-term loan, and the way that interest and profits are accounted are exactly the same way. And especially in a business year where there's almost no risk to the lender of failure to repay, I would say that 33% is actually a pretty generous interest rate.
No, so a 33% mortgage rate is egregious. I'm not even sure that it exists. But what I would say to you is that 33% is, and now I'm just repeating what has already been said ad infinitum, is 33% on a loan product that's out for a week, it's irrelevant. What's that mean? Well, because what you really want to know is not what 33% of $250 is. You want to say, what's it cost me to borrow $250 for a week or two? And that's where I'm getting hung up, is because it's not the same conversation. I'll let you have the last word because I don't want to belabor it, but it feels like Groundhog Day.
No, I'm happy to address your concerns, I think. And I think that what the research and the data shows is that it's not simply a one-off product that people use once. People use these products over and over and over and over again, often with multiple providers. And therefore, every single pay period, they're taking out at least one or two of these loans. When you add all of that up, you're talking about pretty long length of period in which someone's indebted to somebody else over time.
Well, okay, so
and the results.
In fairness, if what you're saying is true and people use this regularly, then people would not use a product that is usury, right? If the interest rate was usury, if it was hurting people, they wouldn't go back to the well and do it again. They go back because it probably is effective, because it's not that terribly expensive to borrow their own money for a week. That's a different conversation than charging 33% on $250,000 over 10 years, because that's usury. That's what Maryland's law is meant to stop. Large sums of money with interest rates that are completely egregious. Not this. I'll stop.
I appreciate that, because I guess that's the point, is this is obviously something, your argument that all the people using this sounds like it's something that's useful. And our point is to protect citizens. It's not to say, well, and be pedantic because there's not a percentage behind that number that they're looking at. It really was our usury law is just to protect citizens from being taken advantage of. And I believe, at least on this side, we did not feel that they were being taken advantage of because they were accessing their money for a few days. But I guess that's all the questions we have. I don't see any other opposition on this. Thank you very much, sir. I appreciate it.
Thank you.
Next bill, please. Delegate Chi, you have a panel? Hopefully this is not a long bill.
Chair Wilson, did you want the information?
I apologize. We didn't really need information because we've been through this a few times. But so unless you guys, do you have information that's new, exciting?
We presented information over the summer.
Yep.
I think if we could get the chance to.
Wow us with it. Go ahead. You're standing.
Maybe we will wow you. Thank you, Chair Wilson. Appreciate it. Chair Wilson, Vice Chair Cross. Oh. You better be good. This is going to be wonderful. I want to thank you for the ability, Tony Salazar, Commissioner of Financial Regulation. And we want to give, as I said, information. I want to thank the chair for bringing this bill to continue the discussion. We believe that a bill is important on EWA products. So that's the first point I wanted to make to the committee in terms of information. Our office is not in the business of chasing out legitimate companies from the state, and that was not our intent with this bill at all. But we do believe it's important that the products be regulated. Secondly, we found that companies need to enhance consumer disclosures, and that's what the bill does, so we appreciate that. Third, only 2 companies solicited tips that we know of, because what we did is we initiated a market inquiry where we looked at 21 companies in the state, and we found that they extracted millions of dollars in tips from their workers, and none of which was given to their employees, to our knowledge. So setting the tip amount to 0, we believe, will not impact the market. That being said, our findings and the future trends of this industry lead us to believe that you could ban tips and that would not affect the industry at all, because that's not the way it's going. They're moving away from it. And fourth, we see the bill as a bit overbroad, because it exempts on page 14 and 12.11.502C providers from the provisions governing consumer loans, including all the other consumer protections, as long as they hold a consumer loan license. And that's a freedom that no other loan class has. So we'd like to point that out to the committee. You might want to consider limiting the scope a little bit there. We've submitted our written testimony, and Deputy Commissioner Highland is here maybe to talk just a little bit about some of the facts of that market inquiry, because I think it's important. So I'm happy to answer any additional questions. Hopefully that was okay.
Thank you, Chair Wilson, Vice Chair, and members of the committee. Thanks for the opportunity to speak today. My name is Kat Highland, and I'm the Deputy Commissioner at the Office of Financial Regulation. I'm here to share what we learned from our market inquiry into earned wage access products, specifically in Maryland. We surveyed 21 providers and collected data from 16 companies operating in the state. We looked at how these services work, their costs, how people repay the money, and who's using them in Maryland. These services we found are highly profitable for providers, but costly for consumers. The average cost for consumer is $76 per year, meaning Maryland workers pay nearly $80 a year just to access their own wages. Between 2019 and 2024, Marylanders made over 11 million EWA transactions, but with 345,000 users. The average transaction was $108, and many users took advances over 50 times. The APR equivalent fee was, the average was 101% across providers, often higher than payday loans. Many users paid extra fees for faster access, and as Tony said, only 2 collected tips, with 1 collecting a combined $23.5 million in tips and fees. EWA use is highest among low to moderate income workers, earning $25,000 to $50,000 annually, and peaks at age 40. However, older users over 65 and low income consumers experience the highest default rates. Many users rely on EWA repeatedly, with 16% of one provider's users cashing out 6 or more times in a 2-week period, showing a cycle of financial strain. Repayment is a major concern. Nearly 10,000 transactions were declined due to insufficient funds, and over 40,500 payment extensions were granted to 17,000 workers, showing many couldn't afford repayment. We found transparency issues. One company does report to credit bureaus, and the rest don't, meaning consumers don't build credit, but could still face financial consequences. 4 reported doing collections, a combo of internal and external, and the rest did not report. Finally, it's highest in Black and Hispanic communities, areas with few college graduates, and areas with lower financial literacy. Thank you.
Thank you very much. Are there any questions for these panelists? Seeing none. Oh, Delegate Adams.
All right, just real quick, the statistics that you were sharing, the average user over a 12-month period spends how much in fees? Was it $67?
$76.
$76, okay. Against how much that they borrow over a 12-month period?
I don't have that itemized by user
That's
because
important.
they tend, well, we do have the data on
If you're going to
it.
come to me and, or if you're going to come to the committee
Yeah.
and say that the average user spends $76 per year on this, my question is, how much are they borrowing in a 12-month period?
It varies.
Your numbers are relevant.
The average transaction is $108.
That's not, if you're able to say in the committee that $76 is what is being spent by a user per year on cash advance, you should also be able to tell us how much they're borrowing over a 12-month period.
Yeah, we have it disaggregated by user. It's just not uniform. So we can give you the average, or we can give you the mode, or the median.
I would need it uniform to be able to consume the data.
Sure, we can get that for you.
Thank
It's
you
just
very
going to be a
much.
long spreadsheet.
Okay.
Okay, thank you. Thank you. No further questions. Next, we'll go to Delegate Chi.
Okay, yes, could I have economic action and EPIC, and the consumer order, thank you, and the Tech Institute, yes, please, thank you. And then we have one virtual favorable as well. Thank you so much. All right. Okay. Good afternoon, Mr. Chair and esteemed members of ECM. I am Delegate Lily Chi, here to present HB 1331.
Real quick, sorry, Delegate Chi. Hey, can we just keep it down in the back? Thank you.
Okay, I'm Delegate Lily Chi, here to present HB 1331, Consumer Protection as it relates to artificial intelligence. As someone who prides myself for being a champion for economic development and have successfully sponsored numerous pieces of legislation to grow our Maryland's tech-driven economy and industries, I understand the need to balance innovation and economic competitiveness with safety and individual rights. Unlike traditional computer systems, AI systems, which are also known as automated decision systems, are trained to learn and adapt to make complex decisions without explicit instructions every step of the way. In recent years, AI systems have made enormous progress and are increasingly used to make complex judgment calls on many aspects of human life, such as hiring, housing, lending, insurance, and public benefits like Medicaid. While it can be very powerful as a tool, it can also be riddled with biases on data input and how the systems are trained to do human-like thinking and decision-making. There is strong and growing evidence that left unchecked, they can perpetuate and even compound certain discriminatory patterns. For example, Michigan's integrated data automated system wrongly flagged about 40,000 people as committing unemployment fraud, which resulted in fines, denied benefits, and even bankruptcy. As an AI tool developed by a tech giant, which is a household name, to evaluate resumes for software developer positions was found to systemically discriminate against the female applicants because it was trained on the data set primarily consisting of male resumes. So these examples show that as AI continues to shape every aspect of our life, we need a basic regulatory framework in place. HB 1331 essentially says that if you are a developer, excuse me, could I please not have the noise at the back? Thank you. HB 1331 essentially says that if you are a developer or deployer/user of high-risk AI systems, then you have a duty to protect consumers from known or reasonably foreseeable risks of algorithmic discrimination. It requires developers and users of high-risk AI systems, which is defined as a system that can impact someone's rights and safety, to adopt accountability and the transparency measures. Specifically, the bill requires developers that offer to sell a high-risk AI system to disclose to the purchaser standardized disclosure documents that include basics like the purpose, intended uses, benefits, and data used to train the system, and the measures taken to mitigate the risks, and to provide the user information necessary to conduct its own impact assessments, and to publish on its website standardized information. And for users or deployers, the bill requires them to implement a risk assessment policy to govern the use of such high-risk AI systems, and conduct impact assessments annually, and offer, not only tell the consumers that they are using such AI systems to make certain decisions in their business, but also to allow consumers an opportunity to correct information input if the consumers feel like they have been wrongly judged on certain decisions that impact them, that are life-altering, important decisions. To be clear, this bill does not require disclosure of proprietary information such as source code, training data, or trade secrets. Many developers today already share the kind of information required in this law on their website and in their public communication with stakeholders, including their clients. This bill also exempts vast majority of Maryland's small businesses with 50 or fewer employees, which is an important carve-out that many could argue is too broad, too big of an exception. You will hear from some testimonies, opposing testimonies, that we already have laws in place against the discrimination, so we don't need this bill. The truth is, existing laws cannot be effective if we don't even know how and to what extent AI systems are being used to perform certain functions at the back end due to the lack of transparency requirements and disclosure requirements. Right now, Marylanders simply don't have a way of knowing because we don't have any legislation in place. For the purpose of this bill, I had a roundtable with tech leaders and was assured of the need to have a strong and a clear regulatory framework. Among the feedback I got was to have fewer exceptions for greater consistency and clarity. As written, the bill focuses exclusively on consumer protection without mentioning workers, which is an important community that also needs to be protected, and you will hear from testimonies later. I agree with some of the favorable with amendment testimony that this bill should be strengthened in several ways to achieve its intended purposes. But I don't believe consumer-facing industries like insurance or banking, which deal with high-risk AIs that can have life-altering consequences on consumers, should be exempt from this bill. And I believe they're asking for exemptions. And similarly, I would push back against the argument that because we already have general consumer protection and civil rights laws, we don't need to have industry-specific laws to protect consumers. To be fair, the existence of Economic Matters Committee is to provide regulatory and legislative oversight on numerous industries. That's exactly what we do. So AI and tech in general is a fast-evolving industry that we need to regulate to protect consumers and communities. We have a responsibility to be proactive, and with that, I urge a favorable report and turn to my panel. Would you like to go first?
Sure.
Good afternoon. Thank you for the opportunity to be here today and to speak. My name is Crystal Wise. I'm the Innovation Policy and Program Manager for the AFL-CIO Tech Institute. I'm also a Maryland resident. The Tech Institute is a nonpartisan organization that's affiliated with the AFL-CIO, which is a federation of 63 unions, and we represent over 15 million workers. The Tech Institute specifically is focused on making sure that technology works for workers and making sure that workers have a voice in the development, in the deployment, and in the governance of technological developments, including AI. The reality is that we know that AI industry is rapidly transforming workplaces. It's leaving workers unprotected from surveillance, from privacy invasions, from discrimination, and it can be used to erode existing labor rights. These immediate threats that are being experienced right now by Marylanders of unregulated AI are very real in the lives of everyday workers. And so we know that we need strong legislation to approach this. And labor has a framework for AI governance. We believe that there needs to be strong protections for both consumers and workers, and we appreciate Delegate Chi's acknowledgement of that it's really important that this bill explicitly includes workers and all aspects of accessing work and job quality. We know that transparency is so important so that end users know when and how companies are using AI to make key decisions about them, whether it's their employment, whether it's their access to financing, whether it's their access to education. There has to be strong, robust accountability and enforcement, and it's important that there's mandatory consultation for workers and their unions in the process of AI governance. So we're really grateful for the inclusion of some of these key principles in HB 1331. As you'll see in the written testimony, we've submitted alongside State Fed President Donna Edwards a number of amendments that would strengthen things for workers and consumers and close some of the loopholes. So we support with the inclusion of those amendments.
Good afternoon, Mr. Chair and members of the committee. Thank you for the opportunity to speak today, and thank you to Delegate Chi for bringing this bill forward. My name is Zoe Gallagher, and I'm the Policy Associate with Economic Action Maryland Fund. We're an advocacy and direct service organization focused on economic justice and consumer protection. We strongly support this bill because it puts necessary guardrails in place to prevent AI-driven discrimination in Maryland, and we also support the friendly amendments proposed by the Attorney General's office to make the bill as strong as possible. AI is already becoming a part of our everyday lives, and while it has incredible potential, we're also seeing real harm, especially for vulnerable communities. Biases in AI can come from the data used to train it, leading to unfair outcomes. For example, one study showed that automated tenant screening systems disproportionately block single-mother renters from securing housing. And according to the same study, 37% of landlords reported following what the screening software says without additional discretion, because people blindly trust AI. They trust these products because there isn't this disclosure. Without this, AI in critical areas like housing, healthcare, and employment can reinforce discrimination instead of reducing it. Addressing AI bias isn't something that we can just hope technology will fix on its own. It requires real transparency and accountability. We're not here to slow down innovation, but new technology shouldn't come at the expense of fairness and civil rights. As AI becomes more common in high-stakes decisions, we need safeguards to make sure it's working for everyone, not just those who design it. HB 1331 takes a proactive approach by requiring AI developers to disclose potential risks and deployers to put real risk management policies in place. It ensures that AI decision-making remains transparent and accountable. The bill also sets clear standards to protect people from unauthorized digital replicas of their voice and likeness. To be clear, this is a bill about disclosure and transparency. This legislation is about making sure that AI works for Marylanders, not against them. I urge the committee to issue a favorable report on HB 1331, and thank you for your time.
Thank you, Mr. Vice Chair and members of the committee. My name is Kara Williams, and I'm an attorney at the Electronic Privacy Information Center, or EPIC. EPIC is an independent nonprofit founded 30 years ago to secure the fundamental right to privacy in the digital age. I'm here today to support HB 1331 and to suggest a few amendments necessary to ensure this bill meets its goal of protecting Maryland residents. This bill tackles an urgent problem. Companies across sectors use AI systems every day to make important decisions about our lives. Whether we get a job or admission into a university, if we qualify for a mortgage or a loan, how much we pay for rent or utilities, and whether we can access life-saving health care or government benefits. Despite their influence over these significant decisions, the inner workings of high-risk AI systems are hidden from public view. Right now, Maryland residents have no way to know whether companies use AI in making these decisions about them or to access any information about how these systems work. And unfortunately, the truth is that AI systems often do not work. The systems that are used in making consequential decisions about people's lives are known to produce inaccurate and discriminatory results. For example, a Maryland man with top security clearance was denied an apartment after an algorithm confused him with another man who was on a federal watch list and happens to have a similar name. This is not a one-off example. There are similar stories about the errors and bias from AI systems turning people's lives upside down in every decision setting that this bill would cover. This bill would be a start to preventing these systems from harming more Marylanders. While EPIC suggested some amendments in our written testimony to strengthen HB 1331, this bill is a welcome step toward mitigating the risks of using AI in making key decisions about Marylanders' lives. These risks are real, and people are being harmed every day by the unregulated use of this technology. Passing legislation to rein in the use of this technology and ensure that they are safe and fair cannot wait. Thank you.
Thank you. Thank you, Vice Chair Crosby, members of the committee, for the opportunity to address the bill, and thank you to Delegate Gee for bringing this important bill. My name is Franz Schneiderman. I work with Consumer Auto Maryland. We're a nonprofit that works for transparency and fairness for Maryland drivers and Maryland consumers. We're in strong support of the bill because we think it provides some important safeguards and equally important as some important disclosures that will clarify to consumers when and how these AI systems are being used and offer some protection against the kind of bias they contain. I mean, ironically, part of the appeal of these systems, I think, is that they're free from certain kinds of existing human bias, but guidance from the federal government, federal agencies suggests they also introduce bias in all kinds of ways, particularly through the use of data sets based on historical experience. They reflect that historical experience, and when used, say, to make financial decisions about credit, mortgages, et cetera, it's easy to see how using past experience would, tend to favor those who've been more likely to benefit from past arrangements, or in getting access to credit and mortgages, for instance, people who are more likely to be whiter and maler and more high income as opposed to more vulnerable groups. The bill has, importantly, mandates a duty of care both for the developers and deployers of the technology to make sure they work to address known and foreseeable sources of bias. It also has disclosure requirements that requires the developers to disclose information to the users of the technology that enable them to assess possible bias, requires users of the technology to report instances of bias they become aware of, both to consumers and to the Attorney General's office. I mean, I agree with the other panel members that as a consumer advocate, I'd love to see certain amendments to strengthen it, but I think it's a great step toward protection of consumers on these issues. Hope you'll give it a favorable report. Thank you.
Thank you. Delegate Gee, I know that we have talked about this bill. I just want to kind of set the stage for a potential scenario that could happen if the federal government were to just eliminate certain government reviews, let's just say for VA benefits, and were to privatize that, and that company used AI. This would simply provide a review so that there would be a human on the back end of that before benefits were likely denied, correct?
Yes.
Okay.
It will provide some safeguards.
Okay, Delegate Queen.
Thank you, Mr. Chairman. Thank you, sponsor. Just have a couple questions, and I may have missed it. Sorry, I walked out on your testimony. Someone mentioned this is a national issue, so this is not new that states have to deal with AI. We know about some of their problems with inaccuracies. So is this modeled after a particular state? Okay, and which states were they?
It's modeled after the Colorado law, and there are several other states that have enacted similar laws, more or less the same, to provide disclosure and transparency requirements.
Okay, so we do have some precedent of what people have done. Okay.
Yes.
And so the idea of the reviews, how is that done? Because I mean, I know we talk about AI a lot, but AI was used a lot when I worked with Fannie Mae for mortgages. We kind of did a thing about, we were using early versions of that in determining people having mortgages. And so how does the review process work? I mean, is it when it's way out of scale and you see that happening and then you call in, or a person can request a review? How is that kind of handled?
It's both. The deployer is consumer facing, has the responsibility to reveal to the consumers that they do use AI. And the consumers also have an opportunity to raise issues if I feel as a consumer that I have been wrongly judged in this case and been denied the policies or denied access to certain benefits. I have the right to ask what kind of data sets you use that could be outdated or inaccurate or mixed up with someone else or whatever, right? To correct that information, not the outcome, but the input.
Okay, thanks.
Yeah.
Okay. And Delegate, correct me if I'm wrong, and I should have done this before, but you have a virtual?
Yes, one virtual favorable as well.
Okay. He or she's name?
I think Center for Democracy and Technology.
Matt, sure. Yep.
Yeah.
Is Matt in? Sure. Okay, we'll go to him, and then we can, if there's no other questions, we can let the panel go. Mr. Sure, are you there? No? Oh, he is, okay. Mr. Scher, are you there?
Yes, I apologize.
No, you're good. Go ahead and turn on, all right, got your camera.
My video is, there we go.
I just need to see you before you can start.
Okay,
Yep, there
can
you
you
go.
see me?
Yep, something straight out of Potter. Go ahead, sir.
All right.
Go ahead, sir, you can begin.
No problem. All right. Chair Wilson, members of the committee, thank you. I lead the Workers' Rights Project at the Center for Democracy and Technology. I want to thank Delegate Chi for her work on this bill. Oh, no.
Oh my God, this is so funny.
Sir, you're still there, just keep going. Sir, you all right over there? Where are you?
Oh my gosh, this is hilarious.
All right, hey, sir, I'm going to give you a minute to collect yourself. Just keep going.
There seems to be a very long lag between when I'm speaking and when you're hearing me.
Well, I would turn off the YouTube and stop listening to us, and then just go ahead and start your testimony. All right, hey, sir. Been on a lot of awkward dates. This is topping them.
AI not working. Oh, Lord, this is hilarious. Oh, my God.
Oh, well, this is why we need regulations.
Okay,
All right, sir.
start over. I apologize. I think that I'm in good shape. I'm very sorry.
I don't know that you are, but you can go ahead and just start. Just give your testimony, please. I promise I'm listening.
All right. Thank you, Delegate Chief, for your work on this bill. HB 1331 attacks the growing problem of companies using hidden algorithms to make key decisions that affect all our lives. I'll focus on three specific problems with AI decision systems. First, a lot of them simply don't work. Because they can be based on poorly compiled or irrelevant data and look for what's typical rather than what's good, untold numbers of Marylanders are losing out on jobs, housing, healthcare, and other benefits due to algorithms that rely on information that may be inaccurate or are frankly even snake oil. Second, these tools might break the law, including civil rights, labor, and consumer protection laws. All that's possible because of the third issue. Many, if not most people subjected to these tools have no idea that they exist, much less what data they're using or how they're affecting these life-altering decisions. HB 1331 would address these increasingly prevalent issues by providing some key transparency and guardrails when companies incorporate AI into crucial decisions. Individuals would have a right to basic information about such AI-driven decisions. Companies would have to test their systems for legal compliance, and consumers and workers would receive a right to review. However, there are some exceptions and definitions in the bill that companies could use as loopholes to avoid the law's key provisions. Most notably, the bill covers systems that are a substantial factor in a decision but doesn't define what a substantial factor is. Companies have almost completely ignored New York City's 2021 AI and hiring ordinance, in large part because they exploited a similar definition. To avoid that same fate, the substantial factor requirement should either be eliminated or defined to cover all systems that influence key decisions about workers and consumers. I've submitted written testimony to the committee expanding on these points. Thank you, and I apologize for my technical difficulties.
It's all right, we did it. Okay, seeing no questions.
Thank you.
That concludes this panel. Next, we have favorable with amendment, Donna Edwards, Elizabeth Bobo.
Not here yet.
She's not here, okay. Elizabeth, are you, yep, go ahead. You can start when ready.
Good afternoon, Vice Chair Crosby, members of the committee. My name is Elizabeth Bobo. I'm the Legislative Director at the Maryland State and DC AFL-CIO. I won't belabor you with repeating the things that have already been said, as we are in alignment with the other panelists that were up here. I just want to underscore just how important this bill is. Just to give slight context, right now, there are a lack of regulations at the federal level around artificial intelligence, which means that the responsibility falls on the states to ensure that strong protections and strong regulations are around the use of AI and the development and deployment of AI. Coming from me and my generation I would like to speak for. This is especially important since we are in a day and age where AI is no longer a thought in the future, but it is now here affecting our everyday lives. It affects everyone in the state, young, old, you know, AI obviously discriminates, can discriminate, but the people that will be affected by AI is going to affect and impact everyone. So making sure that we enact strong legislation with strong protections around AI is crucial to our future and the future of our workforce and future of our state. So thank you.
Thank you. Seeing no questions, that concludes the favorable with amendments. Next, we will go to the unfavorable. I have Grayson Wiggins, Brianna January, and then we have 2 virtual.
Good afternoon, Committee. Brianna January with Chamber of Progress, again, this time in respectful opposition to HB 1331. Committee, to be clear, Chamber of Progress strongly supports strengthening anti-bias measures, whether decisions are made by humans or by algorithms. However, we do not believe that this omnibus regulatory approach of HB 1331 is the appropriate one for Maryland. As a born and bred Marylander myself, I'm very proud that our state has some of the strongest civil rights protections in the country, though we could still do better. Chamber of Progress agrees that protections should extend to algorithmic decision-making, and they do already likely do so. A better approach, in our opinion, would be to take stock of our current laws sector by sector, and if there is an algorithmic loophole, let's work to close that. After all, the ways that AI is used and potential bias in education are different than those in employment, and again, different than those in housing. The omnibus approach of HB 1331 also poses a real risk to businesses wanting to develop AI in Maryland, especially small and minority-owned businesses. And we know that that's not the intention of the bill sponsor or of this body, but it would also go against the Governor's New Decade Act that looks to bring these exact businesses into the state. In fact, we at Chamber of Progress are estimating compliance costs for this bill to be about $285 million for innovators. Lastly, I would like to address Delegate Queen's question earlier of what other states have similar regulatory frameworks. The only 2 that have passed bills like this are Colorado this summer, and by the fall they reconvened to rework the bill because they realized that it was not the appropriate approach, and then Virginia just 2 weeks ago, and the governor is currently weighing its financial impact and on economic development for the Commonwealth there. So let's get this right. Let's work together. This just simply is not the right approach. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. Appreciate the sponsor's intent. We sent this to our members, and we got a long list of questions and concerns back, that anything from definitions to potential for liability, joint liability, the way the bill is drafted. That's on page 4. Disclosure requirements, both from the deployer to the developer, or the developer to the deployer, and the deployer to the consumer. The content included in those disclosure requirements, potential liability that stems from that, how it impacts consumers, or excuse me, the impact assessments, the timing of the assessments and the content of the assessments, the potential for what seems to be maybe a private right of action in some sense on page 13, line 23. And as you just heard, my understanding is that other states, like Colorado's law did pass, but it has not technically been implemented yet, and they are going back and making changes. You heard about Virginia. Just last week, Connecticut's governor publicly asked the Senate not to move this bill for fear of unintentionally stifling innovation. And so we would be happy to continue to work on this issue. We would be happy to continue to work with the sponsor. We did support the Chairman Wilson's work group bill, House Bill 956. And I would just note that the issues I ran through very quickly are not comprehensive of what we received from our members. There is a very long list of questions and concerns. But again, we're happy to continue to work on that. We'd be happy to be part of a work group.
Thank you, Mr. Chair. I appreciate the testimony. So to Ms. January, I am looking at the testimony from our Office of the Attorney General that says existing law does not address the responsibility of developers or even in some cases deployers for the discriminatory harms the artificial intelligence systems they design and deploy can cause. So I don't know if you are aware of that opinion from the AG's office in your opposition to that, in arguing that this would, one, stifling it, and two, also, we should go industry by industry. As you and I both know, the chair himself introduced a study, a work group bill, and I think these two things can work in tandem, right? The purpose of the work group is to work more in granular ways, to work with different industry representatives to understand how artificial intelligence can apply in different scenarios, right? But this sets a very broad general framework to say if you are using or deploying high-risk AI systems that have life-changing consequences for consumers, then you need to at least tell people that you are using it, okay? So that's all it does. I want to make sure we're on the same page.
Thank you, Delegate. Respectfully, we strongly believe that it does much more than what you've just outlined. I am aware of the AG's opinion. I'd like to note that in Connecticut, the Attorney General actually had the opposite opinion, that their law probably does already cover, and I know that our laws are stronger than even Connecticut's. Simply put, Maryland law, if you are discriminated against in housing decisions, in employment decisions, you can bring a case, right? So whether that's because a person made that decision or an algorithm was used because a person decided to use the algorithm to make the decision, we believe that it would be covered. When it comes to your point on having the task force to look at sector by sector, respectfully, we believe that that's a lot like driving the plane while you're building it. We shouldn't have overbroad regulations while we're still figuring out what those regulations should be. We should look at sector by sector. What do Maryland's education civil rights laws look like? Is there a way that for some reason an algorithm could find a loophole to discriminate? And if so, let's close it in the education code instead of having a broad approach that, to be frank, we've heard from members that are very tiny AI innovators, and they just won't be able to work in Maryland, whereas the larger folks, like our partners like Amazon and Apple and Google, they might be able to comply, but you're going to price out a ton of innovators in the state.
Well, we can agree to disagree about how it might hurt small businesses, because as I said in my testimony, this bill, and some don't even like that, for that matter, carves out any companies with under 50 employees, which is vast majority of tech businesses in the state of Maryland. I don't know if you noticed that, but, we can discuss that offline.
I'd be happy to, Delegate.
Okay, we have two virtual, or both in the waiting room. All right, first we will go to Donald Maurice. Oh, never mind. All right, you're both here. Donald, go ahead. You can start, sir.
Thank you, Chairperson and respected members of the committee. My name is Don Maurice. I'm outside counsel of the Receivables Management Association International. It's a trade association of over 600 financial services companies, banks, non-bank lenders, and the industries that support them. We oppose HB 1331. Its purpose is clearly needed. However, the financial services industry is a heavily regulated industry. This bill would add a further layer over 4 existing federal laws: Graham-Leach-Bliley, the Equal Credit Opportunity Act, the Fair Credit Reporting Act, and the FTC Safeguards Rule, which is a data privacy regulation. These rules require disclosures to consumers when AI is being used, particularly as far back as 2022. The Consumer Financial Protection Bureau issued guidance saying that if AI or algorithms are used in credit denials or for credit evaluations, then that has to be disclosed. These laws also require disclosures. So this law, HB 1331, if it was to become law, would have another layer of disclosures. Colorado is the only state that has experience with this. And what happened? They had a task force, and it just issued a report last month. There's a lot of confusion in Colorado. There is a lot of disagreement about the meaning. I say let's work out what each sector needs, because the financial services sector is not a pet store. We have a differing layer of regulation. We appreciate your time. I'm available for any questions.
Thank you. Margaret Durkin.
Good afternoon, Vice Chair Crosby and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director with TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on House Bill 1331. TechNet and its member companies are committed to the responsible use and development of artificial intelligence. We were pleased to support the chair's work group on artificial intelligence bill, House Bill 956, a few weeks ago, and we believe that that's the crucial first step for exploring the very complex issue that is artificial intelligence. You'll see my full commentary in my written remarks, but in terms of my verbal remarks, I will speak on some high-level concerns that we have with House Bill 1331 as drafted. To summarize, we are requesting some changes to the current definitions. We're also concerned about the private right of action in the bill. We believe that any enforcement should rest solely with the Attorney General. We also have some reservations about the Attorney General's discretion to adopt regulations. And while we appreciate the cure period within the bill, we would like that option to be definite and not at the of the Attorney General. Thank you for allowing me the opportunity to speak today, and I'm happy to take any questions.
Thank you. Seeing no further questions, that concludes this bill hearing. Now it's 4:35, and we can begin the bills that we all came here for today. We will go to Delegate Ampry for the next hour. We'll start with House Bill 1348.
I knew my committee loved me, but not this much for, 5 bills in one day. At least it's all in this room. I'm going to try and be as brief as possible to get through all these bills, but we'll start with one that's really near and dear to my heart. For the record, Delegate Marlon Ampry here in support of House Bill 1348, Consumer Protection Solicitation Following a Disaster. I'll just start with a quick story. So almost 2 years ago this April, there was a horrible fire right behind my house. About 5 homes were burning. My wife woke me up screaming. I looked outside and I saw my constituents outside their homes holding their belongings, holding their children, literally watching the flames still roaring. And, it was really a sad moment. I was doing my best to remain composed, call the city, make sure the services were being provided. And, at the same time, unfortunately, there were individuals who were present at that moment or just moments after soliciting services to families who had literally just watched their house go up in flames. And the reality is that some of these services that they're providing are overpriced. Some of these services they're providing it's not clear. And especially when you're in that frantic mode of just saving your children, just getting out that family photo, you're not necessarily in the right mental frame to be signing contracts and determining what services you want to get to make sure your house gets restored eventually back to its proper form. And in learning about these companies that are doing this, we want to make sure that these companies are playing fair. And the purpose of this bill is to ensure that whenever there are disasters like fires, hurricanes, floods, that there's not unfair solicitation being taken place from bad actors or actors that don't already have relationships with the families or the members of who own that home. So the purpose of this bill is essentially just to provide a framework as to how that solicitation can take place. We understand that there is a place for people to contact people who are in need for their businesses, but I think there's a time and place for when that should occur, and there should be rules and regulations as to how that happens. So what the bill would do, along with some amendments that we currently have, that we're still working on, you should have those amendments in your inbox or in your inbox shortly. But what the bill would do is it would prohibit certain solicitations where contractors cannot approach, contact, or attempt to solicit business from disaster victims within 48 hours following a disaster. This cooling off period protects victims from making rushed financial decisions under stress. Of course, if there's pre-existing relationships, or if it's actually your insurance company, or it's an adjusters, there are certain carve-outs. So we would allow those companies, of course, who are there to support and help individuals during a disaster. But certain actors that we've noticed that show up that are just a little bit, invading the space of individuals who are going through trauma. And I think that there should be some time where people have the ability to work through that. The amendments that you have before you, or that you'll have shortly, a couple of items that we've heard from other people in the industry that would incorporate emergency service providers under the Maryland Home Improvement Commission. So it would ensure that those individuals who are providing these service providers are regulated companies. Implement a right of rescission. So that would include a 5-day right of rescission period, so that if you sign a contract and you realize, oh, this isn't the best deal, or this isn't the deal I want, you can rescind that contract. Contracts will specify not to exceed amount to make sure that there's not an excessive amount of money that's spent on certain services. And other ways in which we can make sure there's other percentage amounts within your insurance policy or not to exceed. And I have a panel here who can give more details about some of the services that are being offered in these tragic moments. But with that said, I encourage a favorable report on House Bill 1348, and I guess we'll start things off with Councilman, well, I'll let the chair decide. I'm sorry. Councilwoman.
Thank you, Mr. Vice Chair, members of the committee. My name is Odette Ramos. I'm City Councilwoman from the 14th District in Baltimore City. The delegate is my constituent, and we were present at that fire that he described. We were also present together at another fire just down the street where there were 14 homes affected. And as a matter of fact, when I got there, I basically was able to catch a constituent who had just escaped the fire with her life, her husband, the dog, the kids, and she was crying hysterically, as you can imagine, watching her house burn down. And then, as I have her in my arms, there is somebody who comes up with their business card and says, hey, we can help you with making sure that the house is secured and boarded up. What? Really? She has just come out of a burning building, and someone is coming up to her saying, hey, so what we need are these companies to be regulated, which is what this bill does, to allow for the time for the homeowner to catch themselves, to be able to then, understand what their options are, contact their insurance company, and figure out what the next steps are. And that's all we're asking here. This is also a companion to some work that I'm doing in the Baltimore City Council to establish a set fire scene so that those kinds of companies cannot come within the fire scene during that time. And that way, again, it gives that homeowner and that resident the time to be able to figure out what to do. This bill before you also allows for the opportunity for one of those contracts, if they happen to sign in duress, to say, no, I don't actually want to go through this, and I'm going to work with my insurance company. So we request a favorable report with amendments on this for all of the reasons I extend above. And thank you so much for all you do for all Marylanders across the state. Thank you. Thank you, Mr. Chair.
Okay. Good afternoon. I'm Neil Kahn, General Counsel and Principal at Goodman Gable Gould, one of the largest public insurance adjusting firms in the U.S. GGG has been Maryland-based and owned since 1941. I have not been there that long. Law sites have really often, as you've heard, become the wild, wild west. Property owners are literally overwhelmed by various contractors before the professionals, often to the point of physical intimidation. Mind you, this is as their home or business has just experienced a significant casualty. Never are people more vulnerable. I will tell you that I'm not here to demonize emergency contractors. They are a very, very necessary part of the process, and what they do has to happen quickly. There's board up, there's water damage, there's security, and some of the waiting periods really need to be discussed. But currently, the only people at the site who are not currently regulated under Maryland law are emergency contractors. These are firms that do board up, dry out, fencing, security, and other required mitigation efforts required for both safety and under the terms of an individual's insurance policy. The contracts that can be used by these emergency contractors, and not all, just some, can tie up a property owner and authorize the emergency contractor perform basically unlimited services at their own discretion, whether necessary or covered by insurance. HB 1348, as the delegate is alluding to, the amendments will go a long way to remedying what is currently a free-for-all by mandating that emergency contractors be subject to the licensing, bonding, and regulatory framework of the MHIC. As public adjusters handling claims for Maryland homeowners for decades, we're 100% in favor of HB 1348 as amended, and applaud Delegate Amprey's efforts to protect Maryland homeowners after casualty by seeking to regulate emergency contractors.
Good afternoon. My name is Nancy Egan. I'm with the American Property Casualty Insurance Association. We write approximately 71.4% of the total property casualty insurance here in the state of Maryland. I'd like to thank Delegate Amprey for putting this bill in. It seems funny that over the interim, APCIA had been working on a bill called the NCOIL Storm Chaser model, which is similar to the legislation that he has put forth today. And we look forward to working with the delegate. It's not all contractors where we're seeing this type of issue, but we see that often after hurricanes, especially roofer contractors promising new roofs, promising to get the deductible back. And so any type of cooling off period, I think, is very important for the consumer, and it protects all of us when we're all facing these types of crises. And with that, we hope a favorable report. Thank you.
Go ahead, sir. Go ahead.
Hi, my name is Andy Emrine. I'm the CEO of Thomasville Restoration, here today in support of House Bill 1348 with the amendments that have been proposed. I think these are the necessary steps that need to be taken to better regulate, the companies and contractors that are operating in this space. At Thomasville, we take a great deal of pride in terms of the way that we, treat customers, handle those tough situations with a lot of compassion. But yeah, not everybody holds themselves to those same standards. And so I think, regulating this under the Maryland Home Improvement Commission is a really big step forward. That way everybody has to be a license and it'll be governed and regulated there. And then also the 5-day right of rescission, so that people have an opportunity to kind of rethink. And then also the not to exceed piece of the amendment is huge, right? Because what we don't want is to find out on the other side of the emergency board up and TARP up, water mitigation, that we don't have enough money left in their policy coverage to actually help put their home and life back together. And at Thomasville, we've come across that far too often, where too much money is eaten up on the front end, right, on the disaster mitigation that actually wasn't even necessary, right? So by putting in a do not exceed, right, line and actually having to write in that amount in the field and having the homeowner or property owner actually initial it, at least there's going to be some controls around it. Our typical board up and tarp up at Thomasville for events like these are somewhere between $1,000 to $2,500. And we've heard of people waking up on the other side of this having bills in the neighborhood of $20,000, $35,000, just to give you some perspective. So thank you very much, Delegate Ampray, and we are in favor of this bill with the amendments.
Thank you. It actually reminds me a lot, or at least when I was thinking of it, is the company Stormpar out of Twister. If you've ever seen the movie with Glenn Powell, like they're the ones who basically show up after a Twister rips through a town and offers all these crazy lowball prices for the homes. It immediately went to that. So, Delegate Boffo.
Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill. I find it pretty interesting just because I haven't heard a lot about this issue. Councilwoman, thank you for the work you're doing in Baltimore. I think that zone perimeter probably will be really effective. I think your name is Neil, if I wrote that down correctly. I'm just out of curiosity, what did some of these agreements actually end up looking like that folks are signing? I mean, what exactly are they?
Well, our firm are public adjusters, and we're hired to handle the claim for the insured. There's no one size that fits all. It gives authorization. Often, sometimes it'll say to the extent covered by insurance, but to the extent it doesn't, that can cause problems. But to the contractor side, sometimes they don't know the insurance policy. It's just burned up. No one has it in front of them. These are not regular commercial settings. So the devil is always in the details, but I do believe that once a regulatory framework is set up, then those kind of issues, I know that our contracts are highly regulated by the Maryland Insurance Administration. They have to be approved. They are very, very specific, and that's true in the dozens of states we practice in. And my guess is somewhere along the line, that's where this will end up, although it'll probably be kind of reactionary legislation to get there, if you will.
Got it. Thank you, Mr. Chair.
Seeing no further questions for this panel, does anybody else from Thompsonville, are you speaking on behalf of everyone else, or do they want to come up as well?
I think
it went pretty good for you.
Me Too goes a long way.
Okay, excellent. Yeah, we do have 3 other individuals.
I just want to say Me Too.
All right.
Because our time is tight.
Okay, I got you. So
Can only go downhill from here. No, I'm only kidding.
Time.
Terry Gwynn, Jamar Platter, and Alexis Neidert? Neidert, my bad. Gave it the French twist. Go ahead, ma'am.
Terry, you want to go first?
Good afternoon. My name is Jamar Plater. I'm the general manager for Thomasville. With over 20 years in the restoration industry, I've seen firsthand the importance of efficient emergency response and clear industry standards. Today, I'm here to support House Bill 1348, but only with the proposed amendments. Thomasville Rapid Response Team operates 24 hours a day, 365 days a year, and we are here to help families put their homes and lives back together. As a preferred vendor with most insurance carriers, we update those providers immediately so that the process is efficient. We adhere to ICRC S500 mitigation standards and maintain the highest level of safety and documentation. We strictly follow insurance carriers' guidelines, ensuring that board-up costs remain aligned with industry standards through Xactimate pricing. We are constantly communicating with those carriers and homeowners to ensure fair pricing and prevent inflated costs. For example, we also set up fencing when it's more cost-effective than boarding up to secure the property and help provide a safe site in the neighborhood. With over 800 Google reviews and a 4.8-star rating, our reputation underscores accountability and quality service. Why does the amendments to House Bill 1348 matter? The proposed amendments to the bill will provide clarity, fairness, and protection for homeowners while ensuring contractors can continue to deliver essential emergency services. In closing, I strongly support House Bill 1348 with the proposed amendments to ensure that homeowners remain protected, contractors operate with integrity, and insurers receive transparent documentation. Thank you.
Thank you. And I just want to reiterate, it's going well. If there's any redundant testimony, a simple me too is good.
Sorry.
My turn? Hi, my name is Terry Gwynn. I'm the head of strategic growth. Yeah, move this closer. Is that better? Can you hear me? Hi, I'm Terry Gwynn. I'm the head of strategic growth and operations for Thomasville Restoration. I've been in the industry for 11 years, and I've come here today to support House Bill 1348 with the proposed amendments. So Thomasville has got some core values that we extend out into our community. They're family first, compassion, and communication. I wanted to share with you some of the things that we do when we meet somebody who's gone through a peril, because we found that the largest need when something happens is education. These are people who've never gone through this before. One of the first things we do is we urge them to call their carrier and file a claim. If they can't do that, we walk them through it. If it's appropriate, we'll call the Red Cross for them or teach them how to get in contact with the Red Cross. We'll give them a document that step-by-step walks through what the insurance restoration process will be. We have another document that shows what the role of every person they may come in contact will do. We educate them on the need to winterize a home if it's cold. We advise them to retrieve and secure important items like passports, firearms, pharmaceuticals, et cetera, once the home is safe enough for them to enter. We've paid for hotel rooms for people who have no place else to go after a disaster. We provide care packages for them with toiletries and snacks and phone chargers. We ask them to gather a week or two of clothing that we can take, wash, dry, fold, and return to them so they have smoke-free clothes to wear. While we continue to work with people throughout the restoration process, this information that we give them up front really helps set the tone to give them a successful process. Thank you for your time.
Go ahead, Ed. Okay, so I'm gonna me too all of that, but the only thing I wanna do is just share a story. I had this really cool thing written out, but I just wanna share a story. In 2023 in May, I'm sure you guys remember that Aberdeen explosion that happened. It was leveled 3 townhouses, and we were called out to respond to that. And I set up with some snacks and drinks on the bed of my truck, and I was in uniform and I just sat there. And one of the things that I found the most impactful from that experience is I had so many homeowners coming up to me like, what do I do? What happens next? I mean, the fire happened at 10:30 the night before. I showed up around 10:30 the next morning, and these customers were still experiencing a state of confusion at 12 hours later. And so there were customers who had very slight siding melting, or customers whose homes had been completely destroyed. And I had the fortunate opportunity to be there to support them and tell them what the next steps were, whether or not we did their job. I was able to be a source of information, and I was able to encourage them to call their insurance company, file a claim, find out that Thomasville is reputable because we were required to be on, to be vetted, to be members and connected to these insurance companies. So I just remember sitting there and pulling out chairs from the bed of my truck for people just to sit because nobody had anywhere to sit. So it's really, really important that homeowners have access to information because they're getting access to information from many different places. And most of the time, this will never happen again in their lives. They will never receive it. They'll never have another fire. They'll never have another loss. So it's really important that they're able to have access to information and support. Thanks for letting me share.
Thank you. Seeing no further questions, that concludes this panel. Next, we will go back to Delegate Amprey on 1471. I have Richard Freshwater and Marceline White. Go ahead and start when ready.
All right, thank you for my theme music. I appreciate it. All right, I only got one person with me on this one, so. For the record, Delegate Marlon Amprey here in support of House Bill 1471, Innovative Financial Product or Service Certification Program. So, purpose of this bill is we have really a wide range of financial service models that are available out there. And there are really unique models out there that sometimes don't fit into some of the regulations that we already have put in place, which we've already heard about today. So the purpose of this bill is to create a different certification program for those unique models that are providing a different type of financial service model. One of those type of models, and the panel member here today can give you more details on his company, but there's companies that offer, for example, peer-to-peer models, right, where you can borrow money from someone else in the marketplace. Think of it like eBay, but instead of buying, a clothing or something on eBay, you're actually trying to find someone that will loan you some money. And through those models, they don't really fit into the systems that we have where we're actually dealing with an actual service provider. You're getting money directly from a peer-to-peer person or another person. So the purpose of this bill is to make sure that we're thinking about how can we encourage these financial institutions to consider setting up shop in Maryland, doing business in Maryland. The company here today, Solo Funds, will talk more about their model. The co-founder is from Baltimore, but also ultimately there's other companies that are also doing the same type of work. And I think that the important thing about this bill is that if we're thinking about expanding opportunity for companies that want to come and set up shop in Maryland, we've got to be thinking about what kind of programs and systems can we offer to make sure that they're regulated fairly, to make sure that they are, being consumer friendly, but also making sure that they want to come and set up shop here in Maryland. So the purpose of this bill is to create the certification program to ensure that they would be properly regulated. So with that said, I ask for a favorable report on House Bill 1471, and I'll hand it over to a panel member.
Good afternoon, Mr. Chairman, esteemed delegates. My name is Richard Freshwater. I'm the General Counsel at Solo Funds, a peer-to-peer lending platform. First, we'd like to thank Delegate Amprey for bringing this legislation forward because the bill paves a path for innovative companies to meet the needs of underbanked Maryland residents by providing loan access on a borrower's own terms to meet emergency needs. One loan at a time, no compounding interest, no surprises because the borrower selects the terms. This micro-lending model, as Delegate Amprey indicated, exists in the United States. It also exists throughout Europe and Africa as well. On the Solo platform, which provides this avenue in other states, the default rate is less than 6%, and over 30% of borrowers eventually become lenders. Now, why? Because the transaction is between individual people, not companies. The top 4 reasons listed on the Solo platform for loans are emergency auto repair, medical expenses, emergency child care, emergency household expenses, which happen to be the top 4 most common emergency expenses identified by the federal government in a study they completed in 2022. Economic Action Fund opposes this bill, noting companies like Solo try to build a model that escapes interest caps, which were discussed earlier as it relates to EWA, so I won't go back into that, and cites consent orders in Connecticut. However, Connecticut enacted laws that defined optional tips as interest after Solo entered the state. Other states, such as Kansas and Wisconsin, explicitly in their statutes define that tips do not constitute interest. All other states in the United States have no such definition, including Maryland, which considered an attempt to add it in last year's session, and it failed. The AG's office letter suggests that this bill creates a sandbox in which a company could play in and harm consumers. However, the bill does not create an area in which to play. It enables platforms like Solo to be properly regulated by the commissioner, whereby he can approve or revoke any certification issued under the bill, and enact clear regulations that innovative companies can follow versus the current state state regulatory landscape, which does not provide companies like Solo with a clear path forward. We thank you and happy to answer any questions.
Thank you. Delegate Frazier-Hidalgo.
Thank you, Mr. Chair. I don't know who would like to answer, maybe Solo, but in the Economic Action Maryland letter that was submitted, it talks about Solo funds had consent orders in DC, Connecticut, and California blocking them from offering unlicensed payday loans that use tips and donations, concealing annual percentage rates at 511%. Would you like to comment on that?
I'm happy to go into that. Thank you. As it relates to Connecticut, Connecticut enacted a bill while we were having a dispute about whether tips constituted interest, and the bill actually was passed and signed by the state governor. So we entered an agreement with Connecticut to exit the state. With California, California was concerned with the licensing scheme. California did not have a licensing scheme for which we could follow, so with them, we actually created a path forward in California whereby Solo can re-enter once it goes through certain steps under a licensing scheme, which we now understand. As it pertains to the interest portion, which you talk about, we talked about that a bit with I heard that discussed about with the EWA bill. Maryland, is my understanding, was talked about with EWA, does not consider a tip under the definition of what constitutes interest. When you think about interest, it's something that compounds. With this platform, like for the instance, if a borrower says, I need a $100 loan, they can propose to tip the lender. And again, that does not go to Solo, it goes to the individual lender for like $6. Now, that is a loan that would occur over like a 14-day period. So if you take if you annualize that, like we talked about with the EWA bill, that turns into an interest rate that would exceed a usury cap. But the fact is, it's not interest, it's just a voluntary tip. And the Solo platform currently does not require a tip. When a borrower is proposing their term, they type in a proposed tip and they can type in 0. Did I address your question?
Yeah, I think so. I think you mostly got it. Thank you. Thank you.
Delegate Queen.
Thank you, Mr. Chairman. I like this idea because as we're seeing with EWI and all these different products that come up, you know, things are new and different because of the technology and fintech and all that stuff. So the idea that we would have someone look at that and figure out what type of regulation fits which type of lending product makes lots of sense to me, because I think a lot of the issues we're having is people are trying to look at these maybe square things and putting them in a round, that, you know, they're putting it all in one basket and they're very different products. But with that said, because Maryland is not a state that typically is a first adopter of stuff, any other states have taken that approach or doing something where they kind of, you know, have a mechanism where people can come in and say, this is a product we want to enter, provide here in the state, and they go through and kind of say, okay, this fits as this,
So,
this fits as
yeah, so like there's two specific states, Kansas and Wisconsin, have enacted legislation that tells us that tips do not constitute interest and therefore no license is required. There are other states where I've had discussions with state regulators. They look at Solo, like New Hampshire, Alabama. There are two that come to mind that I've had conversations with, which we have licenses in now, and they're like,
so
yes.
So it's based on, so what you're saying is the licensing is based on whether that product fits a loan, traditional loan, or if it fits something with a servicing and tips and fees. That's the only way other states are looking at it. They don't come in and say, this is a new product type, and we would regulate it differently, I guess is what I'm trying to get to.
Yeah, it's been different. It's been a state-by-state approach. So this bill would be unique because it would give platforms like Solo, not just Solo, but platforms like Solo, the opportunity to apply for this type of license and then be regulated and understand that it's going to fall within that scope with the Department of Financial Institutions here in Maryland. So I think this bill's unique in that sense, but right now, Maryland would be out and leading the charge on that. Right now, what the conversations that we've been having have been on a state-by-state basis to see, to your point, where the square peg trying to fit into a round hole. And some state regulators have been clear, willing to work with us. and giving us the licensure path forward. But this, I think, it could be a benchmark for other states to follow.
And Solo, who is your competitor? Prosper? Who else is out there doing peer-to-peer?
I think it's what, Honeycomb?
Honeycomb and Kiva.
Kiva.
Okay, thanks.
Okay, seeing no further questions, next we'll go to the unfavorables. Marceline White. You can start when ready, Marceline.
Let me just sit down. Yeah. All right. Thanks, Vice Chair, members of the committee. For the record, my name is Marceline White, Executive Director of Economic Action Maryland Fund. Economic Action works on economic rights, equity, and housing justice through research, education, policy advocacy, and direct service. I am a proud resident of District 40, and in District 40, our direct service programs have served 223 residents. Their average income is $40,000, and I can tell you that they would not be served by this product. At a time when consumer protections are being rolled back at the federal level, Maryland should be strengthening and championing new protections, but HB 1471 would exempt peer-to-peer lending programs from a wide swath of consumer protections, including our rate cap of more than 50 years. You've heard, I have my written testimony. I will say loan laws, including the interest cap, protect financially fragile families. This would roll things back. If you see the fiscal policy note, you will also note that it says that under the bill, lenders or borrowers in the program would not be subject to fines or penalties for unfair, abusive, or deceptive business practices. So there could be no investigation, enforcement, or regulation of these products. They would be carved out from our current consumer protection regime. So that is one of the reasons I'm very concerned about that. In my written testimony, I've talked about some of the cases. They have a D+ rating on the Better Business Bureau with 100+ negative reviews. For Solo, there are other practitioners as well, but we think at this time we need to be strengthening consumer protections in Maryland for our working families, not rolling them back. And this would be the first time in more than 5 decades that we would have something that exceeds our 33% rate cap for small consumer loans. So for all of these reasons, I am opposed and urge an unfavorable report on HB 1471.
Thank you, Marceline. That's probably a record for how much information was fit into 2 minutes. Seeing no further questions, that concludes this bill hearing. Next, we'll go back to Delegate Ampery, 1416.
Hope you all are enjoying the show. All right. For the record, Delegate Ampery here in support of House Bill 1416, State Department of Assessments and Taxation, expedited document processing and fees. So this bill is a bill where we're trying to catch up with the rest of the country, particularly our neighbors in Delaware and other states where they have a better system, faster system for expediting some of the SDAT services that they provide. So in other states, if you're doing a deal, as a former deal lawyer, when you're doing a transaction and you need to get a deal done by a certain time to avoid interest rates or to hit a certain number, you need to get your filings done as fast as possible. What some states offer, like Delaware, is they offer an expedited fee program where you can pay a whole lot more, like $1,500 to get whatever you need done in 30 minutes because you're under that tight of a timeline. And often companies are willing to pay it because it fails in comparison to the cost of the entire deal, right? If they were to pay $1,500 and get the deal done, they're going to avoid like $20,000 in maybe interest or what have you if it doesn't get done by the end of that week, et cetera, right? So companies are more than willing to pay for the services as long as we have the services that are allowed to make sure that our SDAT services move as fast as possible. And I think it's important that if we want to be competitive, if we want to be in alignment with what the governor's goal is as far as expanding and growing businesses here in Maryland, we have to have services that complement the expansion of businesses and opportunities here in Maryland. So what this bill does is we try to do that. Ultimately, we've had conversations with SDAT. There are possible amendments. The issue that we have right now, to be honest, is that it's a matter of do we have enough staff and people to make this happen, you know, given the timeline of the bill. And we're open to amendments around moving out the start date for when this will take place. But we've got to get to a point where we can compete with other states as far as offering SSTAT services that are as fast as possible, as reliable as possible for companies that want to do business here in Maryland. With that said, I urge a favorable report on House Bill 1416.
Thanks. My name is Trey Helberg. I'm here on behalf of the Maryland State Bar Association Business Law Section. I'd like to thank the delegate and the committee for considering this bill. Our section is in favor of this bill because it offers two important things to Maryland businesses. One, flexibility and predictability when they're dealing with transactions that require these filings. And as the delegate described, it will bring the state to equal footing with neighboring states like Delaware who already offer this exact service. The particular pricing and timing that are proposed in this bill match identically to Delaware and I think are appropriately tailored for that reason. And as a transactional lawyer who represents countless clients that are navigating these transactions in a year and requiring these filings, I can tell you that this really is a true pain point for the client and a factor that weighs into their decision of whether to form in Maryland, whether to form in Delaware or elsewhere, is this ability to have certainty of cadence of transactional filings, timing for registered security purposes, et cetera. And so to the delegate's point, this is a fee that a lot of businesses would welcome to pay and would ease their concerns with being a state formed in Maryland and take that off the plate as far as an obstacle to forming in Maryland. So I think it is really important to have SSTAT's voice involved in this because they're a key component to this. So their ability to execute is really important. But it's being done elsewhere, and I think Maryland's capable and able to do it, and it can be really advantageous for Maryland businesses. So thank you.
Delegate Adams and then Delegate Chi.
So what service are you thinking is not best served? I mean, because let me ask the question a different way. I was getting ready to go the wrong direction. Currently, SSTAT can do this same day. That's the testimony that I've got from SSTAT. What service is needed that's faster than same day?
Yeah, it's a fair question. So the reason that you may want service faster than same day is typically comes up in two instances. One, where it's part of a transaction where you need to file an amendment to your governing documents, and that transaction is a part of, for example, a series of transactions. So you need to create some cadencing where the Maryland filing has to happen first, and then there might be subsequent filings that come after in other states. And for purposes of the transaction, whether it's tax reasons or otherwise, they have to happen in an order. And so right now, for example, if there's filings that are happening in Delaware, Delaware can tee up multiple filings in a few hour period, whereas Maryland, you can only guarantee about one filing in that period for that day. The other place where it comes up is companies that have publicly registered securities. There's often a need to have closing on the transaction either before the stock market opens or at a point in time certain. And so again, being able to lock in either a half hour or hour is really critical to that planning process with NASDAQ or the NYSE.
All right. Do you think it's going to affect SSTAT in a negative way for the average user of SSTAT? Because I don't imagine that, I see the fiscal note saying they probably have to hire somebody more, but what would likely happen is it throws a regular demand, whatever they do on a daily basis, it takes that and makes it not same day, which is, I guess, standard operating procedure, and turns it into something other than that. Are you worried that it overall will diminish the performance of SSTAT?
I think we've had conversations with SSTAT, and we understand their concerns on the timeline. That's why, as I stated earlier, we understand the issues on our timeline. We understand the staffing issues. That's why we're happy to add amendments to the bill so that we push out the start date of when we would offer these services. But I believe that once we have the staff and the technology to do so, I don't believe it would curtail their ability to offer the services they currently provide. It's a matter of not just offering, in order to offer the services that Delaware provides, we got to play a little bit of catch up, to be honest. But I think once we catch up, I think it wouldn't necessarily harm the ability for SDAT to do their services. But we've been in contact with them, and we do understand and hear their concerns fully.
Thank you. So you cited Delaware as an example. I wonder if there are other government services where we essentially have like two classes, right? Where you go through the regular line and an expedited line. I understand the concept and I entirely agree. Flexibility and reliability is so important to businesses. But I wonder, because years ago when people proposed those HOA, I'm sorry, yeah. No, high occupancy lanes, right? Yeah, HOB lanes. There were people criticizing, saying, oh, that's Mercedes lane, whatever. I just wonder psychologically in how we explain that, because government serves everybody, and we should always try to do our best to serve everybody, right? Everybody waiting the same line. So you're saying we should allow people to pay extra if they want expedited services. And I'm not saying I'm for or against, I'm just wondering, can you cite other examples, let's say passport services or whatever, or licensed services, right? Are there other examples of that?
I can't think of any services off the top of my head. I mean, I know, SDAT offers a same-day service that currently costs more than your normal. So we already have a current system where here in Maryland where it's like, hey, if I do same day, it costs more versus a regular filing, it costs less. So we already kind of have that. It's just that we're trying to accelerate our expedited service. The example I like to use, it's not necessarily government related, is like an Uber Black, right? Like Uber Black, I can get the Uber Black, I can pay more. They're going to wait for me a little longer. I'm going to have more room in my car. I'm going to be able to enjoy those services, and I'm paying more for those services. But the other Uber access cars are fully available, and I felt there's not necessarily a situation where people feel like, oh, well, one's, I think that's the example I like to use for, but within the actual licensing example, currently we currently have same-day service versus regular service, so that currently exists, and is there anything else you want to add?
Yeah, I mean, the only thing I might add is I think a lot of times, at least the clients of mine that would have a desire to have this are usually operating in sort of a specialized transaction, or there's some specialized pressure on the transaction, whether it's because they're publicly registered or otherwise. And so I think in a lot of instances, your more kind of room team businesses or mom and pop type businesses, which obviously require or deserve adequate service from SDAT, probably wouldn't need this service, and so there's no need for them to pay that. And ultimately, I think they continue to file either at the same day expedited option, or there's several other options again where you probably don't need even that same day service that are still widely available. And in speaking in the conversations we have had with SDAT, I haven't heard from them that they think this will encroach on their ability to offer the same day services they have. I think it's more been a question of just capacity to make sure they can turn around that timeline just in their processes and in the way they receive the document, who they have to review it, less so than it's going to eat into capacity to review other filings.
Yeah, the fiscal note's kind of confusing, but let me, before I get there, how many of these do we get, these special requests?
Sure. So it'd be hard for me to gauge, but I would imagine, my firm probably does hundreds of these in a year. And obviously, I'm not the only firm that operates in this space. And so, if I'm doing hundreds of same-day filings a year, and at least, a significant portion of those, it would be particularly valuable to have the 1 hour or the 30-minute option. I know my clients would be willing and kind of jump at the opportunity to pay that fee, because frankly, they're paying a lot more in my time and opposing counsel's time to try to navigate how to still close these transactions in the restricted manner that we have available to us. So I think it'd be a no-brainer for them in that instance. And so you'd have a lot of folks who are currently doing the same day choose to go with that expedited rate and an
Well, how
expedited
many do you
fee.
have during the same day? That's something you already do. How many do you typically do a year?
In the
day?
same day? Several hundred.
Several hundred.
At my firm alone, and obviously there's, dozens of firms.
Okay, Delegate Empery, when you look at the fiscal note, it says if we could add more people, if we need to, but the fiscal note doesn't reflect any new hires, new people, new anything. It's saying we can handle it right now. And I'm wondering, how does that work? Because you're going to be providing an additional service at no cost then.
See, you said providing additional service at no, well, there would be a new cost, higher cost for the service.
Cost to about employee cost, I mean.
I'm trying to follow your question. So you're saying,
Could I check?
Can you restate the question?
You're going to be providing more services with no
Correct.
more people that
Yes.
we currently don't do enough of now.
Correct.
Why do we need to build if we have those people that could do it?
So I think, again, like I said, I'm willing to push out the start date because I agree that we definitely need to get our people and technologies up to par, but we've got to start moving on making this happen to be competitive with other states. So I think that the issue is, if we don't start having the conversation to make this happen as soon as possible, I think that, like our panelist said here, it's a matter of companies are deciding to not incorporate here because we don't have the same services that Delaware has. So are we willing to continue to lose businesses based on the ability to provide services or not? So that's what it comes down to. But I think the bill as written can be modified through amendments to make sure we're thinking about the realistic time frame when we can have the staff and technologies to make this happen.
All right, thanks.
Delegate Frazier, Delga.
Thank you, Mr. Chair. So I kind of want to circle back to what a lot of folks are saying, and maybe I'm on the same or maybe a different perspective on this. When we talk about Delaware and being on a competitive playing field, I totally get that. And I think that there are going to be ways to work forward with this bill. But I have to say that one of the things that I am really concerned about is this whole, jumping in front of the line. And I will give you an example. What you had mentioned about Uber Black. That is a for-profit private company. AMC Movie Theater does the same thing. Like, you have this VIP pass, and you ever go to the movies there, and you wait in line, and right before you get up there, somebody shows up and they just butt right in front of you in line, whether that's to buy the ticket or whether that's to buy the popcorn. And that really burns me up. So when I think about, and I don't go to that movie, I don't go to AMC anymore because of that, just so you know.
Right.
But with that said, I can only imagine, what is the fallout for a business that's already in line that gets pushed back? I know that's been talked about a little bit, but that is really where my really big concern is that how fair is that to another company that's been waiting in line, and then all of a sudden somebody jumps in front of them because they have the financial resources to pay to hop the line. So I think if there's a way to work around that and make sure that that doesn't happen, which I've heard some conversation, then I think that's great. But if that's not the case, then I'll tell you, I have great concern with you just being able to have the financial resources to jump the line. So if you want to reply to that, or we can work through the amendments, because I know you've already talked about it, but that's kind of where I am.
I'm happy to talk offline and work through amendments.
Thank you.
Delegate Watt.
I think it's
My question is for Delegate Frazier Hidalgo. Have you ever been to Universal Studios or Disney World?
Yeah.
You're my dish. You would have never.
All right, are we good? Okay.
Delegate Aaron's, I think, asked the question, but I didn't quite hear the answer. Can SDOT do this now without the bill?
So yeah, they could offer the services, and we've talked to SDOT. They said they could do it, but they worry that the ability to deliver on certain timelines would possibly be a constraint. So it's a matter of giving them the manpower and technology to do so. So that's why, again, I'm happy to amend the bill to push it out a year or two, just that we have the ability to properly staff and get the better technologies into SDOT so that they can offer these services. We just can't continue to, I truly believe there's a little bit of urgency here in that, I want to make sure that we're thinking about how we can make Maryland competitive. And the way we can be competitive is offer better services to sophisticated businesses that need these kind of expedited services. So we want to make sure it happens sooner rather than later. So I think even putting this bill in and having a timeline will kind of put some urgency to the department and everything like that.
Well, I appreciate you wanting to make Maryland more competitive, but I think there are other issues.
Okay, seeing no further question. Oh, I apologize. Sorry, I'm operating without the computer. Delegate Pippy.
I just don't remember it being asked. So the fiscal note, like a little further down, it's like 327,000 or 387,000 is what SSTAT predicts they'll need to hire 4 people to do this. We talked about that, right?
I mean, like, not the exact number, but we talked about hiring, yeah.
Okay. And then is Delaware the only state that's doing this? Because you realize Delaware only does taxes. They do nothing else. Okay.
No, you have others you can give them.
Yeah, I mean, there's definitely other states that have, I mean, Pennsylvania is one that comes to mind, one that SSTAT has been looking at and trying to, catch up with as well. Pennsylvania, I mean, we spoke with SSTAT, we had a productive conversation with the delegate, and they specifically brought up Pennsylvania's new filing process that they're trying to catch up to. So that's one I know off the top of my head. I mean, Delaware is what everybody compares to because that's where everyone, forms when they're thinking about, do I form in this state or elsewhere? You're usually comparing to Delaware, so that's what I'm most familiar with. But there certainly are other states.
Because all the businesses are going into Delaware and all the businesses are leaving Maryland. It's like, we got to fix that. But you don't have to answer that. All right, thank you, Mr. Chairman.
Okay, seeing no further questions, that concludes global entry for SSTAT. Now, next we will go to House Bill 1407, Delegates Ampery and Boafo.
We're gonna keep this the Ampery show for now. I think it's just me on this one, so I'm gonna be as quick as possible because we got another bill to get to. For the record, Delegate Marlon Ampery here in support of House Bill 1407, the No Fakes Act. This bill is about, again, making Maryland competitive. It's the theme of the day. So HB 1407 protects individuals from the unauthorized use of their voice and visual likeness through generative artificial intelligence, AI. As AI technology advances, the ability to create highly realistic digital replicas without consent poses serious risk to privacy, reputations, and livelihoods. This legislation does not hinder AI-driven creativity or innovation, but ensures that individuals have the right to control how their likeness is used, even once they are no longer here. By establishing clear protections, HB 1407 strikes a necessary balance between technological progress and personal rights. And what the bill essentially does, and I'm not going to go through all of it, you have the bill in front of you, but what it pretty much does is it gives individuals' voice and likeness actual IP protections so that they can then bring suit in case someone uses it illegally to make a profit. One of the examples is, I think a year or two ago, Drake and The Weeknd's voice were used to make a song, and they literally had the song on platforms that are making money, and eventually they got to shut down. But so we're seeing that happen more often as AI gets better. So what this bill would do is ensure that those likenesses are actually protected and that they would have a right of action. And you can go through the bill for the specifics on how it works. I don't want to give you all more time of me on the mic, but one thing I will highlight is that Tennessee has passed this bill. It has support from the recording industry and association, and Congress is also working on this bill. It'd be great if Maryland could be at the forefront of this and be the first state on the East Coast to get this through. And I think it would really highlight and encourage innovators and creatives to decide to settle in Maryland and create more opportunity for the industry here in Maryland. With that said, I urge a favorable report on House Bill 1407, the No Fakes Act.
Seeing no questions, we will now go to the unfavorables. Brianna January, Margaret, Brianna, come on up, and then the other two are virtual. It's one-on-one.
Thank you again, Committee. Brianna January with Chamber of Progress in respectful opposition to HB 1407. Bottom line for us, Committee, is that while we appreciate the intent and agree with the intent of the bill, we do believe that this approach is not ready for consideration, and we should pause as the issue of likeness is being considered by the federal government. The Federal No Fakes Act, which HB 1407 is mirrored after, has not been properly vetted yet at the federal level, partially because it's to be frank, seriously flawed and likely unconstitutional. Committee courts have consistently held that voices and likeness are considered as facts. HB 1407 would contravene the fundamentals of federal copyright law by unconstitutionally protecting those facts. And I will add that liability for these kinds of matters should be with the bad actors themselves and not with the tools. For example, the state would hold a bad actor, a person responsible for using a Sharpie to create and plagiarize a cartoon and profit off of that, but they would not hold the Sharpie company itself liable. The same should apply to AI. Don't hold the tools liable, but hold the bad actors that misuse them liable. As I stated, there are several issues at the federal level that Maryland should consider, and it's for that same reason that Virginia just 2 weeks ago decided not to pass their No Fakes Act because there are outstanding issues. We encourage this body to continue to study the issue and see what happens at the federal level. Thank you.
Thank you, Ms. January, for being up here. And I have one, I guess, pushback that I'd like to hear
Absolutely.
your response, and that is, I currently find the federal level absolutely useless. Not only do I find the federal level useless, I find them like hurdles for, I mean, I could go on and on. I'm not going to. So when I say that, like, why would we wait on the federal level for anything?
Yeah. Absolutely. Actually, Chamber of Progress is a center-left organization, and we agree along those lines. I will note that the issue here is really with constitutionality, and so should Maryland pass a law like this, it would be challenged in the courts, and that would be a Trump judicial system, something that should be considered. So in the meantime, while Congress is considering the same law, we just suggest that we study the issue instead of pushing through a bill that will be challenged in the courts.
Yeah, I would submit to you almost the same thing about the courts that I previously said, so I'll leave it. Thank you.
Oh, boy. Delegate Adams.
Mr. Chairman, so a Sharpie is not the same thing as emerging AI technology. Would you agree?
I'd agree, but they're both tools for creativity.
Okay, so let me try it again. A Sharpie and me taking and making a picture of somebody is not the equivalent of an AI, which is an emerging technology for which I have some severe concerns about how that technology might be used in a deceptive way. It's a different subject. It's one thing to say the Sharpie is going to create a likeness of a cartoon, and AI that's creating what I think are emerging and severe concerns for the public. So your testimony doesn't seem congruent to me. I don't see the connection. There are two different things.
Sure. So to be clear, for AI to create an image that uses the likeness of someone has to initiate that, right? There has to be an actor that says, let me use this AI tool to plagiarize someone's voice. Just like a cartoonist would use a Sharpie to plagiarize a cartoon already in existence. What we advocate is that you hold that bad actor, that person that made the decision to use the tool, whether it be Sharpies or AI, you hold them accountable. You don't hold the tool developer themselves, because just like a Sharpie manufacturer, you wouldn't hold them liable for creating an image that ultimately plagiarizes something.
But the AI tool is not creating a likeness. It's creating a image of almost perfect example, so.
And someone has to ask that tool to do so. You hold that person accountable.
Okay, so I'm going to do like my friend here to the left and just stop. Because I'm very concerned about AI and how it's going to transform our country. And while I disagree quite often with my friend here about Washington, especially here recently, I think that the state of Maryland probably is right to at least bring the bill forward to have a discussion. And I don't like the idea of saying this is the example of a Sharpie when I deem it as being far more serious a subject.
Understood. Thank you, Delegate. You're welcome for bringing you together. No, I'm kidding.
Thank you, Mr. Chair. So we've done the General Assembly in 2019, not going off too much topic here, but we passed related to child pornography. Like,
Correct.
You made an image that was indistinguishable we treated that as a felony in the state. And so I know now we're looking at, and I'll just put it out there, I have bills that have passed related to this. I have a bill this year, AI with revenge porn, that if you make an image indistinguishable from a real thing and you share it, you know, we want the same penalties as if you shared the real thing. And so my question for you is that if somebody creates, I guess, the likeness of whatever we're trying to protect here, and then they share. So who do you not want to be held accountable in this bill? Or your concern is that it goes
The AI
after
developer themselves.
the developer, but not the person who, what, purchases it or uses
The
it?
person who is deploying the AI to make that likeness, that's the bad actor that should be held accountable, not the developer.
Okay, and the way you interpret this bill is that it only goes after the developer?
I believe it goes after both. We're saying that the developer should not be included in that.
But the portion related to the person sharing and all that, you're good with that part?
The person who actually tells the AI tool to make the carbon copy of, I don't know, whatever celebrity, and then put that on their poster or something, yes.
Okay.
They should be held.
You're like favorable with amendments, or?
Sure, I think that there's still greater considerations around constitutionality because this ultimately comes down to copyright law, and so that's where the contradiction between state and federal is a little murky here. That said, it's not a similar situation like the CSAM, for example, or revenge porn, because there is copyright law involved here. It's just a bit more nuanced. We're just saying, let's take a look and see what makes sense in the landscape of the context that we're working in.
Okay, all right, thank you, yep.
So back to the whole conversation around we should let the feds figure it out, which I think is I agree with my friend from Montgomery County. Want to get your thoughts. Tennessee passed this bill. Where were you all on that bill? And is there parts of that bill you would say, why can't Maryland do that?
Yeah, we oppose that bill for the same reasons. And to be clear, we don't think that the feds should just handle this. What we're saying is there is something being considered at the federal level, and so you want to look and see how a Maryland law would possibly interact with something at the federal level. The Tennessee bill, we had the similar concerns around constitutionality, around copyright law, and there can be some implications that are broadened. I think that this bill might be tailored in a way that is okay, but generally speaking, we've heard from partners that there could be issues around good uses of AI likeness, such as, for example, it'd be awesome if our third grade public students could have an AI-created projection of George Washington crossing the Delaware, right? Like, that's a great use of a likeness replication that AI has the opportunity in education, for example, to be used. So again, another consideration around definitions and just making sure that we're a bit more nuanced here.
But you're willing to work on amendments and help us get this bill across the finish line. All right, got you on the record. All right.
Good job, Brianna, all by yourself. All right. No, we have two virtual witnesses. Margaret, go ahead.
Good afternoon, Vice Chair Crosby and members of the committee. Again, Margaret Durkin with TechNet. We're a tech trade association here to speak today on House Bill 1407. TechNet did submit extensive red lines to the sponsor, so they are with him and he is aware of our comments. We support protecting an individual's personhood and are committed to working with the legislator to address any gaps in laws for legitimate purposes. Brianna mentioned things that are already in my remarks, but one thing I will touch on in the bill is that we have reservations about the provisions regarding removing or disabling materials that are, quote, claimed. If an online service removes content, they could be subject to First Amendment violations. We're also concerned about the private right of action that exists within this bill. We believe that any enforcement should rest solely with the Attorney General. And similar to prior speakers, we are happy to work with the sponsors to potentially craft something that is workable for all industries. Happy to take any questions, and thank you.
Thank you, Margaret. Megan Stokes.
Opportunity to speak again. I'm Megan Stokes. I serve as the State Policy Director for the Computer and Communications Industry Association. We are an international not-for-profit tech trade association. I know it's been a long day and a long hearing, so I'm going to do a lot of me tooing to what TechNet and the Chamber for Progress have said. Just to reiterate, one of our main concerns is that this bill really should hold bad actors accountable when they knowingly and intentionally exploit a person's likeness without permission, not the intermediaries, but happy to work with the sponsor and happy to work with others in this realm. So thank you for considering these comments.
Thank you, Megan. Seeing no further questions, that concludes this bill hearing. Next, we will go to the final bill of the day. Delegate Boafo, House Bill 1400. Please bring up your panel.
Yes, sir. That's right.
I'm sorry.
You want to bounce off and let Len sit right there.
Excuse me?
I said Len will sit right there.
Len is gonna sit there?
Yeah. All right.
I don't know where you sit.
Chair Crosby, members of the House Economic Matters Committee, for the record, Delegate Adrian Boafo here with a non-controversial bill, HB 1400, to present the Maryland No Tax on Tips Act. Let me just start by thanking all my colleagues on the committee and off the committee who traveled with me to meet workers in your respective districts and counties, not just workers, but restaurant operators across the state, to discuss this bill and where we need to go from here. From my travel, one thing is clear. Maryland has tremendous room to grow when it comes to helping restaurant workers and attracting more businesses to our state. With sponsor amendments, HB 1400 does just that. Here's what the bill does, and I think all of you guys have the reprint in your emails from this morning. First, HB 1400 allows us to cut taxes for working families by allowing a subtraction under state income tax for tips received by individuals during the course of employment. This only applies to those who are currently tipped workers. HB 1400 strengthens workplace protections against harassment. It requires tip credit workers and their employers to complete regular sexual harassment prevention training, and those who fail to do so will be prohibited from liquor license renewals, similar to what's happening in Washington, D.C. HB 1400 increases transparency for both customers and tip workers. It requires restaurants to disclose service fees up front, preventing deceptive charges and ensuring customers know exactly where their money goes to, the restaurant or the worker. HB 1400 requires a state study to analyze the full minimum wage in the state and potential sub-minimum wage changes. This study will compare Maryland to other states, examine finances, and assess how tips earnings are affecting workers. Data from this study will help guide future policy decisions. Let me be very clear. This bill does not eliminate the tip credit. This bill does not.
To the audience, that is your warning. Next time, everybody will be cleared out.
This bill does not increase the minimum wage at this moment. But as noted this weekend on the popular HBO show by John Oliver, tipping in America is at a tipping point. Maryland consumers find themselves tipping for all sorts of things, taking away from the workers who rely on it most. They deserve financial relief at a time when they're getting squeezed by rising costs. HB 1400 provides a solution that helps both the worker and good business actors in the restaurant industry. The Maryland No Tax on Tips Act provides us an opportunity to do two things: cut taxes for workers and also provide a minimum wage increase. For those reasons, I urge a favorable report on HB 1400.
Good afternoon, Vice Chair Crosby and the rest of the committee. My name is Rebecca Pierce, and I am the One Fair Wage Maryland lead organizer. Over the past year, I've communicated with thousands of Maryland tip workers who are struggling to make ends meet on Maryland's outrageously low subminimum wage of just $3.63 an hour. The restaurant industry has been the largest and fastest growing employer in Maryland.
Hold on one second. What is your name?
Rebecca Pierce.
Yep, I got you. Continue.
Yes. The restaurant industry has been the largest and fastest growing employer in Maryland for decades, but it's also been the lowest paying, dating all the way back to emancipation when the wage structure was created. After emancipation, the restaurant industry sought to hire newly freed Black slaves, Black women in particular, not paying them and forcing them to live on tips alone. This is the first time tips were ever used as a replacement for wages rather than as an extra or bonus as they always intended to be. Today, Maryland tip workers are still 2/3 Black women and often single women working in casual restaurants where tips are not as high. As you'll hear from a few select leaders today and many more workers tomorrow, they struggle with the highest rates of economic instability and sexual harassment of any industry because they must tolerate inappropriate customer behavior in order to feed their family on tips. They also struggle with the highest rate of wage theft of any industry. Although the law requires employers to ensure tips bring workers to the full minimum wage or pay the difference, the Obama administration found an 84% violation rate with regard to employers actually complying with this law. And now, under the Trump administration, the National Restaurant Association has announced that they're working with Trump to roll back on these very protections. Our most recent poll conducted by Fred Yang this year shows that 67% of Maryland voters support tip workers receiving a full minimum wage with tips on top. It's crucial for the state of Maryland to look into raising the state minimum wage and ending the sub-minimum wage for tip workers so that workers can enforce their rights while they wait for this important wage increase. So we're urging the committee for a favorable report on HB 1400. Thank you.
Okay. Good afternoon. My name is Jacqueline Littleton. I have nearly 15 years of experience as a tipped worker in the restaurant industry. I've worked in both sub-minimum wage and one fair wage states. When I was 14, both my parents lost their income during the 2008 recession. To help, I started working as a server in New Jersey. I was earning just $2.13 an hour. My income was entirely unpredictable. It depended on customer generosity, the season, and my shifts. Oh, like this? Okay. If business was slow, I left with empty pockets. If a guest walked out without tipping, I had essentially worked for free. Sometimes I even had to cover unpaid bills from customers, losing more than I earned in the day. My paycheck was often non-existent because it was consumed by taxes. I didn't know my rights. My manager should have made up the difference when I didn't make a full minimum wage, but that never happened. So when I was 18, I took a job providing bottle service at a nightclub, hoping for better tips. Instead, I was catcalled, propositioned, and touched without consent. I was treated as part of the service, not just the provider. Speaking up meant risking my income. I needed their money, and they knew it. At 19, I moved to Olympia, Washington, where I was guaranteed $15 an hour plus tips on top. For the first time, I had a stable income. I could pay rent, tuition, and buy groceries without relying on customer generosity. More importantly, I could set boundaries. If a customer made me uncomfortable, I could stand up for myself without fearing financial retaliation. This contrast made it perfectly clear the sub-minimum wage for tipped workers is legalized exploitation. It keeps millions, especially women and people of color, economically insecure and pressured to tolerate sexual harassment just to get paid. Yet Washington's restaurant industry thrives, just like the other 7 one-fair wage states. While they pay a full wage, proving fair wages and a strong restaurant service sector can exist. Every worker deserves a stable income, no matter how busy their shifts or how generous their customers. Studying one fair wage isn't just good economic policy, it's basic justice.
Hi, good afternoon, Vice Chair Crosby. My name is Alicia Porter. I spent the 4 years in an industry that broke my heart. I left because I couldn't no longer endure the devastating reality of an inconsistent income, wage theft, and exploitation, and the soul-crushing weight of sexual harassment I faced every day. I won't name the establishment where I worked, but it was a nightmare, perhaps the most hostile environment for a young woman of color could possibly endure. I was made to feel worthless, as being a server somehow made me feel less deserving of dignity and respect. On a personal note, my childhood was already marked by trauma. I was sexually assaulted by a family member when I was young, which deeply caused emotional scars. Then, as just 18 years old, I entered an industry fresh, vulnerable, into an environment with predatory men that felt entitled to hunt. The catcalls were relentless, but I would never forget this one moment. A client slowly caressed my leg just above my knee. At that moment, traumatic flashbacks flooded my mind. I couldn't defend myself, sorry. I couldn't leave my job. My livelihood, my ability to pay my rent and to eat depended entirely on tips from those same people. So I hid in the bathroom, sobbed quietly, wiped away my tears, and forced myself back onto the floor to continue taking orders with a smile. But this brutal reality comes from countless young women across our state right now. They are suffering in silence, just as I did, trapped by a system forced them to choose between enduring harassment or going hungry. If I were receiving one fair wage, I wouldn't put up with the countless harassment. I stand here before you representing every young woman who must tolerate who must tolerate sexual harassment because of her survival depends on tips. I implore you, look at me and see the daughters, your sisters, your loved ones. Would you want them to suffer like many of us have? Please advise HB 1400. This isn't about fair wages. It's about human dignity and safety. Our bodies should never be the price that we pay for a paycheck. Thank you.
Delegate Crosby, I think given the hour, I will waive my testimony. It's more important you hear from the workers than from the lawyers, so I'll do that. I'll be glad to answer questions on the amendments.
All right. Good afternoon. My name is Van Lynn, and as a Black woman who's worked in restaurants and fine dining for over 10 years, I'm here to share how sub-minimum wage policies have harmed me and why this bill, HB 1400, matters. In fine dining, I was repeatedly excluded from high-profile events where white colleagues were chosen to serve wealthy patrons. Managers claimed it was about ambience, but it was about discrimination. Those events meant bigger tips, which were my wages. And when you're paid on just $3.63 an hour, every lost opportunity devastates your livelihood. And when customers harass me, I had to swallow the dignity to keep a tip because my survival depended on it. Black workers, workers of color, and women are susceptible to this type of discrimination and harassment. Not having a guaranteed living wage means continued instability. But it doesn't have to be this way. 7 states require employers to pay full minimum wages plus tips. In those states, servers, like I used to be, aren't forced to tolerate abuse just to pay rent. Study shows these states have the same job growth, same menu prices, and tipping rates as Maryland, but half the rate of sexual harassment. Women aren't trapped choosing between safety and a paycheck. Cities like DC and Chicago have already made this change. Researchers at the New York Times and universities like Tufts have found that restaurants thrived from it. Jobs State study, tips didn't even drop. Even in national platforms like John Oliver's show has highlighted how workers have gained power and no longer have to accept discrimination or harassment. Cities who passed this never look back. It's in the numbers, and servers report making even 10% to 20% more. I've seen the difference. Servers in the 7 states who have passed this feel the difference. Colleagues in these states have the stability that I never had. They can say no to a customer's advances without fear. They don't lose wages because of their skin tone. They get a full wage with tips on top. But this passing HB 1400 would allow us to understand why no server has to endure what me and other colleagues had to do. Please vote so we can support a fair living wage.
Is that your panel delegate? I just want to make sure. I know some people are bouncing in and out.
Yeah, yes.
Okay. All right. Before we start questions, I just want to say to everybody in the pink shirts that testified, we appreciate you coming up here. I know it takes a lot of courage, and I'm sorry for what you've had to endure. Okay, we'll start with Delegate Pippy.
Thank you, Mr. Chair. So Delegate, the bill's been heavily amended, correct? Okay. So the 2 big items were elimination of I think you just addressed that, the tip credit and then the minimum wage. I don't have a reprint in my system here, so I'm not looking at what this modified version is. So can you just briefly just tell me what was cut out and what does the bill do now?
Yeah, so here's what the bill does, essentially. It ensures that we create a program similar to DC within the Maryland Department of Labor that ensures that to get a liquor license renewal, the commissioner is going to have to set up a process and training that allows folks, both the owners, the employees, and the management at an establishment to go through sexual harassment training. That's the first thing. The second thing the bill does is it provides study language both for what the minimum wage would be today, what it would be in 2030. That's one thing. And how the subminimum wage in particular would affect Maryland if that were eliminated. And that's the third part of that. The fourth part is that, as the bill says, it's no tax on tips. It eliminates actually workers having to be taxed on state income tax in particular on their tips. And the other piece that I just realized that I failed to mention in my testimony was that when it comes to credit cards, right? If you're a service worker and you're getting tipped, as most folks do on credit cards, there's a 3% fee that actually you end up charged. We're eliminating that so that credit card companies aren't actually taking those 3% fee back.
So that last part is substantive, so you're eliminating the credit card, the fee that they charge for the bill when they buy services at a restaurant, is that what you just said?
No, so if you're a service worker right now, like many of these folks in this room, and you're tipping out, right? To process your tips that are on the credit card, they take 3%.
Okay.
We're eliminating, this is actually similar to the bill that the Vice Chair and Todd Morgan have to eliminate credit card folks from doing that so that workers get 3% of their money back. Their tips are their tips. We shouldn't have credit card companies involved in taking that back.
Okay. So my other thing is this, look, I waited tables in college. So, I mean, I probably didn't get a lot of cat calls, but I definitely worked hard for those tips. But the original bill put in was offensive to a lot of people. And a lot of people drove down here, took a full day off work to come down here to contest this bill. And thankfully, the bill's been heavily amended to kind of remove the most egregious parts of that original bill, which I think the people in the back are grateful for. But, you know, we got to do better by our small businesses in the state. I think the bill as introduced originally, which is a moot point now, but that could have been pretty devastating on a lot of small businesses and people that, like me, when I signed up to be a waiter, I signed up because I wanted the tips because I could make more money than minimum wage. And so it kind of defeats the purpose of setting a $20 an hour. I probably wouldn't have taken the job if it was $20 an hour. You know, you can make more money if you work hard in that industry with tips than you could if somebody gave an artificial minimum wage. And I think that's the concept that's being missed. But it's a conversation for another day. I appreciate you answering the questions. Thank you.
Delegate, I'll just say one key point. The evaluation of the minimum wage and study language does remain in the bill, and that's critically important. I don't know if folks drove down here because they opposed the $20 minimum wage increase. I think, as you just heard, most people actually agree with that in our state, both in my party and yours. But I do want to be clear that the sub-minimum wage conversation still does exist. And the initial bill never eliminated tips. That is just not even a thing. We can't really actually legislate doing that. What it did was eliminated the sub-minimum wage so that folks can get paid $20 an hour with tips on top, including the service fee provision. That's what that bill initially did, but we went to study language, and I appreciate your remarks.
We're going to go right around the horseshoe. Delegate Johnson.
Thank you, Mr. Chair. And thank you, Delegate, for bringing this bill. I just had a quick, well, two-part question, because I thought I heard you say that it would cut taxes?
Correct. Yes,
And
workers under this
could you
bill.
clarify that?
Yeah, workers under this bill will receive a tax cut.
Okay. And what about the elimination of tips?
No tips will be eliminated at all.
No tips will be eliminated.
Correct.
So I see in the unfavorables that they were saying that tips would be eliminated. So could you clarify that?
That's a great question, Delegate, and I can't wait to get back to my seat for the unfavorable portion because we have negotiated in good faith with the Restaurant Association for the last 2 weeks. They knew we were pulling the tip credit out. They knew we were pulling out the sub-minimum wage piece, and they knew we were pulling out the minimum wage piece. So I have the same question, and I can't wait to ask that question.
Okay. Well, thank you very much.
Thank you, Mr. Vice Chair, and thank you, Delegate, for bringing this bill forward, and thank you for the willingness to work with all the parties involved and come to a resolution on a bill that everyone could support here. My question just goes to, and thank you all for your stories today, and I'm sorry, again, like the Vice Chair said, for some of the things you've had to go through, and just wanted to get clarification on better understanding, just give us more details on the importance of why you're adding this sexual harassment training provision and just better understanding of just the legalities of it as far as that requirement is okay. Is that a standard? What other places do we have sexual harassment training for a license, et cetera?
Yeah, it's a great question, and again, thank you, ladies, for sharing your story. And I'm sure the folks behind me who may not be testifying today probably have similar stories, or know folks in the industry who have similar stories. You know, the EEOC says that 60% of tip workers have reported experiencing some level of sexual harassment, and about half of those folks experience it once a week. and what Washington DC, before I get into what other jurisdictions have done, what major companies have done, major restaurant operators, some of the same places that we go to when we're down here for 90 days, have implemented aggressive sexual harassment training for their ownership, for management, and for employees. And that's what we're trying to do here. A lot of the big operators in our state, especially those that we've talked to, say we already do this and that's fine. And what we're trying to do is make sure that the Maryland Department of Labor, the commissioners are able to set up a program similar to what they've done in DC that says you have to establish a sexual harassment training prevention program that allows employees to know their rights, that allows owners to know their rights, and more importantly, gives folks the ability to know where to go when something like this happens. And that's what that part is about, and it's contingent upon a liquor license renewal. And so I think that's extraordinarily important that we get done.
Thank you.
Thank you, and I apologize that I had to run over to my office during the middle of your testimony, and so, or actually at the beginning of your testimony. So I missed pretty much, I guess, everything. So the bill has, I heard you say, Delegate Pippy, that it's been heavily amended. So what I'm looking at on my system is not what the bill is.
Correct.
And so I walked back in, and I was hearing about the sexual harassment. I didn't understand where that came in. And I think I understand a little bit better now, because you're implementing under your amendment, one of your amendments, an anti-harassment training, so that in hopes to eliminate that behavior.
Yes.
One. So I go back, I want to just go back to the beginning. Delegate Howard was making jokes over here earlier about us. And so you've had, I guess, a couple of bills related to tips.
Yeah.
And what is bringing this about? What's your experience that you would even want to bring this besides someone coming to you and saying, hey, we've got this issue?
Yeah, let me tell you about my personal experience. I wouldn't be here if I wasn't a service worker. I worked about 2 miles up the road. My first job out of college was that. I then went to go work on the Hill, as many of you guys know, for many, many years. And frankly, at that time in 2015, 2016, we weren't making a lot on the Hill. I don't think there still are. But to supplement my wages, that's what I did. And I worked in a restaurant that had paid me in 2016 $14 an hour with tips on top. I worked in the restaurant that paid me to whatever it was in 2015, I think $265 with tips on top. And what we realize is that there needs to be a conversation, especially in this modern era. So that's the personal experience. I just want to say that. What these bills have been about over the last 2 years is that there needs to be a conversation here in Maryland about, we have, and this committee is proof of this, we just passed on the floor a bill relating to tipping. You go to Dunkin' Donuts now, they're asking you to tip. And frankly, the culture of tipping, while though it has a super dark past, the intent has been to make sure workers are supplemented from the sub-minimum wage that they have. No one's trying to eliminate tips. I worked for my tips. I was not good at my job in particular. They're probably better at me better at the jobs than I was. But that's the conversation that we need to have. We got to make sure that service workers, who are some of the most vulnerable folks in our population, have access to wages like everybody else. And what we do know, and this is a running joke in the service industry, if you're paid $363 and the minimum wage in the state is $15 an hour, as the Obama administration found out, as the Biden administration also found out, most folks who are not making that $15 an hour, not meeting that threshold, aren't actually getting the money from their employer. And that's the enforcement problem that has to happen.
They're not getting the money
is called
based on the tips. So whatever their tip is.
If you work in a slower restaurant, let's say you work in a slow restaurant, we'll use our county for example, and in an hour you made $5 an hour. With tips, you made $363 and then you got a $2 tip, so you made $563. Your employer, by law, federal and state, is supposed to make up the difference for that. Now, most workers in this industry are blessed enough to make well more than $15 an hour, and we want to make sure they continue to do that. But we're talking about those workers where they're not getting that money from their employer, and their employers are skirting around. We're talking about the bad actors, which is not the majority of this industry. As I travel this state, and as I said earlier, that is not the majority of this industry. You talk to restaurant operators, they'll say it is wrong to do that. We're talking about the bad actors in the industry, and that's what this bill has been about for the last 2 years.
All right, thank you.
Thank you, Mr. Chairman. Delegate Boafo, thank you again for your testimony. I do have a follow-up about the sexual harassment training. It's been 25 years since I bartended and was a waiter myself. But if I could recall, New York State required sexual harassment training when you got hired. And I noticed in your written testimony, it says DC does it every 2 years. So would you consider something that would be upon hire? Because in the restaurant that I worked in, there were different employees every week, right? So if you have two, so I just want you to clarify that, because I think that's an important part of the bill.
Yeah.
And if you could just kind of lean into that a little bit about what the requirement would be, because if that's the intention, I want to make sure that that's getting done, but also, you know, how people move, employers, or whatever else. Thank you.
No, I think that's a great point, Delegate Peruski. I think that by this amendment that we put in, we're not trying to have employers reshape how they do sexual harassment. So if you're an employee walking in the door and you have to complete that, you should and can continue to complete that. What we're talking about is upper management and owners of restaurant venues, those who have power and control, who oftentimes don't take that level of sexual harassment training, who, at least in Washington, D.C., we saw those are where those numbers were coming from. And so what we're saying is if you're an owner of a business, you should be liable to take the same sexual harassment training that the rest of your employees in the industry take, so that you know what's right and what's wrong. And that's really what that amendment does, but I'm happy to clarify that over time.
Thank you, Mr. Chair. So I'm sorry, I felt like I'm not quite following the various components of the bill, and I'm more confused after this hearing. And I do appreciate the heartfelt testimonies, and I totally get the need for sexual harassment training, how tipped wage workers tend to be, treated certain ways because they have to depend on the discretion of customers and all of that. And these discussions are not new. But when I looked at the title, No Tips on Tax, I was like, is Delegate Boafo bringing a Trump idea to Maryland or something? Now, I thought the bill would do one thing and then it ended up doing quite a few other things. So my question is, are you simply saying eliminating the fee if people pay tips by credit card? Or are you saying no tax period on tips, whether you pay by credit card or by cash?
Yeah, so I'll answer your question in a two-part. On the Trump piece, I want to be very clear. The president is right on this one particular issue, and apparently a broken clock is right twice a day, and he's right on this. But let me be very clear. In the 116th Congress has been one bill introduced on no tax on tips. It was by Democrats. The 117th Congress, it was 3 bills introduced by Democrats on no tax on tip. 118th Congress, it was 2 bills by Democrats introduced on tax on tips. We have a bad marketing problem, and the president took advantage of that. So I want people to know on the record that this isn't an idea that just President Trump all of a sudden had. This has been a deal that we've been dealing with since 2020 in our party. And this year, there's 4 bills in the Congress, both of them bipartisan, 2 GOP, 2 not. So that's that part, because I had to address the Trump piece. Let me just kind of give you the quick highlights of what, again, the bill that now does, for the record. We're exempting tips from state taxation. That does mean both on the credit card and on cash. Now, I will say, and actually I'm not gonna say that on the record. Number 2, we're gonna require disclosure for where service fees go. When you and I go to a restaurant and we eat, there's a 25% service charge fee. Most of the time, consumers will say, you know what, that's the tip, and walk away. And what we're trying to do is make sure people know if that's going to the restaurant or is that going to the worker. And that's a big debate that's happening, especially with the rise of inflation. 3, we're prohibiting deduction of credit card fees from tips. So if you're a service worker and you go get your tips on your credit card, usually there's a credit card processing fee of around 3%. We're eliminating that, which I think there's already a bill on that. We're requiring restaurants and owners to complete sexual harassment prevention training. We're requiring the Commissioner of Labor and Industry to submit 2 reports by November 1st, 2021, one on this regarding the state's full minimum wage and the effects of what ending the sub-minimum wage would mean for the state of Maryland.
If I may ask a follow-up question on this no tax tips thing, I'm sure you've read many studies and reports in order to reach this conclusion that it's a good idea. I just wonder about the unintended consequences of people taking advantage of the system by saying, okay, don't pay me wages anymore, just pay me tips because I don't have to pay taxes on them.
Well, let's be
Right.
clear. We narrowed down the scope of who is going to be receiving in this bill, no tax on tips. It is specifically restaurant workers. More importantly, that's what's happening now. Their wage by the state, by legal mandate, is $363, and they're getting the rest of the money on tips. And so that wouldn't change in theory. What we're saying is let's not tax that for the most vulnerable workers in the state.
Thank you.
Delegate, just a couple questions about, we talked about that bill eliminating the tax on tips and stuff like that. One of the issues is you realize that the credit card companies, they set that rate, not anybody else. So they'll come back and they'll find a way around that. But my big question is, and I deal with a lot of restaurants because I used to have one, but what people are finding right now, over the last year, 2 years, year and a half, whatever, prices gone up 30% or 40% in so many cases. And when we look at that bill, my bill is growing each time I go out to eat dinner, and I'm tipping, still trying to get that tip 15 to 20% on that rate. And it's very difficult because now my customers I'm hearing, not mine anymore, are sitting back saying, you know what, I'm not going to settle for anything less than perfection. So if I get something happening, and then my tip's going to start getting affected. As we keep raising the minimum wage, I think you're going to see people sit back and say, you know what, people are making $15, $20 an hour now. Maybe I don't have to tip anymore. And that's a serious problem because I can't afford to eat. I mean, I take my wife, my daughter, my son out to dinner, I'm at a $250 bill if I go to a decent restaurant. And I think when we start looking at these bills, we ought to be more aware of how we're going to affect those rates and what we're really going to do to the workers. I appreciate the intent of the bill, and I've owned a restaurant, I've worked in a restaurant, so I understand some of the problems, but I also understand what we're doing to ourselves by doing that.
Delegate, thanks for that. I want to be very clear again. This bill does not affect the tip credit or the sub-minimum wage. It just doesn't happen. But to your point, you're right. Prices are going up. We've now seen restaurants adding service fees go up, and we haven't increased the sub-minimum wage. It's still at $363. We haven't increased that threshold for workers. In fact, you're hearing workers say more and more that they're seeing a decrease in tips because of the lack of transparency. Now, it also depends on what food establishment we're talking about. When we're talking about those Class A businesses, tipping in that culture will not change because there is no thing as tip fatigue because those folks are blessed enough to be able to continue to do that. But we're talking about, again, the 30% of the most vulnerable folks in the restaurant industry that may be affected. But happy to talk to you tonight about that a little bit more.
Just my personal experience. Thanks.
It's already night. I should have done this in the beginning, but I want to welcome our colleagues from HGO. And with that, Delegate Feldmark has a question. I'm sorry, Ways and Means.
Thank you, Mr. Chair. And thank you, Delegate, for the bill. And I really do want to sincerely thank everyone who testified and shared your experiences. Really appreciate your time and your testimony. My question, even though Ways and Means is here because of the tax piece, I just have a quick clarification on the credit card piece of it. So are you saying that the credit card service cannot actually charge the processing fee on that portion of the check, or simply that the employer cannot deduct the processing fee from the tips that are given to the employee?
You want to take it?
Is it?
Sure. Delegate Feldmark, it doesn't stop the credit card fee. It just prohibits the restaurant from passing it on.
From passing it on. Okay, so the employer absorbs the processing fee on the entire check.
Right.
And the tips remain whole.
That's correct.
Okay, thank you. Thank you, Mr. Chair.
Yep. And just to clarify, there is an amendment to make it just about food and beverage, correct? Because I'll tell you, as an employer, I change every one of my employees to a tipped worker and hook them up so they didn't have to pay taxes on that.
Yeah.
And then I'll tell you what I wouldn't do. I'd stop tipping when I go to a restaurant because I'm not going to sit there while I'm paying taxes and these other folks aren't.
Yes.
So no need for claps. So, I mean, obviously the bill is heavily amended. We'll have to take a pretty strong look at it. I'm sure something like this will go to subcommittee. But seeing no further questions for this panel, we will now go to the virtual witnesses. I have Apologies, is Roger Gary there? Okay. We will go to the virtual. Saru Jayamaran?
She's on a plane right now.
Okay. Alex, go ahead and start.
Sure. Thank you, Mr. Chairman Wilson and Vice Chair Crosby and members of the committee for having me on. I'm Alex Marsh. I'm speaking on behalf of the economic advisor to the Maryland Living Wage for All Coalition. We include groups including Unite Here Local 7, ASHME, SEIU 1199, and the United Food Service Workers Local 400. I'm speaking on behalf of HB 1400 because key sections of the legislation focus on ending worker exploitation by ending employers' abilities to charge workers credit card fees on their tips, creates rules on so-called service fees, and at least through studies, moves Maryland towards ending a sub-minimum wage. The median income of Maryland's tip restaurant workers is just $14,000 a year. For perspective, that's only $150 above the individual income level required to file taxes in the state of Maryland. In fact, 95% of tip restaurant workers in the state make under $53,000 a year. This should not be a surprise to anyone, as Maryland has the largest per dollar difference of any state between its minimum wage and its sub-minimum wage, a difference of $11.37. It is one of actually only 3 states that have the difference of over $10 an hour. We see today that raising base wages means workers' incomes go up and employment can increase. You know, the U.S. Department of Labor had to do analysis in 2021 on this subject just because they were doing chip rulemaking. They found that they did not see a decrease in tips with higher hourly pay. We also see, just looking at the U.S. Bureau of Labor Statistics quarterly census of employment and wages, that not only do restaurant workers on average in fair wage states make more money than their sub-minimum wage counterparts, but that income difference on average has widened by over $760 in just the last 3 years, to a difference over $3,100. This is for both tip workers and back-of-house workers. They make more money when you pay them more money. And we see businesses succeed. You know, the one big state that's been raising tip worker pay consistently for the last few years is actually Florida, through a minimum wage ballot initiative. They've been raising tip worker pay $1 a year every September since 2021. Since then, their employment—
Thank you, sir. I'm going to need you to wrap it up.
10%.
Okay, thank you so much for your testimony. Next, we will go to Thembi Makakwa.
She has a time difference and it went past the time, so she can't make it today.
Okay. All right, we will now go to the unfavorables. I have Melvin Thompson, Grayson Wiggins, Mike O'Halloran, and Rebecca Paxton. Start when ready.
Thank you, Mr. Vice Chair, members of the committee. I'm Melvin Thompson, and I represent the Restaurant Association of Maryland. And we submitted written opposition to this bill as the language was introduced. I'd first like to begin by saying that we certainly do appreciate the amendments that the bill's sponsor has offered here today to strike the language in the bill that would eliminate the tip credit. We are very grateful for that change to the bill, because we have a lot of tipped employees here today who are very concerned about that part of the bill. We have a lot of employers who were also concerned about the proposal to raise the minimum wage to $20 an hour. And so we were very happy to hear those things in the bill being taken out. But on the other amendments, I will have to say that I certainly cannot comment on any of the other amendments today, because we have in our association a government affairs committee that evaluates legislation and proposed amendments. We discuss them, and we can get back to this committee on what we think of all of those changes. I did certainly have a conversation, a couple of conversations actually, with Delegate Boafo over the past couple of weeks, and he explained to me some concepts of amendments, some ideas they were thinking about. And I told them that we would need to see those ideas in writing. And I expected to get those ideas over the weekend in writing, and we did not. I actually received an email this morning as we were en route here at 11:30 with those amendments in writing. And so I will have to take those back to my Government Affairs Committee, evaluate them, discuss them, and get back to this committee on what we think about those amendments. But over the years, this whole tip credit issue, in which I fully explained in the written testimony that I submitted, over the years we've seen different forms forms of legislation to eliminate the tip credit. We saw it in 2014, 2015, we saw it in 2017, 2019, 2023, 2024, and here again in 2025. And those bills never made it out of the General Assembly because of the strong opposition from tipped employees and restaurant operators. We also saw proposals in Prince George's County, Montgomery County, and Baltimore City. There was not enough support to pass those bills here. These bills are being pushed by an out-of-state activist group who's trying to push their policies into Maryland. And our tipped employees and our restaurant operators and our customers in Maryland don't want this policy change, and that is clear. And that is the reason why we oppose this bill as it was introduced. But I'll be happy to answer any questions and give some important clarifications in response to the bill sponsor's testimony. Thank you, sir.
Hi, my name is Rebecca Paxton. I'm the research director at the Employment Policies Institute and a trained economist. I applaud any efforts now and future to protect the current tip credit in Maryland because you are siding with the workers in this room and 90% of tipped workers across America. But I'd like to take this time to highlight the worst possible case scenario when you eliminate the tip credit, and that's what's going on in DC. And unfortunately, John Oliver didn't cover that part the other night. Tipped restaurant workers in Washington, DC right now are fighting for their livelihoods. Thousands of jobs have been lost under Initiative 82. Compared to the year before tip credit elimination, DC's restaurant employment rate dropped 19 percentage points. That's in a year, or 2 years. Things have gotten so bad that dozens of DC workers flooded to a DC council hearing this January, many asking to pause the law. The one fair wage promises you're hearing don't materialize. That's because when tip credits go away, tips do go down. States that have eliminated the tip credit have the lowest tipping percentages in the country, 10% lower than the national average. Some of the most poignant comments from that hearing were, my hours have been cut, my tip percentage is down, my support staff is gone. But the most memorable quote I'll share verbatim. I can go to Maryland and make 200, even 300 or more for 5 hours of work. Or I can work double those hours and make only $150 in DC. I urge you, if you're going to study this issue, to please investigate how this has hurt workers in DC. Don't allow that to come to Maryland. Thanks.
Good evening, Mr. Vice Chair, members of the House Economic Matters Committee. For the record, my name is Mike O'Halloran. I'm here today representing NFIB. Look, obviously, when I signed up, it was on the bill was introduced, so I don't want to belabor the point. I think everyone here who's heard me testify before this committee in prior years on the minimum wage understand what a devastating impact a $20 minimum wage would have. Set aside the issue with tip credits, while we certainly represent restaurant owners, we also represent industries more than just that. But I think our members are relieved to see the $20 minimum wage piece removed. Certainly have some consternation about a study and what that study may look like. But if the committee does move forward, we certainly want to be a part of that conversation as well. Thank you.
Good evening, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. Would echo Mike's concerns and statements. We signed up on the bill as introduced. I do want to thank the sponsor for continuously meeting with me throughout session to listen to our concerns. We would just respectfully request the ability to review the new language with our members, because it does appear that the bill was stricken and there's a new bill in front of us now. Thank you.
Thank you, Mr. Chairman. I really wasn't going to say anything since it's 6:21, but I think I've got to say some things for the record. So let me just be clear. You know, we got this amendment at 11 o'clock today as well, so we're all in the same boats here. But Melvin, we've been talking for many weeks about this, and I think we knew the sub-minimum wage was coming out. I want to reference on page 2 of your bill. Contrary to what the bill advocates claim, there is no such thing as a sub-minimum wage for restaurant tipped employees. Are you familiar with the Fair Labor Standards Act?
Yes, I am.
Okay, and what's the carve-out for tipped employees?
Well, the Fair Labor Standards Act is federal law, and under federal law, there is a tip wage of $2.13. In Maryland, the tip wage is $3.63, and what that means is the employer has to make up the difference if the employee doesn't earn enough tips with the base wage of $3.63 to make at least the full minimum wage, which is $15 right now in the state of Maryland. Under the federal Fair Labor Standards Act, the cash wage is $2.13 on a $7.25 minimum wage. In Maryland, we follow the state law, which I just referenced.
Correct, which is higher than the federal federal law, which
That
is
is
great
correct.
for Maryland.
That is, but the employer is still required to make up the difference.
Absolutely.
So there is no
Let's
sub-minimum
just-
wage
let's-
is what I'm saying,
well,
sir.
let's just, for clarification, in the Department of Labor, it's actually referred to in law, this is not just me making it up, Section 14C of the Fair Labor Standards Act is called the sub-minimum wage, and it has a bunch of categories that are under that. That is not a hyperbole. I know for marketing, it's better for you guys to call it the tip credit, but let's actually get it correct. Section 14C, for the record, of the Fair Labor Standards Act is actually called the sub-minimum wage. Second question, do you believe that restaurants need to charge a service fee?
Let me answer your first question. I do appreciate your questions. The Federal Fair Labor Standards Act does refer to a sub-minimum wage, and the sub-minimum wage is for youth employees, and it is also for some other categories of workers who are in school full-time. But the sub-minimum wage, as it's defined in the Federal Fair Labor Standards Act, does not apply to tipped employees. That is the tip credit. So there's a big distinction between what the Federal Fair Labor Standards Act says regarding sub-minimum wage. As you're using it here, the $3.63 cash wage for the tipped employees, that's not a sub-minimum wage. That is a base wage because the employer in Maryland is required by law to make up the difference if they're not making enough to make at least full minimum.
Great, well, we'll get you a copy of the Fair Labor Standards Act. Do you think that restaurants need to charge service fees?
Service fees vary by restaurant. There are some restaurants you may have noticed, sir, that have a service fee for parties of a certain size. The service fees that I think you're referring to in this bill have come front and center in the debate because Washington, D.C. is phasing out their tip credit. And because of phasing out the tip credit in Washington, D.C., employers have to now pay a significantly higher base wage to tipped employees. And so they're imposing service charges on their customers because the service charges are helping the restaurant to make up that difference in the increased labor costs. That's what's happening in D.C. And that's why customers in D.C. are often not tipping on top of service charges because they consider that service charge to be for the service. So I just wanted to fully explain the context here, sir, because I think that's very important.
That is so great that you said. I wasn't even going to go to D.C., but let's talk about D.C. In D.C., the reason why we have what was called the I-82, and it's not we, but what D.C. has is the I-82 fee that I'm pretty sure a lot of workers in this room probably know of because it hurt workers significantly. It was advocated by the Restaurant Association that did that. That's why we have a service fee in D.C. I wasn't even asking that question. I was asking simply, do you think that restaurant owners should have service fees in their restaurant?
I'm sorry, sir, but you said that the Restaurant Association advocated for service fees in Washington, D.C.?
Yes, that's a thing, yeah.
I am unaware of the Restaurant Association advocating for
we'll get
service
you a
fees.
copy of
I know that in D.C., the Attorney General's office issued a clarification regarding disclosure on menus because customers there were confused about where the service fees go as a result of phasing out the tip credit after voters passed a ballot initiative, Initiative 82 that you referred to in November of 2022.
I will get you a copy of this article too. The Restaurant Association did push for a reform to ease financial burdens, the I-82 service fee. Do you want to talk to me about ServSafe? You know what ServSafe is?
Yes.
Do we use that here in Maryland?
Yes, we do use ServSafe in Maryland. In fact, our association offers ServSafe. That is a program by the National Restaurant Association, which is training for restaurant industry employees, sanitation training, alcohol training, ServSafe Workplace, which also includes sexual harassment training. Yes, sir, I am very familiar with it.
And has the ServSafe, the money that goes into ServSafe that employees put into it, does that go to any other causes for the Restaurant Association?
It's my understanding that ServSafe and the programs offered and sold through that program are totally separate from the Restaurant Association. Are you talking about the National Restaurant Association?
No,
Just to clarify.
Yes, yeah.
The ServSafe program, is my understanding, the funding that goes in that program is separate from the Restaurant Association.
Any dollar of the ServSafe program going to any other lobbying efforts by the Restaurant Association?
I do not know, but I can find out for you. I don't know the answer to that question.
This is my last question, Mr. Chair.
Sorry.
New York Times article from January that showed that the Restaurant Association, for the mandatory $15 food safety class, you actually use that to lobby against wage increases all across the country. Not just here in Maryland, it's something that you're offering Maryland workers to use. Here's what I'll say for the record, and then I'll end, because it's been a long day. I do this in real life, professionally. And what I find so egregious is that we spent weeks and weeks and weeks of ensuring that the most vulnerable people of our state weren't affected. And here you are, and you brought folks out, even though you knew the sub-minimum wage wasn't in. And this bill is going to protect the workers of our state. Everyone in this committee knows that I'm not opposed to being in an uncomfortable position. I feel like I live there at this point in time in life now. But what is disappointing is the Restaurant Association coming time and time and time again to this committee so that we cannot improve businesses, but instead improve the bottom line for your restaurant operators. Mr. Chairman, I yield back.
Mr. Chairman, can I?
No more. I know everybody bought wrestling uniforms off of Senator Bidle, but no more, please. Delegate Charkoudian.
I just, I was wondering if you had agreed to the study concept, if you will agree to the study concept.
We have not reviewed internally
Let me just
the
ask you a
language
different
of the amendments. We will certainly take a look at
Let me
those
ask you a
amendments.
different way. Are you open to the concept?
Oh, we're always open to studies on issues because that's an opportunity to learn more about the issue. I don't know the scope of the study, the time frame, the stakeholders who will be involved in the study. I don't know what kind of data the study will be collecting. I don't know the time frame for submitting reports. I think the delegate said November 1st, and I think I saw that in the amendments as well. But I think there are a lot of factors that we would have to consider before determining whether we would support the study.
Are you saying you don't know what the study is, or you're saying that you don't know if you support the study as it's written here?
What I said, Delegate, and pardon me if I was not clear, I don't know the stakeholders who will be participating in the study. I don't know the type of data. If I recall correctly, the study would require the Maryland Department of Labor in conjunction with the Maryland Department of Commerce to study tip credit wages and compare those wages to other states where tipped employees may not be subject to a tip credit and report on the differences in wages. I don't know whether we will be invited to participate or provide data. I don't know what the data sources would be. And the reason I say that is because earlier today, we heard some.
That's okay.
Okay,
You don't need
I just wanted to explain some confusion regarding BLS data and where there are shortcomings in that data based on the employee-employer reporting of wages. And so I want to make sure that we're using information and data for those studies that is as accurate as possible. That's what we want to make sure of, not that we're opposed to the study.
Yeah, so I generally, we would be delegating the study to the Department of Labor. It looks like we're not telling them what kind of data to use. We're giving them the questions that we have, and we're trusting that they will figure out the data points. I mean, they have labor economists there who we trust to study and analyze all of these issues. So it's not a work group, right, where we decide who's going to sit at the table and we all express our opinions. It's an actual economic study. And I think it's important, and I hope you can get on board with it, because I appreciate that we have different experiences. I've been a server, my children more recently, that was 30 years ago. More recently, my children have been servers. We have different experiences, and depending on where we are, we can do very well in a tipped context, and there's people who are very exploited and do very poorly. And we have concerns about especially the folks for whom the system is not working. And so it's not to say there's not a lot of people for whom the system is working, but we have the responsibility to figure out what we do about the people for whom the system's not working, the people who are exploited, the people who can't pay their bills, the people who are harassed. And I think at the very least, doing some kind of analysis. So to your point, we've had this bill in front of us for a number of years, and it's hard to move off of something that we're familiar with because there's the risk that it might not work, but that doesn't mean that what we have is the right system. And so I do hope that you can get behind a study. I do hope that we can get better data, so it's not just folks' experiences and what they think, but we're working off of data, and maybe there's a solution we haven't thought of yet that really effectively protects people who are vulnerable.
And that's what I meant, Delegate. We are not opposed to the study. We just need more details. Thank you.
Study. Delegate Vogel.
Thank you, Mr. Vice Chair. I'll be very quick. I appreciate the concern around wages and compensation from this panel. It's refreshing. I would say I know that you said earlier that You can't comment on the bill in full because you just got the reprint today, but there's two pieces that would raise workers' wages and put more money in their pocket every month, right? Which is eliminating the deduction on the credit card fee and adding that subtraction modification. Is that something that you would support, recognizing that that is something that would raise wages for workers?
We certainly do, Delegate, and thank you for the question. We do support no tax on tips, provided that it's not tied to any other language that would eliminate the tip credit. Our tipped employees are the backbone of our industry. They define customer service and hospitality, and we support anything that will help them, and we think no taxes on tips is a great idea, provided that that's all the bill does. And it
And
doesn't.
the credit card fee as well, sir?
The credit card fees, there was another bill, House Bill 29, that would prohibit the processors and networks from charging the processing fee on the credit card tips. I think the clarification that was raised here earlier was that this would prohibit the employers from doing that. I am not aware that this is a huge problem with employers doing that, and so that's something that we want to go back to our membership and get some additional background information on how many restaurants are actually deducting this service charge from credit card tips. I don't have that information before me today, sir.
Okay, for the last question of this evening, Delegate Chi.
Mr. Chair, I know it's late, but I have to ask this question because I have this big curiosity on my mind. Rebecca, right? Are you with the Economic Policy Institute?
No, I'm with a different organization called the Employment Policies Institute.
Okay, never mind. Thank you.
I apologize. We still have a myriad of witnesses. That's not the last question for the evening, but that is for this panel. Have a good evening.
Thank you.
Next, we will go to Tanya White, Taryn Rivers, Elena James, Greg Brown. How many seats? There's 5. And Stan Fletcher. You can start when ready.
Let's go down there. Do the order there. Do the order there, right?
Yeah, hey, just a reminder, I know it's been a long day, everybody's sleepy. When you talk, you got to bring the mic into you, because they're not the best at picking things up.
Taryn left.
Okay.
So we can see if he's.
Hello?
Excuse me, did y'all call Robin Brooks?
No, we did not. You were 2 away.
Thank you. No. Okay.
Okay, and then Taryn, I believe she left.
Okay, listen,
Okay, we're just letting
we got
someone
Tanya White, Taryn Rivers, Elena James, Greg Brown, Stan Fletcher. Whenever one of those 5 are up there, they can begin.
How you doing, Chairman? I'm going to start the Ask Me to Elect. First of all, I want to apologize to any of the people who spoke earlier in the pink shirts, whatever they found in this business as a harassment, anything else, okay? I hate playing the race card as a crutch, okay? I'm a black man. I've been in this business over 37 years. I've raised my family on it. I started in PG County. I worked in DC. I now work in Montgomery County, okay? I do have 2 daughters. I already went through this business, okay? The oldest daughter of mine just graduated cum laude from Northwestern. She also got a degree from Old Dominion, 2 degrees, okay? But I base, and my other daughter is a property manager in Baltimore. My 3 sons work with me at the restaurant I work in Montgomery County, Clyde's. Okay, so the business has a foundation that is built on service. That's what we give, okay? The tips on the credit cards, okay? It's part of processing a business, okay? Since it's been on, I've increased my income in the last 2 years, $12,000, $13,000, okay? To pay taxes where I live, I enjoy where I live from what the taxes I pay. I expect to pay taxes. To think that this industry needs a babysitter. This is my 3rd time talking with y'all over the last 10 years. I make a significant income, not an income, a significant income. Okay, I've raised my family on it. I have 7 kids. My 2 kids now, they're still at home, horseback riding, competitive dancer, dreams that I wanted to bring to life only because of what I do for a living. Okay? What we have is somebody who we need to maybe concentrate on other things and other people, like school teachers and firemen, that I live in Montgomery County now, that I make more money than. Okay, this is
Sir,
the
I'm gonna
race
need you to
card.
wrap
I'm
it up.
gonna wrap it up real quick. The race card they want to play about color and skin, I make more money than anybody in my workplace, and I'm a black man. Okay, so don't play the race card. The service is built on service.
I understand, sir. Thank you so much for coming up here. I know it's been a long day. I know you all have been waited around, but we want to try to keep to the 2-minute witness. But I do appreciate you coming up here and sharing. Whoever's next, please begin.
My name is Greg Brown, President, Monocacy Hospitality. I represent all of Frederick, Maryland service tipped employees, including 150 of my own. We do certainly appreciate the amendments that were made today and communicated to us around 11:30 a.m. This morning, which would obviously remove elements of this bill that would kill jobs, kill livelihoods, kill businesses, increase inflation, kill revenue for the state, and as I heard earlier in the room, ultimately make Maryland less competitive. We do appreciate that. That being said, I do have to say with all due respect that it is frustrating that this is my 3rd year coming down here to fight what would phase out the tip credit, and we have minimum wage back on the list. And I know the hearing was in the Senate for the past 2 years, but I also understand it was here in 2019. Our servers and bartenders don't want the tip credit to go away because they make a lot of money and they enjoy it and it gives them flexibility. The business owners, myself, they don't want it to happen because we're going to make our guests really upset. We're going to eliminate jobs, and we're going to see tons of employees in tears just going out the building and not knowing what they're going to do. It's just disappointing that we seem to have an out-of-state activist group that keeps pushing for this every year, and we have to come down here and spend time away from our businesses and our jobs to ask lawmakers to please just don't do anything. Luckily, we've been able to defeat this proposal every year, but I just hope we stop seeing this bill introduced year after year because it doesn't seem to make any sense. Please withdraw this entire bill. I realize most of the committee do not appreciate 11th hour changes and amendments that directly impact the lives of all employees and owners. This volatile, uncertain rhetoric and respective actions create uncertainty that, quite frankly, derails a business owner's appetite to grow and also really negatively impacts the employees. This is not right and shows total disrespect to all those in hospitality.
Thank you. Okay, I understand that there may be emotions around the bill, one way or the other. But I think going after legislators' intent, especially those that represent the state of Maryland, is not okay in this committee. So just to be clear, you may think it is an out-of-state group pushing it, but I assure you this delegate represents Maryland, and he brought it, and he has every right to bring it. And these legislators, both sides of the aisle, can bring whatever bill they want each and every year. Doesn't mean that bill's going to pass. Doesn't mean that we all want to be here at 7 o'clock on a Tuesday night. But nonetheless, they still have ideas. They still earn the right to bring a bill in front of the committee. And I'm not going to deal with any more comments like that. Next. Cliff Killing, I'm sorry. Ma'am, your name?
Elena James.
Okay, go ahead, ma'am.
Well, thank you so much for allowing us to still speak at this late hour. Thank you to the delegate for your amendments. We do appreciate that. There are just a few things that I want to address that came up regarding the amendments. Also, to the young women that gave their testimony earlier, I'm sorry for what you've had to deal with. However, they do not speak for me or my other colleagues. It's unfortunate that sexual harassment does happen in this industry. It happens in every industry, okay? But it's not something that every woman of color in this industry has been subjected to and is forced to be subjected to in order to make a living. So I just want to address that. If you are being harassed, yes, that is wrong, and you do not have to stay in that workplace to earn a living. Okay, so let me just say that. Next, as far as the credit card fees, okay? I process credit card transactions, okay? And I see how it works with the credit card company can only deduct that percentage from the bottom line. They cannot specifically take it out of the credit card tip, and the employer cannot say, we're going to take it from there. If these employees are not seeing 3 to 4% of their tips, it's because it is going to support staff that we tip out to, such as bussers and food runners. That is, and it's not 3% of their tips, it's 3% of the sales. That has nothing to do with the credit cards. Credit card companies cannot touch the tips. And lastly, when it comes to the tip credit, if a company is not paying that difference, please just attack that company and deal with them accordingly, instead of trying to pass a bill that affects those of us who are making an incredible living. Thank you.
Thank you.
Okay, your name, ma'am? You're Robin Brooks?
No, I'm
I'm
can
sorry.
y'all hear me?
Yep.
Okay, no, my name is Tanya. Thank you for your amendment. I appreciate that. Hello, committee and chairs. Chair and committee, I'm sorry. My name is Tanya, and I work at Silver Diner in Greenbelt. I'm a server. I've been doing this for 45 years. And first and foremost, I want to say, I don't want to downplay none of your stories, whatever you've been through, but I'm kind of confused. Okay, you said you been sexually harassed, you want to take the paper tips off the table, but you want to put the hourly salary on. You're still going to be in a restaurant. Are these same people still going to be coming in there? I'm just, I don't understand it. Because when a person has intentions like that wants to sexually harass you, they don't care if they're going in their pocket to put the money on the table or if you're getting it hourly. And I want to say to you, like I said, I've been doing this for 45 years. I make my choice to walk to the table or away from the table. We're all grown. We got that sixth sense where we can see something's not right. If it don't look right, don't feel right, something might not be right, okay? Now, it happens. You can be sexually harassed at the bus stop. You know what I mean? I don't want y'all to go away thinking every server that works in a restaurant is sexually harassed. That's not what it is. I'm not saying it doesn't happen from time to time. 45 years. I've got compliments. Maybe it's the way I carry myself. Maybe it's the way I approach people. You understand what I'm saying? Maybe it's the way I do my job.
Yep.
22 minutes. But I just want to say, I'm sorry. I just want to see if y'all was listening. I'm sorry. But I'm just saying, this it is what it is. But every time y'all invite us here, you see we're going to show up. Okay, every time y'all invite us to this rodeo, we're going to saddle up.
Yep.
Okay, but we're kind of getting tired of it. Our horse is old. Thank you.
Delegate Pepe.
Thank you, Mr. Chairman. I'd just be remiss if I didn't say it. So, look, sometimes I'm tough on witnesses, but we do appreciate, particularly Mr. Brown from Frederick, you sharing some of your concerns. And at the end of the day, we work for the citizens out here, and we want to hear from you. And it's certainly frustrating sometimes when you're in an industry and we're talking about a bill that impacts your industry. So, nonetheless, we appreciate your testimony. So, take that for what it's worth. Thank you.
Thank you all for coming out here today and staying this late. I appreciate it. Just want to quickly, I'm trying to assess, so as amended, you all still are in opposition to the bill as amended, because it sounds like some of the comments that you had were towards the bill that was offered originally. So as amended, the bill would still not meet your, I'm still confused on what the primary issue you have with the bill as amended.
We want to be left alone.
Pretty much.
Period.
It's amended today. What's going to happen tomorrow?
Yes.
So you still oppose it as amended, even, okay.
Just
all right.
leave us alone.
Because some of the things you all mentioned, like, the bill's no longer doing. So I'm confused on what to say. Like, so at the end of the day, let's say this bill does move. Do you have suggestions on how to make it better? Are you okay with the amendment? So you just oppose it outright?
Yes, I oppose. I have 3 sons, and I have 2 daughters waiting to come work in this business. They know what the living that they get to live off of by what I do. They get to see what I've already done for their older siblings. They already know that this business needs to be left alone. We're fine. Everything is fine.
I understand.
If I may,
No, I'm good. We can
Okay.
come on, sir.
Yeah.
I know it's late. I'm sorry.
Okay, yes, thank you. Thank you, Delegate. Okay, Delegate Turner. Go ahead, Sunshine.
Thank you, Mr. Chair. I'm just really want to tell a little story so y'all can hear this. A couple years ago, I put in for the tip bill, but I'm labor, and labor came to me and asked me to put in the tip bill. Okay, so I went and did my homework. And I went to a lot of restaurants, I went to a lot of stores, I asked a lot of people how they felt about it. I'm really shocked to see all of y'all here. Y'all took off y'all jobs, I hope, to be here. And I know you're not being paid for not being here. Okay, so I'm just appalled that y'all are here. But I want y'all to know how hard I work. I worked for 1 solid year to make sure that the tip workers, they was left out of the fight for 15. So I went back there and said, okay, y'all was left out of getting that raise. So let me go back and let me fight for the tip workers that I think they deserve to get money, and they were left out, okay? So I went and wanted to put the bill in. The bill did not pass, but I want y'all to know the Delegate Turner here worked very hard to get y'all money for the tip bill. The thing is that they told me, I want y'all to know what the people told me when I did my survey, that they leave us tips, but we don't see it. They take it, and we don't see the money. They split it among all of us. I said they split it among all of us. We don't get all the tip money. That's why I prefer if people give me cash instead of credit cards and all that. They said they didn't see it. I said, oh my God, y'all didn't see it. Let me fight for y'all to get y'all money. But I'm appalled. I am just shocked to see all these green shirts here that is against this bill that I know for 2 years I fought hard to get y'all money. Y'all want me to leave it alone, but I just want y'all to know I fought for you to get y'all money that y'all deserve, because tip workers are important.
Delegate.
I want y'all to know.
Thank you.
They definitely appreciate you. Okay, so seeing no further questions for this panel, we have Cliff Killings, Robin Brooks.
Mr. Killings already spoke.
That's me.
No, it's not a question, buddy.
No, you're done.
No, he
Right,
spoke.
that was me. I'm Cliff
Jane- no.
Killings.
Oh, he's already.
Yeah, he's already spoken.
Spoke.
Yeah, everybody, who?
Mr. Killings
I
has
am
already
Cliff
spoken.
Killings.
Okay, Robin Brooks, James Stark. So now you guys gotta clear the table. Deepak Patel. And if your testimony has largely been given, we encourage a me too.
All right, I'll start. Good evening, committee members and Mr. Chair. Thank you. My name is Deepak Patel, and I own and operate a hotel in Baltimore County. So we are not the restaurants, but just as long as the minimum wage part was in a bill, we want to show up. I'm with the Asian American Hotel Owners Association. This association has members, about 62% of hotels are in Maryland are member, and I have my fellow hoteliers also join and use whole day today for this hearing. We are strictly opposing the minimum wage portion of the bill, and we are happy that's amended, and we are open to any study if we are invited. the small business is how the margin is really razor thin these days. It's very thin, and it's hard to make any money for owners. So please keep in mind the hotels are and motels in Maryland offer entry-level and minimum wage jobs for students and new workforce. And if the wages goes up, then this will eliminate most of the entry-level positions. They forced to reduce hours and also forced to reduce, close their doors. So please keep that in mind. We just want to happy that the person is amended, and we're open to any study on that. Thank you.
Good afternoon. My name is Robin Brooks, and I am 67 years old. Have never done anything in my life but serve tables. I have a 12th grade high school diploma. I've never been to college. For the bill to be recognized for us to get $15 an hour would set me back. I couldn't take care of myself anymore because right now I average $39 to $40 an hour on Saturdays and Sundays, and I work for IHOP in Greenbelt. On Saturdays and last Saturday, I walked out. I opened the store at 5 o'clock in the morning. I walked out at 12:30. My tips was $319. At my age, I can't go anywhere and get that. So if you all are listening to an older woman who wants to continue to take care of herself, please don't pass this bill that we get $15 an hour. Thank you.
Good evening, Mr. Chair, members of the committee. My name is Jim Stark. I'm the VP of Hotel Operations for the Best Western BWI, Arundel Mills in Howard County, and I'm also the legislative co-chair for the Maryland Hotel Lodging Association. I'll be very brief. Again, we were presented with the amendments this afternoon, and the amendments address quite a bit of the bill that we have concerns with, especially as it relates to the minimum wage component. And I just want to reiterate what Mr. Patel said earlier, that hotels, please consider not only for this bill, but just in future bills, hotels, the burden that is on our owners and operators, we have a very small margin. And when we're looking at increased cost, not only labor, has labor gone up exponentially in the last few years, but insurance costs, supply chain costs, costs related for us making changes to implement the legislation that previously passed for BEPS and becoming in compliance with that. There's an energy cost component that's going to go up in July as it relates to the delivery of energy, not just for us on the commercial side of things, but actually everybody that's a resident in the state of Maryland. Just please keep in mind all the other costs that we have to calculate into to operating our businesses and operating in the state. And I'll conclude just saying one thing, and I appreciate your patience. I appreciate everyone that's in the audience. And I say this for myself, my hotel, you know, I'm an average size hotel in the state of Maryland, but all the other folks that I know that run small businesses, restaurants and hotels, we look at our employees as extensions of our family. I know when I bring my 5- and 6-year-old into the building, into the hotel, they interact with other staff that I have that have little kids too. So we just don't look at our members of our teams as employees. We look at them as an extension of our family, and we do take that into our calculus as we make decisions, and we try to balance it out. So thank you very much for your time. Certainly entertain any questions.
Thank you. Seeing no questions, we have one witness left. It's information. Christopher Meyer.
Mr. Chairman, I have a client who signed up, Nick Mangione. Hopefully it's gonna be quick. He also signed up and submitted this test on behalf of the Hotel Association. Yes. He signed up. Yeah, I did. Certified.
Nobody has one on the list, sir.
Nope.
Did you have a me too or something you wanted to say quick? I mean, when I say me too, I meant
I just want to say good evening, everybody. I submitted my testimony to the chair, and I'm good.
Okay, we'll get Christopher
on
Meyer.
record. Thank you.
Thank you. My name is Christopher Meyer from the Maryland Center on Economic Policy. Our testimony is informational. Let's be clear, tipped jobs are generally not lucrative. For example, restaurant servers in Maryland typically took home a little over $16 an hour in 2023, including regular wages and tips. Tipped workers in Maryland are more likely than other workers to live on sub-poverty level incomes. And nationwide, tipped workers are more likely than other workers to report struggling to put food on the table. That's an important point. That's not wage data from the Bureau of Labor Statistics. That's people.
Sir, are you informational or unfavorable?
Informational.
Outstanding.
That's people reporting the circumstances of their lives. So anecdotal claims that tipped workers are actually making a lot of money don't hold up to scrutiny. If wage data were systematically underreporting tipped workers' pay, you would expect to see a disconnect between reported wages and other data sources on their standard of living. As we see from data on food security, no such disconnect exists. Furthermore, credible research backs up common sense. Raising wages is good for workers. Well-designed studies find that raising the tipped minimum wage increases net take-home pay with no meaningful impact on tips. Meanwhile, there's a large body of evidence showing no meaningful link between the minimum wage and the number of jobs available. So the reason my testimony
Sir, we appreciate it. Next time you have to sign up unfavorable. This is a straight unfavorable testimony, and you're signed up as information.
This has been mostly favorable about raising wages for tipped workers.
Well, then it's been very confusing.
So we're opposed to exempting.
Please wrap it up.
We're opposed to exempting tips from the state income tax. That's the wrong solution. It would create an exploitable loophole. More effective measures would be the EITC or CTC.
Okay, thank you so much. That concludes the bill hearings for today.